Okay, everyone, we're gonna get started. I'm gonna have our dean give a quick welcome. Thank you.
Thank you, Rich. Aloha.
Aloha.
Welcome. It is such a treat and joy to see you here. Indeed, it is an honor to host the 2025 Law and Development Conference in partnership with the Law and Development Institute. We are deeply grateful that you have chosen to be here with us. We know many of you have traveled a great distance. This year's conference brings together an impressive roster of more than 40 speakers from across the globe, including Asia and the Pacific, Africa, Europe, Latin America, and the continental United States. Your presence reflects the truly international character of this gathering and your shared commitment to advancing this vital field. Warmest thanks go to Professor Steve Lee. He is the driving force behind the law. Through his vision and dedication, a dozen law and development conferences have been organized around the world since 2010, creating an essential forum for rigorous dialogue and cutting-edge research. Indeed, Professor Lee is already planning the next conference, which I'll let him tell you where it is. It's wonderful as well. Stephen, we are profoundly grateful for your leadership in sustaining and growing these very important conversations. Thank you. I also want to thank Professor Richard Chen, who is on our faculty here. Really, a couple of years ago came and said, can we host this? And was really the leader internally in supporting these efforts. And I also want to thank our IT team and our events team. And I hope you'll enjoy the next couple of days. The topic of law and development has never been more urgent. I think you know that as experts better than I. Around the world, communities are confronting threats to the rule of law, deepening inequality, and the accelerating impacts of climate change, to name but a few of the pressing issues that you will engage with today and tomorrow. Against this backdrop, your work and your ideas, critiques, and innovation helps chart a path forward towards a more just global order and harmonious community. It is especially meaningful that this year's conference highlights sustainable development. This focus resonates deeply here in Hawaii, where questions of sustainability, resilience, and equity are daily lived realities. Our state and our university have long engaged with these issues, and we are proud to contribute to the global dialogue in this very special and unique place. Over the next 2 days, you will enjoy rich intellectual exchange, spirited dialogue, no doubt, and discover a new collaboration opportunity, I hope, with friends and colleagues, and grow new friendships. At the same time, we do hope that you will take advantage of this incredible place and find some moments to relax, experience the warmth of our community, and enjoy the beauty of Oahu. We also invite you to consider ongoing engagement with our law school. We are really proud of our strengths in international and comparative law, including our leading scholars in Japanese and Korean law, our expertise in human rights, and our absolute commitment and expertise in international environmental law. Our programs welcome students from all around the world with opportunities to pursue an LLM or a JD with advanced standing, and we are fortunate to host several visiting scholars each year. In every sense, we strive to be a global law school, and we hope you experience that spirit during your time with us here. Mahalo nui loa for being with us. Thank you again for your participation, and very best wishes for an inspiring, productive, and thoroughly engaging and enjoyable conference.
Thank you, Dan. It's truly an honor, pleasure to be here, and I thank you and Mr. Chan for such wonderful hospitality. So I'm very glad to see all of you for the 2025 Law and Development Conference. I serve as a director for Law and Development Institute, and I always took it as such an honor to do this work for the past 15 years. This marks, and I see some of you have been to our conference more than a few times, and this is actually our 13th Law and Development Conference, probably the longest continuing academic engagement in the field so far. The Law and Development Institute, I'm sure some of you already know what we do. If I may introduce, it began as a nonprofit organization dedicated to advancing the study of how law and institutions influence economic and social progress. We all have some idea that laws and institutions are relevant. The question is exactly how, right? So we needed to go into specific fields, such as property rights, industry promotion, environmental protection, and others, and see how exactly laws and legal frameworks and institutions contribute to progressing in those areas. So we've been working on that for quite some time. Our mission has always been to bring clarity, empirical insight, and multidisciplinary analysis to the complex relations between law, institutions, and economic transformation, also obviously social progress. Over the years, the Institute has produced a substantial body of scholarship, including several books, journal articles, and global collaborative research projects. And we also manage one of the very few peer-reviewed journals called Law and Development Review. I know that most of you are planning to publish in LDR. I've been doing that for quite some time. Through these efforts, we aim to build an intellectual foundation for law and development as a recognized and rigorous academic discipline. A major part of our work has been convening conferences around the world, such as this one, gathering scholars, policymakers, and practitioners from every region to present research, exchange ideas, and collectively assess evolving challenges of development. So at this conference, I'm seeing 40 speakers from over 20 countries. We've been always doing this. So our past conferences have taken us to every part of the world, including North America, Europe, Africa, and Latin America, and now here today, Hawaii. Each conference has contributed a unique perspective shaped by its regional context. This year, we're delighted to have a conference here in Honolulu, obviously co-hosted by the University of Hawaii School of Law. Hawaii has long served as a bridge between East and West, North and South, a place where diverse perspectives converge. And it is why it's such a fitting location for a conference dedicated to global issues of development, governance, and legal transformation. In this conference, you will hear from 40 speakers from 20 countries, covering a wide range of topics. We'll talk about sustainable development, environmental protection, information and technology, international trade and investment, all in the context of development. I would like to express my deepest appreciation to all our presenters, chairs, and discussants and attendees. Your presence reflects a continued commitment to improving the human condition through scholarly engagement and dialogue. I'm grateful to our host, the University of Hawaii School of Law, and especially to our co-host, Professor Richard Chan, and whose efforts made this conference really possible. Thank you once again for being here. Thank you.
Aloha and welcome to the University of Hawaii and the William S. Richardson School of Law. I just wanted to add my thanks and appreciation to everyone for making the trip to join us and start by commending Professor Steve Lee on organizing another amazing law and development conference. I am grateful to Steve for all the work he did to make this happen. And I did want to highlight that everything that was possible to do from a distance, he tried to take off my plate when I had a very busy semester, and I said, I'll do everything I can. But if he could, figure it out from West Virginia or Atlanta where he's living, he tried to make it easier for me. So I do really appreciate that. And this is really his passion. And I think he's doing a great service to the community of scholars and practitioners in this field. So I just have a couple of quick points I thought I would mention while I have your attention. First, the funding for this conference came from, large part from the Frank Boas Memorial Fund. And Frank Boas was a philanthropist who attended Harvard Law School and then became an international lawyer in Brussels. He later moved to Honolulu, and at that point, he became a very generous supporter of the law school and established this fund specifically to support international programs. So in addition to conferences like this one, the Boas Fund is used to support scholarships for international students. And so particularly for our LLM students. So on that note, just I'll take a moment to give a little plug for our international programs. That's one of my roles here to direct that program for our LLM and HAT students. So I think everyone knows what an LLM is, but I just want to highlight our strengths in those fields, as Steve Nelson mentioned, in international comparative law and environmental law, indigenous law. So we have students come seeking advanced training in those fields in particular. And then, of course, we have strengths in Asia and Pacific. But the HAD is something that I think most schools don't have. And so if you haven't heard that term before, what it really means is it's just a regular JD, but with advanced standing. And so students who get, for example, an LLB, a Bachelor's of Law in foreign law school, can come and get a JD, transfer some credits in, and complete it in SVU as 2 years, right, rather than the standard 3. So it's an opportunity again that it works as the same JD that you earn anywhere else, and including our own JD, it's the same degree. It's just there's an opportunity to do a little bit less time. And so those are our in-person programs. We are working on online options for both of those. And so, many of you are professors, and so if you have students who might be interested, please share information. I actually do have brochures I'm going to bring down. I'll probably leave them up front. You can pick it up, take it home with you. And if you ever have students who are interested, or if you yourself are interested in studying in the United States, then please do feel free to reach out to me. Other than that, let's see. I do want to apologize. I am going to be in and out a little bit. I still have a class that I'm teaching this morning. It's a faculty meeting, so I'm going to try to get out of. I might stop it too. So I will be around if you need anything. I also want to thank, we have a few student volunteers in addition to our events and law IT, or IT assistants. And so they will be looking out for people who seem lost. And if you need anything, hopefully one of us can help you. So with that, I'll just say I'm looking forward to some wonderful presentations and discussions. I read all of the abstracts, many of the papers, and I think we have a lot of great ideas and projects to discuss. So with that, I'm going to just very brief introductions. I think we'll do that for the whole conference because you do have the program with detailed bios. And so all I will say is that we are very honored and pleased that Jonathan Zasloff agreed to deliver a keynote to really get this conference started. So Professor Zasloff teaches at UCLA Law School. He is an expert in property, land use, environmental law, and his keynote is titled Water, Federalism, and Sustainability, the South African Case and Beyond. So let's welcome Professor Zasloff.
Should I go?
Do you need to be plugged in? Yes.
Yeah. Actually, I don't think it's gonna run out of juice. Do I need to be there or here or what's the rule?
I think some prayers if you could there.
Okay,
If you don't think you're gonna run out,
I don't think I'm gonna run out of juice. If Steve wants us to be here, then I'm gonna be here. Wait, so
You can just put that in the back pocket right there.
All right. And then I put this here, this here.
Take this one out. You're not good.
Yeah, probably. Yeah. Okay. I'll put it. I'm not using a PowerPoint.
It's yours.
What?
That's yours.
That's mine. Yeah. Wait, so I can just leave this here?
Yeah.
Okay.
We can need to PowerPoint later.
Good. I confess to being a little intimidated by doing a keynote. Perhaps this is because I'm a little too modest about it, but I'm reminded of a line from Winston Churchill when somebody once remarked that his Labour Party counterpart Clement Attlee was a very modest man. And he said, yes, he is, and he has much to be modest about. So I will attempt here to get things started in a way that can be of assistance. The 21st, so the first thing I should say actually is, given how rapidly changing development is, the title of my talk has changed. Originally, I thought it was about federalism. Now I've actually gone farther down. It's now about local government, empowering local government for sustainability, day zero and beyond. And I think I'll try to make it clear as to why that is and how things change in this way. The 21st century is the urban century. The world's population reached 8 billion in November 2022, with over half living in urban areas. And that figure is projected by the World Bank to go up to 70% by 2050, and 85% in cities and metro areas by 2100. And urban areas are the drivers of growth. Again, according to the World Bank, cities account for about 80% of global GDP and about 88% of private sector job creation. So if we're going to have economic, social, and human development throughout the world, and especially throughout the global south, we're going to have to do so in cities and metropolitan areas. But here's the problem of particular relevance to us. Cities are also legally and politically weak. They generally lack fiscal capacity and often the authority to regulate many of the most quintessential municipal affairs. And this legal fragility creates a problem for development because cities also face massive development challenges. Because while people can talk about the triumph of the city and cities are going to lead us and what if mayors ruled the world, that was a famous book by Benjamin Barber, and all of this stuff, they can also be sites of inequality and environmental destruction. And they lack both the power and the accountability mechanisms to facilitate democracy. So what I want to do just very briefly today is to consider the extent to which cities can challenge their legal and political disempowerment through resort to the courts. Local governments are disempowered, but in many cases they possess some sort of constitutional status, comprising both rights and more often responsibilities. What they lack is leverage. State and provincial governments have less incentive to cooperate with local governments in satisfying these obligations. But, and this is to some extent my thesis today, courts can help change those incentives. Litigation, if well crafted, litigation between local and national governments can play a substantial role in empowering cities to play the necessary role in sustainable development. And I'm going to take a look at a couple of cases, South Africa and India. I would be greatly appreciative of people who know more details about other legal systems throughout the world, come up to me and say, hey, you might want to consider this, you might want to consider that, take a look at this place, take a look at that place. This is becoming more and more common around the world. And I'm going to be focused on water, one, because I write about it, two, because I think it's important. Everybody thinks their area of scholarship is the crucial one. Well, you're a water person, but have you ever considered the critical nature of international investment treaties? Well, yes, of course, that's important. No. I write about property. Okay, well, all right, fine, property. Nonsense. What about the Uniform Commercial Code? Everybody get it. Of course, that's our, that's our incentive. You don't recognize that I, in fact, am doing the most important thing. The one thing I can't say about water is I know a little bit about it. So I can actually talk about there. So let's start in Cape Town. And I should say, why I'm here, because I think this puts an interesting context on all of this stuff. I've been interested in Cape Town in South Africa and written about it for years. I was going to be there this last semester on a Fulbright scholarship. But you should know, for what it's worth, what has happened to the Fulbright program if you don't know already. Because my family were victims of the Palisades fire, I was going to had to try to defer it. The man who's now running the Fulbright program in the United States is the Undersecretary of State of Public Diplomacy, a man named Darren Beattie, who was fired from Trump 1 for speaking at white nationalist conferences. So, of course, they brought him back in Trump 2. And he's now the Undersecretary of State for Public Diplomacy, and tweeted out last year, the only way to get anything done in this country is to have it done by a competent white man. These are the people that are running American foreign policy. So if you don't know, you have been forewarned. That is what is happening. So I had to do South Africa from afar, but I can still do that a little bit here. Let's think about South Africa for a second. Cape Town has long been known as one of the most beautiful cities in the world. It is also now known as one of the thirstiest. Some of you may remember that in the summer of 2018, 2019, the city and its environs faced day zero, where citizens would literally no longer have access to water. They were going to run out of water, and it was only essentially the fact that they were able to have a wet winter finally, after several years of drought and rather extraordinary conservation on the part of the people there, that they were able to avoid it. But here was what I began hearing so much from people in Cape Town and people on the ground, is that a major reason for day zero was the inability for them to be able to collaborate and coordinate with the national government. Let me give you a couple of examples that might be of interest in terms of this. Pursuant to the South African Constitution and the National Water Act, the national government owns all the water in the country. That's not necessarily bad. But, for example, suppose you want to drill a borehole in Cape Town. You want to tap the aquifer. The city sits on 3 different aquifers. That permitting would go through the national government. But it's the city that has the legal obligation to provide water services. So the 2 levels of government don't talk to each other and they're not communicating. Or let me give you another example. We've been talking a lot about more environmentally sensitive desalination. Suppose the city of Cape Town invests a whole lot of money in desalination and they get all of this water. They don't own any of that water. The national government would own the water. And the inability of the national government and the local government to communicate with each other is a huge problem. People there telling me, there are some aquifers or some areas of groundwater that literally have 3 or 4 different organizing and regulatory authorities on them to be able to try to handle this, and they don't speak to each other. So one organization has one part of the aquifer and another organization has another part of the aquifer. Well, you don't need to know a lot about groundwater to recognize that you can't regulate half of an aquifer. And that's an enormous problem. And this is one of the things that created massive problems in the creation of Day Zero, that the 2 bodies could not communicate with each other and refused to communicate with each other. And it's worse because the South African Constitution gives a lot of the power to the national government, but it gives responsibilities to local governments. Local governments have the responsibility to provide water services. They have the responsibility to engage, all of them are engaged in doing social, they must structure, each local government must structure and manage its administration, budgeting, and planning processes to give priority to the basic needs of the community and to promote the social and economic development of the community. Classic law and development issue. So local governments have a lot of the responsibility, but they are lacking political empowerment. This is a huge issue, and just to see how difficult it is to communicate with each other. Recently, the National Department of Water and Sanitation in South Africa loudly announced over social media their new memorandum of cooperation with local governments throughout the country. I was very upset when I read this in June because I said, God damn it, they've just preempted my entire paper. I should not be worried, because in an attempt to get a copy of this memorandum of cooperation, myself and the librarians at UCLA kept writing to the Department of Water and Sanitation saying, can we please get a copy of this thing? And they said, no, it has not been released to the public. That was 6 months ago. So I'm seeing a nod here. This should not be a particular surprise that their memorandum of cooperation literally is not available to anyone. And it's not clear that it's even available to the local governments in control. So what I'd like to do is suggest that really this is one of these places where we can potentially use litigation as a way of essentially forcing the kind of cooperation and empowerment of local governments that national governments aren't using. If local governments have responsibilities to provide development, and if they are told by the Constitution, you must do these things, but the national government will not cooperate or communicate with them, that is a legal violation. And it is one that is susceptible, potentially, to a legal solution. And public interest litigation and this kinds of broad litigation doesn't have a very good reputation, at least in the United States Legal Academy now. But the fact that it doesn't have a good reputation in the United States Legal Academy now, I think is a good strike in its favor for all of this. So the problem would be one of remedy. What would you do? How would a judge, for a judge to sort of just be able to tell local and national governments, go cooperate? That in and of itself does not particularly answer the problem. But I think that there are a couple of older precedents from American litigation that actually show how this conceivably could work. I should be very, very clear. The fact that I'm using a precedent from American litigation is not in any way, shape, or form an attempt to claim for U.S. supremacy in any way, in any field. The model has fallen out of favor under a right-wing court, and Americans are the last people in the world to lecture others about how their legal system should work. Nevertheless, I think that it is useful to think about this. An interesting precedent that could be helpful in this case, Massachusetts Bay, outside Boston, Boston Harbor, was famous for being one of the most polluted harbors in the world. So much so that there were actually popular music songs written about how incredibly polluted Boston Harbor was. If you know the song Dirty Water by the Standells, for those of you who are popular music fans, that was about Boston. In 1988, George H.W. Bush, when he was running for president against the governor of Massachusetts, did press availabilities outside Boston Harbor to say, well, obviously he can't run anything because look how incredibly polluted Boston Harbor is. But one of the ways that was able to solve that was through intergovernmental litigation. The city of Quincy, after finding syringes, tampon applicators, human fecal matter washing up on the beach in Quincy, basically sued the state under the Massachusetts Clean Water Act and a public nuisance theory. And a judge, Paul Garrity, appointed a special master in order to do the kind of fact-finding that needed to be done, and that was able to provide a stick that forced the state government in Massachusetts to start cleaning up the harbor. This problem had been going on for 40 years as everyone kept blaming each other. But a judge who could be sensitive about these things can actually work it out relatively well. This is the sort of public law litigation model that was pioneered now 50 years ago in a very famous article by Abram Chase, one of the great men of international law, talking about how these things change. The scope of litigation in these kinds of public law circumstances that is developed by the parties and the judge. It's not just simply two private parties. It's polycentric. There will be many different parties coming into the courtroom to try to advocate for their particular interests. The inquiry is not historical or adjudicative, but prospective and predictive and legislative. Relief is forward-looking. And the remedy is not imposed, but it's negotiated. And this is one place where a judge can, who's doing things in the right way, can essentially say to the parties, which is common now in some of the public interest litigation in the United States, as set forth by my colleague David Marcus, who has a wonderful article coming out of the UCLA Law Review, got it to my own honor of my institution, in March, about the state of public law litigation in the United States. That for the most part, what will happen is that judges will say to the parties, okay, you guys give me a proposal for what your remedy is. In one sense, this act, and we'll for the most part tell the parties, I'd rather have you guys come to an agreement, but if you don't, I'll take one. You can have an arbitration model. Each of you give me a proposed remedy, which could conceivably give an incentive for each party to be more reasonable, because if they're not more reasonable and the other party is, the judge will pick the other party's remedy on this. And the subject matter, and the judge's role is not passive, but active on all of this. So I can talk a little bit more about this. We're probably not going to have much time for the Q&A, but that's okay, because I want to hear what everybody else has to say. The question is, at this point, what we have to do is be extremely sensitive about what the specific local, legal, and political contexts are. But I believe that this model can travel, depending upon what the specifics are, the legal landscape in a particular country. So let me give you another example of another nation that I care very deeply about, and that's India. I know we were going to have someone here from Jindal Law School. Oh, good, we did, wonderful. So you can tell me everything about how I get everything wrong, but nevertheless, this is how I'm gonna say it. Oh, so this is wonderful. So India, the Indian Constitution, India has always been a very centralized system legally. The Union government has taken a whole lot of power. This was, comes back from Nehru to seize the commanding heights of the economy, et cetera, et cetera. In the early 90s, the Lok Sabha passed 2 amendments to the Indian Constitution, the 73rd and 74th Amendments. So that's an awful lot of amendments, longest constitution in the world for all of this. 74th Amendment for an American, oh my Lord, on all of this, that supposedly would empower local governments, the rural governments being what are called panchayats, the urban governments known as urban local bodies, and they have all kinds of instructions in there. You've got to create local governments, and here's how you elect them, and here's how many women have to be in the local governments, and here's how many Dalits have to be in the local governments, et cetera, et cetera. All very good, all set up in this way. We are going to have local governments in India, and we are going to empower them. Well, it didn't really work out that way, and the reason why is because the provision in both of these amendments said, so state governments may choose to empower local governments. So the may versus must has become the excuse, if I may say so, for state governments to be very wary of empowering local governments, to the point where even in a state like Kerala, if any of you are familiar with what happens in Kerala, which is a rather extraordinary, in many ways, an extraordinary case of the way to do development right, in terms of outcomes in India. If you compare a child, say, growing up in Kerala with development outcomes versus a child growing up, say, in Bihar, the Kerala outcomes are going to be by far the best. But nevertheless, Kerala has essentially said, oh, yes, we're going to empower local governments, and then basically takes over everything and doesn't pay any attention to. And if it happens in Kerala, it's happening all over the country, although it's better in some areas, such as Gujarat, et cetera, et cetera. So the question is, what do you do? What do you do in this case? I think that creative lawyering, but intellectually honest creative lawyering, can do this well. For example, in the paper, at least the more updated edition of the paper, what I do is I propose for India what we might call an administrative law model for local government empowerment, which is to say, okay, state, you don't have to empower local government, because it doesn't, the 73rd and 74th Amendments do not tell you that you must empower local government. However, if you don't, you have to give good reasons for not doing it. In other words, in the same way that in administrative law in all Anglo-American countries require of administrative agencies, you don't have to take a particular position on a particular issue, but you have to explain why, or you have to explain why not. And forcing that process, first of all, would change the calculus in the national government or the state government and saying, well, wait a minute, why aren't we allowing individual cities in Kerala to have the authority and capacity to have sanitation, even to the point of allowing them to put up their streetlights, which they are not able to do in cities like Trivandrum and others in Kerala. They essentially are being run roughshod over by the state governments. You have to be able to empower cities to do it. And if you're not, you have to explain why. And it has to be a good explanation. It has to be a reasonable explanation. That, I think, can fit in under the plain and precise terms of the Indian Constitution without necessarily overriding what the state government wants to do. But you have to explain why you're doing it. And that can change a whole lot of things. Because then the state government say, well, yeah, why don't we do that? What is the reason that we can give to a court that can present a remedy as to why we're not empowering local governments? And if they don't have a good reason other than, well, this is the way we've always done it, or, well, we're a state government that's run by one party, but the local government is run by another party, which is very, very common. It's common in the Indian context. It's certainly the case in the South African context. In Cape Town, Cape Town and the Western Cape is run by the Democratic Alliance. The national government was run by the ANC. Now they have this strange hybrid in South Africa called the GNU, the Government of National Unity, which is a great fan. The political cartoonists love this because whenever they want to talk about what the national government is doing, they have a picture of a new, which is the way that South African cartoonists do this. But then they have to explain why. And if they don't have a good explanation, then the court can say you have violated the 74th Amendment. Not because you can't do what you want to do, you just have to be reasonable about it. And that conceivably could change the political calculus. Okay, I have 4 minutes here, so I don't want to take too much time. There are lots of questions that arise out of this. I just want to mention a few. I always want to say, okay, I'm going to cut it back so we can do more of the Q&A. And then there isn't any time for the Q&A, which is was not something that I planned with malice aforethought on this. First is, I think I'm interested in finding out more about experiences of other nations and cities regarding levers of using local governments against national governments. Are there other examples here? I know there are a couple of people here from Brazil, which is more of a federal system. I'd be interested in hearing from them, even though my Portuguese is non-existent on this. Other examples of using legal structures to do this. This actually, I think, comes up a lot in the law and development field. We want to come up with general theories of law and development that we can apply from country to country, but the individual circumstances are so unique that you've got to be careful about planning something. Well, our law works differently, so this is a standard challenge. How can you generalize while at the same time be there for individuals, for any individual states? The second thing is, how does this impact the issue of inequality in urban development? One of the things that has been the case with a lot of the literature, certainly concerning India and many places in Africa, is about how paying attention to cities needlessly disadvantages the rural poor. And that is a huge issue. There's a wonderful scholar of Indian politics, Leela Fernandez, who's written about water governance in India. And it's great that Madras is getting a whole lot of stuff to be able to do something in India, but how's that affecting rural people? And perhaps this is one of the places where we can talk about empowering local cities, but doing it in such a way that the national government can reserve a certain amount of power to cure inequality, certainly between urban and rural areas. Because the last thing in the world you want to do is, make the cure worse than the disease. In the United States, generally, they have been disempowering local governments, which has been bad. But in my home state of California, they've had to disempower local governments precisely because local governments have been so inegalitarian on issues of housing and land use and affordable development. So we need to be careful like that. But just to finish up, when we have the urban century, it's gonna be our choice to either enable cities to handle it or not to make a choice and let the chips fall where they may. I don't think that anybody who does law and development would prefer that. So we need to start thinking about it now. And we need to start thinking about it in a more broad way, while at the same time being very, very careful and attentive to the legal and political dynamics. I'm done. 9:59. So come and yell at me during the break.
Please continue the conversations at lunch and breaks. So we can go ahead and get the first panel, which conveniently is on sustainable development, law, and environmental protection. So if you want to go ahead and take your seats, we'll start. I can grab it.
So panel one, everybody should. Oh, baby. Good. Very fine. Very well.
We can just take turns.
One of my certificates.
Oh, there's two mics that would put
Oh,
down.
yeah, wait.
Looks fine.
Fine.
Oh, hi, yes, nice to see you. It's the wheels, they're.
Want to use that? Okay.
Be very careful on that side. So-
Oh, you can. True.
Oh, very close.
This keeps track, okay.
I think I just need the mods. I'm gonna have to-
We'll just go on the order on this, that's what. I think the speaker is supposed to come up.
You want to?
Oh.
There.
Yeah, with the name.
Oh,
Which going to go on the evening?
I'll call the name. Okay, sure. All right, well, welcome to our first panel. I'm Andy Morris. I'm just the timekeeper here. So we're gonna have 15 minutes each for each speaker, and then we'll have a discussion after that. The first will be Professor Roman. Just kind of look at me, I'll kind of give,
Do I need this or?
I think, yes.
Yeah, I can use it. Good luck.
How?
No, we can use it. Big one, so.
This one? Closer.
No.
Okay.
Right now, this could be 5, 3, and 1. Okay,
Sure.
all right.
Well, thank you very much. Good morning. My name is Rashmi. I am currently not a professor of international law. I've been one for a very long time, and that's why it says professor in the program. I'm on a research break. I'm currently at a different institution, not the General Global Law School. I'm at the National University of Singapore, where I'm completing a few old pending research projects and just taking some time to finish up a bunch of writing that I never got around to doing while I was teaching. So this paper is the first time I'm doing anything in law and development. I'm from public international law and specifically international criminal law. In my previous life, I was a genocide lawyer, and I come into academia from the UN tribunal world. So that's all the set of disclaimers you need. But the paper began with a curiosity about what is the end goal of transitional justice mechanisms, and what do they have in common with law and development? And when I was looking at the field, I realized that there hasn't really been a clear articulation of a relationship. And so my proposal is that there is a relationship, and the case study that I'm using is also a jurisdiction that's completely unknown to me. So if there are Colombians here, I apologize to them in advance for having maybe misunderstood the justice process in Colombia, but I'm happy to be corrected. Please come up to me, tear my draft apart, and we can have a coffee and talk about it. But broadly, my understanding is that the Colombian justice process, which is a negotiated agreement between the FARC and the Colombian state in 2016, was created as a framework agreement involving, of course, many institutions and actors. One of them was the creation of a judicial process, which has yielded, perfectly in time for the conference, two convictions, two outcomes, two judicially quantifiable, recognizable outcomes just last month, in which they have delivered sentences to those who have owned up to, being complicit in acts against the state. There's a long list of 17 counts, international criminal law counts. These two cases are about kidnapping, false information, etc. But essentially, the sentences are about, they're called restorative sanctions. These people now have to undertake programs in economic development in Colombia. Now, this is very interesting to me because this is not really a traditional criminal law outcome. It's not punishment. It's not a legal sentence, strictly speaking. But at the same time, I have to be honest, this is not the first time that international criminal law has come up with an idea that isn't just punitive. It's been in the works from, I think the Marshall Plan also involved plans for restoration, etc. It was in the plan. And during the tribunal that I'm most familiar with, which is the International Criminal Tribunal for Rwanda, former International Criminal Tribunal for Rwanda, it no longer exists. So the ICTR also had portions of the plan involved the Rwandan Gacaca mechanism, which was about community service. Those accused of some of the crimes within the ICTR statute, but who were prosecuted in Rwanda, had to do community service. So you'd see them in pink overalls. They were doing public works like digging ditches and like building schools and stuff. And this was an interesting part of the Rwanda story, but it was really just a part. What's happening in the Colombia example is like a reflexive focus on something that had been always an ancillary part of transitional justice, now becoming the center of it. So moving from punishment and length of sentences, rigor of sentences, cooperation with other governments to have enhanced sentences, bring visibility to the accused, to those who have confessed complicity in the crimes, this model kind of gives back to Colombia. And this is at the most benign, non-critical perspective on what the Colombian justice process is. Of course, it's riddled with holes, and that's a separate conversation. If I get into that, it will make my case for transitional justice and law and development weaker. So let me keep that for the end and just present what the case is first, and then we can pick holes in it, of course. So the Colombian model at the moment appears to me to really turn international criminal law on its head. It appears to offer a sort of a new mechanism, a new model that focuses on integration, development, complicity in public works to rebuild a broken economy. And what this has in common with of course, this has very strong post-colonial echoes. And so this is really like possibly a third world approach to international criminal law, where the state takes ownership of the past atrocities. And so the post-conflict landscape has really no international actors. There's no UN involvement. There's no involvement of other, actors like the United States, which for obvious reasons is missing from most of these conversations these days. So it tells me that in addition to the post-colonial aspect, there's also another similarity or synergy going on between transitional justice and law and development, which is the idea of the end goal being synergized. So, and I think that disciplinarily speaking, this could be an interesting model. And it kind of, when I was listening to the keynote, I was wondering whether there's possibilities in looking at the model itself. How does a judicial reconstruction model speak to local communities? Or how does it speak to empowering those who are most affected by the conflict, which presumably are the Colombians themselves? And I think that there is some sense to this. Of course, now, this is sounding as if I don't have a full view of the problem. Whereas obviously the Colombian story, if you look at the numbers on this justice process, you will find that none of those who are most, the top leadership is completely missing from the justice process, which is normal. That's just how it's been in other international criminal processes as well. And that's possibly why there's had to be some international involvement in the past to get those most responsible some measure of justice for the crimes that they committed. So here, in the cases that I spoke about, the two macro cases whose judgments just came out, it's mid-tier accused, which from an international criminal law perspective is not a great outcome, but it's something to work with. The other problem with the Colombian joint, the justice process, the JEP, is that it's been in the works since 2016. So it's coming close to its 10th anniversary. And they've only just managed to have 2 pronouncements. So, which also is, there was the pandemic in the middle. The FARC agreement fell through a couple of times. It's a political process. There's been no outside involvement. It's run completely by Colombia alone. So there's plenty of reasons to explain this, but it's not a great statistic. Finally, what is the idea behind the paper is to create a story of systemic integration and regime interaction in a law and development setting. So I've looked at the journal and I've looked at some of the past articles on regime interaction and systemic integration. And it's a pretty robust body of work in the journal that brings in other disciplines and gets them in conversation with the institutions of law and development. So it appears to be a promising sort of a catchment area for reopening this conversation. This is basically it. I'm going to hold on to the specifics. That's fine. I'll reserve them for Q&A. And yeah, don't want to have the first paper take up all of that time. And I'm happy to talk more. Thanks very much for the space.
Great. So next is Professor Keynote. Hopefully I didn't mangle your name too much.
Oh my gosh.
It's okay, it was just a seat, unfortunately.
Yeah.
Okay, I should use the PowerPoint.
Hold on.
Thank you, sir.
Give you this.
Okay. So much. Good morning, everyone. It is a privilege to present my work here to such a distinguished audience. But first of all, allow me to thank the Law and Development Institute, its director, Professor Steve Lee, along with the Richardson School of Law and the University of Hawaii, in particular Professor Richard Chen, for their impressive organizational efforts and for accompanying us to this conference with such care. And thank you all for choosing a session on European renewable energy permitting when you could quite reasonably be on the beach right now. And as a lawyer, I take this as a solid and empirical proof that the rational choice theory has its own limits. Start with one simple but uncomfortable question. Can we accelerate renewable deployment in Europe without quietly downgrading environmental protection, landscape values, and the fundamental rights that depend on them? My answer is cautiously optimistic. It is yes, but only if we change the legal method. What I call responsible acceleration means four things. First, we front-load knowledge. Second, we define what counts as a significant risk. Third, we give reasons that courts and citizens can actually review. And fourth, we monitor thresholds with built-in corrective measures. Acceleration in this sense is not a slogan. It is a legal technique. Is it working? Yes. Okay, thank you. And so it moves difficult decision upstream and it keeps control downstream. In the next less than 15 minutes, I will do three things. First, I will show that the European Union turned climate objectives into binding legal infrastructure for faster permitting. Second, how Italy and especially Sardinia, my homeland, acts as a stress test on this model. Third, how this contrasts with the contemporary United States, where money often moves faster than law. And my main and broader message is that the real energy transition is not only about kilowatts or tax credits. It is about how we redesign procedures, evidence, and judicial review so that speed and guarantees can get along and travel together. Let's begin with the European Union. With the European climate law, the Union made climate neutrality by 2050 and the reduction by 55% of emissions by 2030, a stronger and legally binding target. Climate policies moves from aspiration to obligation. And on the backbone of that, see the Green Deal program, the EU Green Deal program, the Fit for 55 package, and the Repower EU plan. Together, they redesign permitting for renewable energy projects. And acceleration comes in three waves in Europe with three different acts. The Directive RED number 2, which introduced one-stop shops and basic simplification. And then during the energy crisis following the Russia-Ukraine war, the 2022 regulation tested emergency fast-track rules. And at the very end, the Directive RED number 3 stabilized the system with renewable acceleration areas, strict time limits, and a presumption of overriding public interest. All of these must coexist with the environmental acquis, EU acquis, which is made of several several procedures which are very, very strict and severe on the control on environmental assessment. The issue is not how to escape environmental law, but how to use it intelligently. And acceleration areas are a good example, because member states in the EU must map zones where renewable potential is high and environmental conflict relatively low. They must assess these maps strategically and only then enjoy lighter, faster project level procedures. So do the hard environmental work once and at the very beginning. Then permitting can run on predictable timelines. Normally 12 months inside acceleration areas, 24 months outside of that. But meanwhile, principles like energy efficiency first and do no significant harm quietly reorder priorities. We should remember the cleanest energy is the energy we do not use, is the energy we do not produce. So even green projects must avoid significant harm to other environmental objectives. And speed is treated as a consequence of good administration and not as a substitute for legality. The Court of Justice in the EU plays a quiet but crucial role by policing assessment thresholds, cumulative effects, and access to justice, turning directives into enforceable rights and expectations. Let's move to Italy, a country that is neither fully federal nor fully unitary, structures that many of you will recognize. Italy has done two important things recently. First, it amended its constitution to protect the environment, biodiversity, and future generation rights, and to anchor economic initiative in environmental respect. Second, it tried to translate the EU's acceleration agenda into national rules, telling regions where renewables should be built without turning landscape protection into a permanent veto. Roughly speaking, the state sets climate, environmental rules, and the regions, something like the US states, control land use and landscape. And the Constitutional Court referees disputes between them. The court's key idea is that environment is not a narrow technical subject, it is a constitutional value. So, both states and regions have to protect it. But the states sets the basic framework so national and EU commitments can be met. Within the framework, Italy created a three-step package. First, in 2021, a national law implementing the Renewable Directive set national targets, created suitable areas, and banned regional moratorium. Second, in 2024, national guidelines told regions how to draw their maps, prioritizing rooftops, industrial sites, degraded land, and limiting unsuitable areas to proportionate and only reasonable cases. In 2024, a national renewable code consolidated the rules, confirmed the one-stop shops and deadlines, and involved the landscape authorities, but without a general veto in a suitable area. Said in a plain English, plan first and together, say clearly where it is easier or harder to build, and avoid silence or vague landscape arguments. So the default should be yes, if compatible within a clear time frame, no, and the exception should be no with reasons a court can review. So now Sardinia, a large island in the Mediterranean Sea with more than 1,700 miles of beautiful coastlines, beaches, makes Sardinia the Italian region with the longest coastline. And Sardinia is also home of archaeological heritage protected by UNESCO and dating back more than 6,000 years ago. Also because, as you can see, the wind turbines are not exactly invisible. And Sardinia has a lot of wind and sun, because while Italy has very diverse wind patterns, Sardinia is an exception in terms of solar and wind intensity and frequency. Persistent wind patterns and the lowest number of rainy days are distinctive climatic feature that makes Sardinia a perfect laboratory for energy transition, but also for conflict. In fact, Sardinia has also special autonomy, a sort of mini constitution, and a strong political culture defending the island landscape against perceived external energy speculation. Between mid-2024 and the end of the year, two things happened quickly. First, the region adopted a sort of pause button law, a temporary ban on new renewable plants over much of the island, arguing they needed time to plan. This is politically reasonable, but legally problematic, because EU law explicitly prohibits moratorium, because planning and permitting must continue in parallel. So the Italian Constitutional Court struck the moratorium down in 2025. But immediately after that, Sardinia passed another law mirroring the national model. So suitable areas, ordinary areas, and unsuitable areas. But according to ongoing challenges, about the 95% of the island was labeled as unsuitable. So formally, this is not a moratorium, but in practice, if one gives a look to the maps, it is a moratorium by cartography. Meanwhile, in Rome, courts also struck down parts of the national guidelines. So this is not a simple bad region versus good state. This is a three-way tension between EU law, national rules, and regional autonomy. 2 weeks ago, national government then approved the new law establishing all areas deemed suitable a priori, the same for all regions, eliminating any chance for region to designate areas unsuitable for the installation of renewable energy plants. And this includes sea, coastlines, mountains, archaeological sites, and even UNESCO heritage sites. So the question becomes, can a national law fully dispose of the territories of regions that also have constitutional powers in matters of the environment, landscape, and territory? Is this sufficient to ensure the achievement of binding targets set by the EU? So the regions have 60 days to challenge the new national law before the Constitutional Court. So hopefully I will tell you about it next year. Let me skip the comparison between EU and US, but I will be very happy to discuss you later during the debate. But let me say something just as a closing. Remember one practical tip When an Italian professor, law professor, offers you a talk on the EU permitting rules here in Hawaii, well, you should probably take it. Because it is a proof that energy transition regulation is already producing bizarre events. Thank you very much, and I very much look forward to our discussion.
Thank you. So next, we have, this thing. Gotta switch the microphone here.
Oh, sorry, yes.
So I suppose we have to ask all speakers to listen, putting on the stage because chairs to. Yeah, with that. So. That it helps.
Yeah.
Putting on the stage. There's a clicker, so you can control the slides. You actually. Oh, it's here. Good morning, everybody. It's a great pleasure to be here to stand before this distinguished guest. And I'm really grateful to Law and Development Institute for giving me the opportunity. My area is I'm going to talk because I'm the student of Law and Development, and I prefer to recognize me as a sustainable development lawyer. As the paper is the geopolitical tensions, environmental conflict, and the development law, reconstructing environmental frameworks. Basically, I'm going to focus on the imbalance between North and South on global policy, and then geopolitical tensions trigger geological disputes over natural resources, and then how to mitigate the environmental conflicts, and then environmental harm and emitters liability, the big debate, who is going to be responsible for environmental injustices? Is it that the government, that the state only, or that multinational corporations or transnational corporations? And then environmental taxation, obviously. And of course, this paper is going to focus on the right to development, trading policies, and geological technologies. And finally, we are going to talk about this, that reconstruction of environmental frameworks and a part of international development law. And finally, crossing this is a global uniform policy. And of course, that overlapping bodies of development laws, because there are certain laws that development with overlaps with the development laws. The impact on environmental issues and conflicts over development is becoming a major global concern. Geological dispute must be balanced with sustainable outcomes because environmental deterioration is escalating and global inequality is growing. Diverse debates and analysis of overlapping development law entities are likely to result from these challenges. In the 21st century, the convergence of global politics, ecological disputes, along with the regulatory structures overseeing development has growing increasingly apparent and is pressing. The increasing environmental pressure and competition for resources can serve as a significant catalyst for conflict and disputes for states and societies aiming for progress amidst various environmental pressures. These connections present significant challenges for governance, institutional structures, and established norms. The expansion of capital across borders has created more interconnected and second environment for investors. The pressing issue for the global community is whether these can also be extended
for the workforce. The challenge at present is for the leaders in the South to reach a consensus on the social provision within the World Trade Organization's agreements that might present a detrimental competition in wages and labor conditions among developing nations seeking to draw for investment. Disparities among states. The most significant difference in global environment policy is between developed and developing nations, which is recognized primarily through the principle of common but the development responsibility, which acknowledges the various is past emissions was present capacities. These disparities demonstrate the necessity for global coordination strategy in which developed nations assist developed states through environmental policies, financial aid, and capacity building to establish an equitable global environmental policy. The pressing issues of ecological degradation, along with social disparities, the pursuit of environmental justice and sustainable progress has become a crucial necessity. The imbalance between North and South on global policy, despite its examining to what extent international legal frameworks ensure environmental preservation. Global environmental policies and North and South divide provides a true analysis of inequalities within developed and developing nations in the formation and execution of international environmental policies. It shows the impact of these disparities on the efficacy of international environment management, the imbalance between North-South and global environmental regulations, and identifying in various key areas where the North-South divide manifests. There exists a significant disparity in knowledge and dissemination between nations classified as developed and these identified as developing. Developing nations conversely have persistently advocated the acknowledgement of responsibility imposed on multinational corporations. The United Nations or transnational corporation played a crucial role, but if we look at still the code of conduct on transnational corporation is not adopted yet. The draft code highlighted the domains where the operations of multinational corporations might arise and advise the impact of host nations. The primary focus was on issues related to development, the implementation of limiting commercial priorities, and similar actions grant significant security participation in regional political conflict and various initiatives designed to support very factions aligned with international corruption was another matter that was discussed. The prevention of bribery and other ethical practices was strongly recommended. There were mentions of safeguarding consumer interest and preserving the environment. Therefore, the inequalities within the global North and South in terms of environmental protections is characterized by significant differences in accountability and suspectability. The historical impact of industrial development in global North has played a significant role in the ongoing climate crisis, also in the environment of the global South experiencing the consequences in a markedly unequal manner. Genuine alignment of policies is necessary enforceable international standards for labor rights, fair trade agreements, and collaboration among developing nations to create a universal baseline for the rights of the workers. Over the issues of differences in global policy between North and South arises from overlying levels of enforcement capability, unequal institutional structures, and divergent development goals across geopolitical tensions. Geopolitical tensions arise not only solely from the explicit rivalries between the nations, but also through the contestation of essential resources, including water, land, minerals, and energy. The conflict over resources is increasingly influenced by change in the environment, deteriorations, and deficiency in governance, whether related to water policies, resource extraction, or shifts in energy framework. Such a scenario illustrates the environmental conflict transcends local boundaries and is increasingly linked to global power structures, financial investment, and regulatory framework. The difficulty is intensified by the reality that numerous regulatory frameworks were established during time when environmental concerns were considered secondary rather than integral to alongside the geopolitical shifts from Cold War. Natural resource governance. Natural resource governance stands at the crossroads of economic development, foreign investment, and imperatives of environmental justice. Geopolitical tension is significant domains of natural resources and sustainability driven by geopolitical factors influenced by political powers and interests manifest in different forms of trade disputes, marine disputes between China and Japan, Russia and Ukraine, conflict caused in global energy markets, and climate change. Conflicts over natural resources and geopolitics is the outcome of colonization for African and Asian resources. Decolonization also coupled with anti-colonial pledges to control over their natural resources and new colonialism focused on economic access to natural resources and cheap labor. Multinational and transnational corporations have played a significant role. Multinational corporations across with new globalization theory that disputes of transboundaries are a threat to international peace, instability, and development. The colonization of natural resources is deeply intertwined with geopolitics to occupy and to exploit leads to geopolitical conflict and tension. Colonization to decolonization. The world experiences evolving geopolitical tensions, sometimes exploding into a serious conflict across the globe. Colonization in another recent expression, providing a platform for various debates around energy and climate in the global north and caused studies from across the global south. The impact of geopolitical tensions for overall development of a state is significant because the return of geopolitics, and we can see that from this discussion, the geopolitical tension has been returned because it was in the time of colonization, now it's a decolonized, but we can see that even in the term of the post-colonization is still that in the name of the green colonization, there is another exploitation. And there is an evolving nexus between geopolitics and development and a sense of complex entanglement between geopolitics and development and the past and future. From this perspective, it is essential to analyze in a decolonized world to see that how countries exploit natural resources by complying with international trade agreements between countries. If we look at that about One Belt, One Road, One Belt, One Road initiative, which is known as the Belt and Road Initiative to foster closer economic cooperation with countries lying along two ancient economic considers, that is Silk Road Economic Belt. Maritime Road, which run from China through the continent, Asia, Europe, and Africa. The exploration of transboundary natural resources is a conflict between and among states. In this regard, the issues we can take over as a case study. Impact on, we can see that what is the impact on over of Asia Pacific region. Under the OVO initiative, investors from China and from other countries which have agreed to join OVO initiative will get the opportunity to invest in each other's status. However, entering into partnership with the Chinese company will be a precondition for the investors of other countries before investing in projects in China. We can look at Bay of Bengal. Bay of Bengal also there is another geopolitical tensions because in the Bay of Bengal there is a huge natural resources. And the Bay of Bengal, also seen as a strategic backwater in the early 17th century, is today becoming increasingly important in global geopolitics. The Indian Ocean region once thought to be free and superpower competition during the Cold War. These are the things that ocean geopolitics. The resolving geopolitical disputes over natural resources is multinational approach. Essentially, law of the sea issues continue to be an effective source of geopolitical liability due to the confluence of legal obligations coming for valuable resources. And if you look at transboundary environmental harm, is a significant challenge in international environmental governance, where actions which one state cause risk significant damage beyond its border. The issue tests sovereignty, accountability, and international cooperation is the environmental consequences of industrialization, deforestation, and greenhouse gas emissions often transcend territorial boundaries. And in the beginning, that's the state is not only the state is responsible, multinational corporation and transnational corporation, they should be also liable for the emissions. And that taxation. And then if you look at that, environmental taxation also imposed. And that's the one point I want to address that insurance when they signed the agreement in the agreement to put that there will be an exclusion clause. So before happening in the environmental disaster, they want to put an environmental exclusion clause, and from that clause they want to exclude their liability. If we look at on the issue of that overlapping, either if we look at the cyber security or the transfer pricing system or any other things, that transnational corporation, where we stand globally, we don't stand on a common platform. The burning issue is how we stand against these injustices, the environmental injustices, that is extraction by north from the south. Thank you very much.
Good. Next, is there any, we need to get the microphone.
Got it right here.
I left it there.
I don't have to bother something.
Kathy Trissolini. I am coming to you from Los Angeles, from the Loyola Marymount University Loyola Law School. And I'm going to be speaking about permafrost today in hopefully both terrify you and then give you some hope. So that's how my students probably describe what I do. Because I work in climate change, there's a lot to be worried about, but I really try to find some optimism. And it's a hard time to be optimistic if you're a lawyer in the United States right now about the environment. Our current administration is really trying to undo everything in the field of the environment, including one of the things that I worked on my students with. They're literally trying to undo the regulatory basis for regulating greenhouse gases by withdrawing the finding of a previous administration that greenhouse gases endanger public health and welfare. So regulatory process, that finding was the essential necessary basis for regulating greenhouse gases under the Clean Air Act. So they are trying to basically gut this from underneath. And in addition, the Trump administration has made it clear that the overriding goal is to advance the development of fossil fuels, and has really tried to gut alternative energy production. And for many reasons, this is obviously crazy. I'm not gonna use kind of fancy language, which I think would normalize it. It's a really crazy thing to do right now, and based on a lot of strange ideology that doesn't even count for all the benefits, even economic benefits that we get from protecting the climate, from pursuing alternative energy. Fortunately, the rest of the world is going on without us, because I think the US is in a state of temporary insanity. It's temporary, it's going to get better. Now, my question is, I'm looking at one specific problem in the climate realm and trying to figure out if there's some way to move something forward. And I should say that this administration has also taken the position that climate change doesn't exist, and that it is some kind of it's a very anti-science administration, and it's a very difficult time to move anything forward. So one of the consequences of the warming planet is melting of permafrost. I kind of knew a little bit about permafrost. I heard a little bit about it, but several years ago, in looking at, in the prior Trump administration, some efforts to open up parts of Alaska for drilling, I ended up commenting on some formally commenting on some processes that they were doing, finding out more about permafrost and just how important it is. Now, all of the things that are being affected by climate are important. I don't mean to downplay that. But there were things I found out about permafrost that made me just raise my antenna up. So permafrost is something we've had around for a long time. Let me tell you what it is. So it's defined technically as ground that has been frozen for at least 2 years. But some of the permafrost that underlie, and not under a glacier, so this is permanently frozen ground, it may go through short periods of thaw in like a little top layer, but some of it has been frozen for hundreds to thousands of years. And it provides us with a lot of ecosystem services. To use the kind of more economic language, we would say it provides a lot of ecosystem services. In the state of Alaska, for example, and I'm sure other parts of the cryosphere, it provides stability upon which we've built a lot of infrastructure, right? Other things that it does is it captures a lot of carbon by freezing plant matter. It's also frozen a lot of pathogens in it. And one of the things that for some reason, even though the thawing of permafrost has all kinds of problems, one of the ones that scared me more than anything was the fact that it is the world's largest store of mercury. It has sequestered mercury from our atmosphere. And we really, if you put all the other soils and sources around the world combined, they don't add up. There's twice as much stored in permafrost. I think all of us have a very strong interest in not having that mercury released, it's a neurotoxin. So that really got my attention, among other things. So when I lost my timer here, let's see.
10 more minutes.
10 more minutes. Okay, I better talk fast. Okay. So obviously when permafrost thaws, the infrastructure falls down. And that's one big problem, right? So communities living on this infrastructure, it starts falling down. This is, as is the case with many environmental harms, it is disproportionately hitting communities in huge environmental justice implications. There are indigenous communities in the Arctic, in other areas. I'm looking predominantly Arctic because there are certain things in common with this community. So there are indigenous communities there, their infrastructure is falling down. The ecosystems on which they rely are falling down. The roads are falling down, their houses are falling down. And there are some coastal communities where the ground is falling down and we're getting sea level rise and melting ice. They literally have to move. So huge environmental justice concerns as well in dealing with this problem. There are a whole bunch of reasons that we don't want to have a massive thaw of permafrost. Another big reason is great potential for a vicious circle because all of this stored carbon gets released as the permafrost melts. It also generates more methane as it breaks down. And one of the things that happens as it breaks down, you get these little depressions and lakes, and methane can bubble up for that. Methane is a very potent greenhouse gas, more potent than carbon dioxide, in fact. So you can get some very bad vicious feedback loops going on with the melt of permafrost. So health issues, release of microbes, infrastructure falling down, huge environmental justice issue, potential for vicious feedback loops. Have I made you terrified? Okay, now I'm going to try to find some reason for hope in all of this. One of the things that I've been thinking about, we generally target, and the work that I've done in the past has been to think very broadly about, we have all these climate harms, let's try to solve the climate problem. And, some parts of the world are doing a lot better than that, on that than are my countries, right? My country's going backwards on that. That's all I can say. We're a big part of the problem, we're going backwards. And I am optimistic that future administrations will do better. But another way of doing it is to think about adaptation, adapting to the changes that come. And yet a third way might be to look at specific media and trying to protect certain things. And I think there may be a path to say, instead of trying to fix the whole climate problem, let's try to protect permafrost. And it actually is possible to do that. And I think it might be politically more palatable, even in this environment, because one of the entities that is getting hit by permafrost destruction is oil companies. And they are big supporters of this administration. Russia, which also has a lot of area in the Arctic and a lot of permafrost. Also, the government owns a lot of oil. The infrastructure for oil needs roads, it needs pipelines, and these things are getting affected by the breakdown of permafrost. So I think there's a potential for some of the very industries that have fought against broad-scale climate change regulation to support targeted permafrost. So this is, maybe that thing of, collaborating with your enemy or something. Sorry for any of those of you who are oil developers, me calling it the enemy. So there's a possibility of kind of realigning some of the political analysis, some of the political entities. And there are actually mechanisms that can be very, very, very protective of permafrost and drastically slow down this melt before you even get to fixing the climate, which I sure as heck hope we're going to do. And one of these, there's a great study out of, forgetting the name of the author at this moment. I had it on the top of my head, and I'm not going to take the time to look it up because looking at using large herbivores in the Arctic. So these are large animals that it's remarkable. They kind of walk around and step on the snow in the winter, and they let it get colder in the winter. Sounds like you might think, well, that sounds like a Disney movie rather than a solution to an environmental problem. But some of the research that's been done on this shows that what you can do with that, the amount of difference that can make, even under the worst climate scenario, one of the worst ones, 4 degrees Celsius of warming by 2100, that this could be the difference between preserving 80% of the permafrost and 50%, just herbivores. Right, herbivores. Another thing that we can do is the way we build our infrastructure, having insulating layers. It's possible to have insulation between your infrastructure and the ground to help protect. There's also certain kind of plants and preserving certain plants that will further help protect this infrastructure. We also have an entity, the Arctic Council, which has benefits and drawbacks, but has this region and has worked as a resource for cooperating and creating treaties in this region. There are other areas with permafrost, Tibetan Plateau, et cetera, but there's a lot of it is in the Arctic. This might be a good place to start. And we have an entity that might serve as an area for collaboration. And there's already research going on. They're looking at permafrost. They're doing some of the monitoring and so I'd like to see us move beyond monitoring to creating some agreements about how we're going to move forward in protecting permafrost. And a bunch of different entities we want to bring in addition to there are permanent members on the Arctic Council. Unfortunately, the indigenous communities in the region they're participating, but not, they're kind of secondary position members, but of course they would be there. Should be involved, and there is indigenous knowledge that can be brought to bear on how to preserve permafrost and what kinds of additional things could be done, and also in terms of working with the existing environment in terms of the plants and the large herbivores and bringing the large herbivores back. Key components of an agreement could be actual kind of land use zoning plans and building codes. There could be funding and resources and zoning for large herbivore communities and facilitation of the development of herbivore communities. There could be mandates put on oil and gas companies to use insulation, and they have an incentive to do this. This is why I'm a little bit optimistic. And in terms of the environment in the US, you don't have to, it's crazy that we even have to go here, but you don't have to talk about climate change. You could say permafrost is falling apart. This is a huge problem. We need to keep the permafrost full. So you can sidestep some of the climate denialism in the US and make progress now, possibly, right? It's a way of getting at something in an otherwise really recalcitrant environment. And because the stakeholders, the entire state of Alaska, the oil and gas industry here, and in the other countries, they're also dealing with oil and gas interests. They have indigenous communities that are being affected. And another thing that we really want to work on in this regard is wildfire control, because wildfires in that region very destructive. But again, that's also something that those national and local communities have a strong interest in controlling. So very serious problem. A third way of doing it, not just like, let's solve the whole climate problem, which I would like to do, but in the meantime, let's try to do this or alongside it. And I have some optimism that it could be possible, sidestepping some of the political barriers. And I really welcome all kinds of feedback, anything you have.
Last speaker on this panel, Professor Mike.
Sorry.
Morning, everyone. Thank you very much, Professor Lee, the organizing team and Institute for this wonderful opportunity. It is a pleasure to be here. I do not take this for granted. It's my wonderful privilege having you all attend this presentation. So I'll be speaking on environmental constitutionalism and the future of sustainable development. As a starting point, I want to give a little background and motivation for my presentation before I delve right into it. I am an assistant professor of law with the American University of Nigeria in Nigeria. I'm currently a visiting global studies scholar with DePaul University in my sabbatical there. And the motivation from this research stems from my own personal studies of environmental protection in constitutions, starting with my home country, Nigeria. Nigeria somewhat recognizes constitutional protection in Section 20 of the Constitution. However, it is non-justiciable, meaning it is just a policy declaration without a binding commitment to actually protect environmental rights. And I found that this is the same intention behind legislative protection of environmental rights in many constitutions around the world. The US Constitution, for example, does not have an explicit recognition of environmental rights, environmental protection. Australia, Ireland, the United Kingdom, these are developed countries. And when you look at African countries as well, you find that across different constitutions. And so my presentation today considers the importance of protecting environmental rights, the environment itself as a constitutional prerogative, and not just a declaration of intention to protect the Constitution. And I'm seeing this as a pathway to sustainable development. If there's anything the 21st century has revealed to us, is that humanity is confronted with a lot of environmental crisis. We see that through climate change, we see that through the crisis across the world, we see that in activities of the extractive industries. And there's been talks, even at the international level, to protect the environment, to protect the rights of people, especially vulnerable people that are particularly affected by these environmental degradations. But most of the time, it has resulted in mere declarations, even at the international level. At best, we have regional documents like the African Charter, which explicitly recognizes environmental rights. But even at that, there are some regions like Asia that does not have a binding regional document to have this environmental protection embedded in it. And so it presents problems for those regions, especially those that are suffering from environmental effects. Even countries, national policies, national laws, like I mentioned earlier, do not explicitly recognize the environment as worthy of protection. And this gap is more visible, especially for vulnerable populations. For children, research has shown that they are particularly susceptible to environmental harms, the effects of environmental harms. Women as well, research has shown how the environment has a particular effect on them, especially their reproductive rights. And so it is important that the protection of environment is not taken as a lip service to international discussions, but protecting people's rights that are linked to several other human rights, such as the right to health, the right to life, particularly. If the environment is badly affected, I doubt if any of us will be here. The right to food as well. And I'm sure some of you may have taken something this morning, we take some of these things for granted as daily lives, but if our environment is badly affected, it affects even the comforts that we get to enjoy. And so the environment is particularly important and is worthy of protection. Environmental degradation has been linked to several issues such as water scarcity, climate change, the ecosystem, and this has resulted in billions of deaths annually around the world. And so I have looked at environmental constitutionalism as a transformative paradigm, as a transformative instrument to safeguarding nature, to safeguarding the rights of the people. And once the environment is recognized as a legally binding, enforceable right, it carries with it a lot of weight. It is no longer a mere policy document for the executive or the government to discretionarily protect. Number one, it gives people the right to seek for enforceable protection. It gives you and I an opportunity to go to the courts, to approach the courts and ask for an enforceable protection, and also to compel a duty on the administrative bodies to protect the environment. And so it is an important responsive instrument to protecting the environment and ensuring that the environment is seen as a conduct towards human flourishing. And so one of the things that I have looked at is linking human rights to environmental protection. As I mentioned earlier on, the right to environment has several links to other human rights, the right to health, the right to life, the right to water, the right to dignity, and several other human rights that you can think of. In fact, I can't think of any other human rights that has no direct or indirect link with environmental protection. And again, when it is recognized as a national law, an enforceable binding national law, it carries with it a support for the international discussions that we keep having on protecting the environment at a global level. What is environmental constitutionalism? Let's look at this in detail. Environmental constitutionalism is characterized by the inclusion of environmental rights, obligations, and principles within constitutional texts, as well as ensuring that their interpretation and enforcement is adequately adhered to by the courts, administrative bodies, by the governments. And what it does is that it gives a priority to environmental protection. In my country, Nigeria, because it is not a binding obligation, it's left to the discretion of the states, discretion of the government in power. Whereas if it were to be a binding environmental priority, it elevates it to a sort of a public good, recognizing it as important as other rights that are justiciable in the country. Again, it provides legal remedies to populations that are particularly affected. I did a study on the extractive industries and the environmental harms that they carry out in mainly developing countries, and I looked at this within the context of green environmentalism. The fact that we want to transition to a better way of protecting the environment, but the people that suffer disproportionately from this are those in developing countries that have these raw mineral resources. And when I looked at their constitution, there is no adequate protection or succor for them to seek for the protection of their environments. Most of the time it's embedded in policies. And when we see economic interests taking the place of environmental protection, there is little legal recourse for the people to put environmental protection in the forefront of economic interests. Again, it imposes a duty on states to prevent degradation, to provide protection for environmental harms, especially the actions of third parties. In my country, Nigeria, the Niger Deltas, a region that is oil rich but has been subject to so much exploitation of its oil resources, had to approach the African court for protection, for legal protection within the context of environmental rights that they had in the African Charter. They had to approach the African court because the Nigerian court does not adequately recognize their rights to environment within the constitution. And it had to take the African court to declare that the people in Nigeria had environmental protection. If the African Charter was not existing, imagine what would happen to the rights of the people in that region. Now, I have looked at some countries that have effectively protected the rights of the people through constitutionalism. And South Africa, for example, is a leading country which explicitly recognizes the right to environmental protection. Ecuador goes further to not only recognize the rights of the people to environmental protection, but the rights of nature as well, ensuring that the environment is adequately protected, not just for the present, but for the future generation. Colombia is another country that gives us a sort of example of a good constitutional protection for the right to healthy and clean environment. Now, outside constitutional provisions, we've seen cases where the courts have exercised judicial activism in proactively recognizing the right to environment by linking it to other justiciable rights. In India, the court was able to link the right to life to the right to protecting the environment. In Colombia as well, they recognized the Amazon, the protection of the Amazon as a link to protecting the rights of the people, and several other cases. So, what are the ways of going about some of the recommendations that I have in my paper? I've asked for constitutional reform. Of course, if I'm calling for constitutional recognition of environmental rights, it starts with constitutional reform. But besides constitutional reform, it's not just enough to recognize the right to clean, healthy, decent environment in the Constitution. It requires a holistic approach, and a holistic approach entails educating the judicial officers on the best way to protect the environment. Say, for example, in Nigeria, that even if the right to environment is not a justiciable, recognizable right, there are other ways, like the Indian courts, finding ways to protect the environment or environmental rights through linkage with other justiciable rights. And apart from that, training, enhancing the opportunities that individuals have for public interest litigation and effective enforcement of court orders. This is very, very important. The African court was able to make a decision in the Ogi case in Kenya, recognizing the right to healthy environment for the people in that region. Till today, the Kenyan government has not carried out an enforcement of the orders that were made by the court. So it's not enough to recognize it. It's not enough for the courts to make a decision. We need active political will to back those decisions that have been made. Again, we need an international treaty. Guys, it is time for an international treaty on environmental protection, a binding international treaty. At best, we have declarations at the moment. We need a unifying instrumental means of recognizing the right to the environment at the global level. Again, global corporate accountability. Most of the environmental harms that we see these days are carried out by corporations or third parties and individuals. We need to hold them accountable in our laws to all the harms and the activities that they carry, as well as linking this protection to issues such as distributive justice, recognizing gender rights, taking into account intergenerational justice, protecting the environment, not just for the present generation, but thinking about the future generations. We're talking about development at this gathering today. Development cannot come about if we only think about ourselves today. Development will only work if we think about the future generation. And lastly, I want to say that the future depends on our collective capacity. Everybody, all of us, one way or the other, we can make a case for protecting the environment. It starts with recognizing, first of all, that the environment is worth protecting. Secondly, protecting the environment, and then enforcing the environmental protections that we have. Thank you.
Well, thanks to all the speakers for keeping to the timeline. We actually have time for discussion now. So is there a microphone that'll get circulated, or people should just speak loudly? Another one here. Yeah. Yeah.
It's easy when you get this, just to turn it on and use this as a microphone, right? So.
We touched on virtually every continent. I didn't see a mention of Australia, and I'm going to count Antarctica in the permafrost as well. So we hit almost every continent, the Bay of Bengal, the Mediterranean. So we've hit lots of bodies of water as well. So everyone should have an opportunity to talk about, raise an issue from their area. Here we go.
I can talk loud here. Professor Trissolini, you talked about infrastructure failing. Can you give us a little bit more concrete examples? Because I don't understand what that means when you say it.
Oh, thank you. Okay, I appreciate that. So, actually, I have a quote here. See if I can pull it up really quickly. Maybe I can. Okay, here's somebody, a Nunavut participant. He's from Canadian Indigenous. Biggest impact that permafrost thaws had on me is probably my house shifting. My drywall, especially around my windows, has cracked. My insurance doesn't cover it. Other places, the foundation literally sinks. So if you can imagine a house and half of it is sinking, Oil pipelines, the ground underneath them shifts, roads, other participants in this survey talked about, yeah, part in our town, the road just collapsed in certain places because you have a solid ground that suddenly becomes it just melts, so that's the kind of thing, and it's quite extensive. There are communities, coastal communities that are so effective. I mean, there's one community that has had some funding and has partially gotten their community moved, but it's been only partially successful. But they're literally becoming uninhabitable because if they're coastal, their ground's collapsing, and the sea ice that would protect them also isn't protecting them. And then we're inland. It's literally the shifting ground. Yeah. Thank you for the question.
Right to the mic, or you can shout.
Yeah, I can just used to talking to figures. So I have a question for thanks, Professor Rahman. So I was interested in what you're saying about the different forms of outcomes in traditional justice forums. And I was wondering if part of that is because there's, I suppose, a different underlying logic behind transitional justice and criminal justice, even though they do kind of meet or intersect within these forums. And do you think there is something there that transitional justice is pursuing something different to, and should we transfer some of what we learn in transitional justice forums into criminal justice? Thank you. That's a great question. You can hear me, right? I don't know how to get this thing on.
You're loud.
Thanks. That's a great question. There's been studies that kind of chronicle transitional justice as being in sort of a phase 3 right now. Phase 1 was very much retributive, very mainstream international criminal law. Phase 2 was, I think, or in some parts, these are overlapping, so they're not like temporally accurate or watertight. But phase 2 has been about amnesties and lustrations and kind of sweetening the deal for those most responsible for conflict to come forward and take ownership. And that also includes truth and reconciliation, sort of the creative period of international criminal law. But phase 3, where we're at, is about looking at what exactly has been lost in the conflict. And that's why I picked Colombia, because it's such a great example of the environmental impact of armed conflict. And the joint, the special program, special jurisdiction takes into account the environmental degradation and tasks those who have owned up to it to come forward with specific, tangible results and outcomes that are linked to restorative justice. For example, in macro case number 05, one of the verdicts, like one of the sentences, is on creating an agricultural plan for a whole community. And so the alternative, so it's like, if you don't do this, this case will now go back to the traditional criminal route. So there will be a criminal sentence at the end of it. This is plan A and that is plan B. So I think you're totally right that there is a creative restructuring of transitional justice as a discipline. But at the same time, transitional justice is still taught as something within international criminal law. It's broadly housed within international criminal law. It includes critical approaches to international criminal law. There's more critical questions on human rights law. But as a discipline, it sits within ICM. So thank you for that question.
Question here.
My question is to Professor Goino. So in your paper, you have mostly focused on the lawmaking rather than the courts. Thank you. So in your paper, you have focused more on the lawmaking side rather than the courts. So I wonder, in terms of advancing there's this area of the law and advancing environmental purposes, to what extent is there space for the Court of Justice of the EU to use the big picture principles such as primacy and be a bit more imposing? You mentioned one of the big principles, which is loyal cooperation, which is always used as an umbrella to advance those things. So do you think that there's extra space for the Court of Justice to make even more of an assertive statement? And if so, would that be seen as too imposing? Thank you.
Thank you very much for the question. Sure, European Court of Justice will have some more room, but maybe after 2030 or 2050, because most of the objective, most of the goal are set by directives. So the member states are free to find a way to get to the goal until the very end of the term. So maybe between now and 2030 and 2050, much more the EU Commission could pay attention on how the member states are doing and what intermediate goal they are already got. Since everything started, the European Union has already reduced CO2 emissions by 35% right now. And Europe is the fourth major producer of CO2 in the world, but it counts for only 6% of CO2 emissions all around the world. So now is the moment of the lawmaking, and the judicial review is going to come. It's going to come in the very future years.
Thank you.
I'll take a moderator's question. Almost all of you, I think everyone, but at least almost all of you talked about some international legal frameworks as an important part of this. And I wonder if you could, and you especially, Ms. Corneau, talked about the sort of meshing of the international and supranational institutions with national ones. So I wonder if any of you have thoughts about the connections between those international frameworks and national law frameworks that are particularly problematic in implementing the goals of the international treaties and supranational frameworks. So
Yes, that's true. I can go on with a question already posed. You have to think of a European Union, especially as a sort of funnel. So environment is one of the main authorities where the EU is placed, and then the European Union can establish standards that are mandatory for the national member states, and then for the regional, for region, and then for local government. So the European Union establishes the very broad standards. Any single member state can also go on can defend it more the environment, but no less. So it is a sort of funnel, and everything stayed together. But the problem is the primauté, the primacy of the European Union is something that is not so easy to maintain all around the broader EU, because national states member states are completely different constitutional tradition with respect with environment. Some are pay more attention, some much less. But today, the result seems to be quite encouraging. 35% between 2019 and 2024, it's quite a good goal. In 2013, it's supposed to go up until 55%, and finally in 2050, the neutrality. We'll see.
Maybe just work down the table. Professor Mike?
Okay, so I I would say that there's no synergy. There seems to be a disconnect on environmental protection at the international level, the regional level, and the national level. At the moment, regional laws are our saviors, so to speak. You look at the African Charter, you look at the Inter-American Convention, you look at the European Convention as well. These are instruments that are strong on environmental protection. But then you go down to national laws, and most of them are lacking on environmental protection. And we increasingly see a challenge to these regional instruments. Look at the African Charter, for example. A lot of countries are currently withdrawing from the jurisdiction of the African courts to make decisions regarding their implementation of the African Charter, simply because of the decisions that have emanated from environmental protections and so on and so forth. And when countries, very few countries, recognize the jurisdiction of the African courts with respect to the African Charter. And when you find countries withdrawing as well, it jeopardizes the ability to rely on these regional instruments. And so there is a big disconnect. And at the international level, it's not trickling down to the national level. How we can bridge the gap and make sure that there's a link from the national, regional, and international level is still the subject of debate. And I have no perfect answer to it. But we need to find a way of making sure that the rights at the national level can translate to the regional level and the international level, and citizens can get to enjoy it at the three levels.
Thank you. That's a great broad question for the panel. We are at a time when all of us as colleagues are looking at the power of the advisory jurisdiction of the international courts. And I'm talking about the ICJ, the ITLOS, and the Inter-American Court. We are waiting for the African Court to come up with the fourth one in the series. And I think that what this advisory trend in international litigation suggests is a lack of faith in national laws to deliver on big ticket issues like environmental protection and climate change. And I think that's also, well, my paper kind of inverts the question. It puts the national level higher and subjects it to the international law on armed conflict, on which there isn't a specific provision for environmental protection. But I think Colombia goes that extra step and just creates, at least superficially creates, this visual of very futuristic restorative justice, which, you know, it's a great, looking at it from the most optimistic lens, it's a really great model to implement international law at the domestic level. But yeah, I agree with Professor Mike. The challenge is not with the domestic, but with the regional systems being able to bring international standards to regional kind of languages, dialects, that then translate into domestic law. And twice today, I think India and Colombia were lauded as great examples of this kind of judicial adventurism. We've seen that in the Indian Supreme Court just this year with the climate change case, Ranjit Singh versus Union of India. And that case also creates a really big ticket visual of a domestic court going the extra step to protect the environment. But if you contrast that with India's position before the International Court of Justice in the climate change advisory opinion, India took a totally different position for the ICJ. And that is in keeping with developing countries' general positioning as victims of climate change in general at the broadest level. But at home, it's a different story. So there's all kinds of levels that the international, the municipal operate at. Thank you.
When we talk about that reconstructing international environmental framework within international development law, so we have to see that is from the global perspective. So from the global perspective, we must see that who is emitters, who is going to suffer, who is going to pay. So we know that, but if we, again, there is a debate between North and South. So on the issue of transfer pricing, on the issue of taxation, everything is, the South did not have, participation in the development of these laws. So if you see that protocol or whatever the laws have been formed, but it's not giving us ample opportunity to get our, the environmental disasters compensations or even the taxation. Rather than they are trying to, even the multinational corporation or the transnational corporation, trying to put the exclusion clause in the agreement so that before happening everything, they can be excluded their liability. We see that Bhopal case happened in India. Still, they are, suffering. But that international perspective scenario is different. So when we talk about that, then I mentioned that Bay of Bengal. It sounds like that from our country. Oh, the investors are coming, so we are, getting the money. But after the cases is being settled, when in the Bay of Bengal, where Bangladesh is trying to bid, but nobody was, participating in the bid. So there are certain, ocean geopolitics. So my point is that why do we stand globally? That what is the barring issue? The barring issue that globally you have to decide or you have to take a stand against the environmental injustice because it's affecting globally. So we cannot see that north and south from that perspective. Though international level, the law should be really, it should be global so that the globally application, we want to see that the ensuring that global accountability and global accountability as well as global application of these laws.
Thanks. So to some extent, the idea I'm talking about is aspirational, obviously. The Arctic Council, which I look at as a possible mechanism for getting together and talking about this, right? Couple of the members on there, difficult, US, Russia right now is involved in an invasion and all kinds of expansionism. The US is recalcitrant on climate change and other activities that seem to not comport with international law. So definitely some difficult members. Reasons that I still think it's worth trying to develop this idea. It's, not too long ago, the US in 2020 passed the AIM Act, which was the American Innovation Manufacturing Act. It enabled the EPA to phase down hydrofluorocarbons, which was to align the US with the Kigali amendments to the Montreal Protocol, an international treaty to phase out hydrofluorocarbons. So actually moved, the US actually took some steps on this international treaty. With regards to permafrost specifically, there are both international and local dimensions to the need to protect permafrost. So in contrast to something where you see a global commons and you have a general tragedy of the commons, which you really need to get people to work together on, we certainly have that with permafrost, but you also have a lot of very specific localized impacts that I believe nations would want to avoid, have a lot of incentive to try to avoid. So the incentives to protect the global commons are aligned to a certain degree with the incentive to protect the localized environment as well, keeping mercury out of the water supply, not having these runaway wildfires. And the mechanisms for fixing this are not in conflict, and it's sometimes aligned with the interests of the large corporate entities that often oppose the international treaties. So I feel like it's worth working towards this, even though we've got a couple of countries that have been challenging in the context of the Arctic.
Yeah, maybe I ask one question aligned on that. You mentioned the Arctic Council. What's your view? What should be then the position of these observing members, like China, who is not even Arctic country, but something else? I'm originally from Finland, so it's close to my home.
No, I think you might be able to tell me more about that. Like I'm learning about this. I will put my cards on the table. I have usually done domestic and local climate change policy. So this is kind of a new thing for me, and I'm learning about it as I go. So I welcome your feedback. I have noticed that China has been very involved, and there are a lot of other observing countries And I haven't
Because for us-
completely sussed out what that role is about, so I'm
Yes,
curious.
because for us, it seems, I'm of course fully biased. I'm originally from Finland, so one of the countries at the Arctic Circle. But for us, it's also a really important way for military purposes. So for us, it's not only about natural resources and how we should make sure that we have sustainability so taken care of in that sense, but also for the military sakes, because those waterways are important when it comes from Russia, when it comes from China, and how you can work your way with NATO and use those roads over, I would say they have a dual sense of usage. So it's, of course, it's an important road for commercial purposes, as we know. We also have a lot of important natural resources. Years. But also, if you look at the map, it also has an importance for military purposes. And I think those are also some of the aspects we naturally need to take into account when we are thinking about how and if there could never be a treaty, and how would that treaty look like, and who would be the parties to that treaty. So that's why I was kind of interested to hear your view, how you would see the standing, and if there is any legal standing of countries that are not actually part of the Arctic, just as China, who is more showing a presence within the Arctic matters. Did that make sense?
Yes, ma'am. What about the Rohingya, that humanitarian crisis? It sounds like that the Rohingya is a humanitarian crisis, but is it that Rohingya is only humanitarian crisis, or is it that environmental refugee? What about this?
I wouldn't know that. I don't have any special.
That's the geopolitics, because
Yes.
that's the geopolitics, because when you talked about that the role of China, that role of China is very dubious, because even my papers I was trying to explain it, that there was a hidden agenda, because America tried to exclude China from another partnership agreement. Then China announced that OBOR, because OBOR was the Silk Road was that was announced 2,000 years before. Now they have brought it on the table. And if you see that the Rohingya issue, because that's a dispute Bangladesh, Myanmar, there is a,
We have to be frank. I have really
that's the main point, is that this is not the issue of the stateless, this is not the issue of the humanitarian, this is the issue of geopolitical tension.
My question was maybe more or less on the complexity that if you are actually not a country who holds any soil or water position of the Arctic area, should you be involved in the table within these discussions?
Yeah.
And I fully hear your argument, and I agree with you. These are things that have a global impact. But when we think also about the military implications that it might have who's sitting in the table, it's really complex. And as generally, of course, I don't have any answer on that. But maybe just kind of raising the awareness there that you have.
I have a,
That's
can I
kind of
ask you a
attention
question?
there.
I don't know, or am I allowed to ask somebody else a question? I don't know. So, I mean, so what's interesting is China actually has areas with permafrost, and I was so there are other parts of the world that have permafrost, like the High Tibetan Plateau, which China has. But I was trying to think of areas that have more of an ecosystem in common, at least to start with. Do you think that merely by having discussions about permafrost, that, and if there are other people at the table, that empowers them militarily? And there seems to be something under your question, and I want to make sure I understand it because it seems really important. Like, is your concern that if China's at the table, they're getting more embedded in this Arctic region in a way that they shouldn't be? Is that what you're suggesting?
I'm choosing my words really carefully.
I'm not. I've already said many offensive
But
things.
I would be happy if you're interested on that. I have a few colleagues who are working on the Arctic matters at the University of Lapland in Finland, and also in Sweden at the Arctic part in Luleå. I'm more than happy to connect with people who are way smarter than me on those.
Yeah, I would love.
But I definitely think whenever you have resources, you might have complex issues at table. That is probably only that I could say in my
Thank you for raising that. That's really important. Yeah.
Good morning, everyone. Thank you for session set for the presentation. Just reaction about two of the presentation relating to European Union and also African perspective. Last week, the African East Court of Justice suspended the trade agreement between Kenya and the European Union. And I was after the request of NGOs, Kenyan NGOs, because the Kenyan NGOs think that this agreement breached the constitution of Kenya, but also the treaty of the East African community. Not the problem in Africa that we don't have just one regional legal framework, that we have also the REX, the regional economic communities. And what I remark, because through the different presentation, there is a very interesting idea concerning the interaction between international legal order, the regional legal order, and also domestic legal order. Maybe the example is the Constitution. And for me, if you look on the practice of the European Union, for example, the corporate social responsibility due diligence directive, you know that the European Union recognized the application, the extraterritorial application of this directive relating to the European enterprises across the world, for example, in Africa. But at the same time, when the European Union negotiates and concludes some trade agreements, for example, Cotonou agreements, you know that your colleague with the African states, they will use a standstill environmental approach. And also for the African states, it's the same thing. We negotiate some trade agreements across Africa, for example, FCFTA, Continental African Agreement, with very high level standards. But also, we negotiate at the same time with the third parties, some trade agreements with very low standards. And there is a discrepancy, I think, between international standards, environmental international standards, the regional, the environmental regional standards, and the domestic environmental domestic standards. Maybe there is something wrong if you try to make a systemic integration, as our colleague from India say. It's very difficult if you try to do that, but with using this perspective. I want to know what do you think about this question or this reflection?
I completely agree with you. One of the issues that we see, again, I will speak from where I'm most knowledgeable about, which is Africa. One of the issues that we have is not just the absence of laws, but also multiplicity of legal instruments. Where do you go to? Is it the ECOWAS court for Nigeria, for example? Is it the ECOWAS court? Is it the African court? Is it the African Commission? Or do you go to the UN and some of the regional bodies, some of the instruments that they have and the commissions that they've set up for these issues? Where do you go to? And that is why, and you have time to mention it, and that's why I'm advocating for constitutional recognition. Because when you look at the Constitution, in many countries, the Constitution is supreme. And so anything that does not conform to the Constitution will be struck down. So everything will have to, every bilateral agreement will have to go through constitutional vetting. Does it agree with the right to healthy environment, for example? One of the papers that I wrote for another conference was looking at trade agreements and the bilateral or some of the multilateral trade agreements that have environmental protections. And that's the way in which certain countries are circumventing environmental rights by inserting these clauses, environmental clauses, that will do away with certain environmental rights and certain environmental protections. And the EU has been fingered in some of these agreements. European countries have been fingered in some of these trade agreements. But the question is, where do we go to ultimately? And I agree with you on that note. For me, the solution, it's quite simple and maybe quite pedestrian in giving this simplistic solution that it's the Constitution. But I think that is a strong starting point because of what the Constitution signifies.
I have a question for Professor Koinu. I'm a student, I'm a 1L here at Richardson. And I was wondering if you could expand on, because it sounds like Sardinia has a lot in common with Hawaii. If you have a chance while you're here to go to the North Shore, you'll see windmills, and a lot of locals hate them. And a lot of the locals who hate them are also members of environmental groups and such, to the point where we like the concept of being energy independent, but we hate looking at what that would mean.
Yes.
So there's almost an environmental argument to keep burning Indonesian light sweet fruit. It seemed like that's sort of a conflict that's been coming in Sardinia a little bit. And I was wondering if you could kind of explain how you deal with it.
Yeah, sure. That's true. Thank you. I think we have very, a lot of things in common. We're both islands. We're both beautiful places where nature is still as they was. And in Sardinia, we are facing a lot the speculation. So the problem is a lot of multinational companies are coming to Sardinia in order to plant their renewable plants, because the weather condition is optimal. But in the European Union, the European Union set a standard goal to share between the member states, and Italy has its own sharing. And inside Italy, we share more between the regions. So Sardinia has a small part. It's not such a small part on average. It's a quite a medium to big part, and we can reach that goal without any massive speculation. So just using roofs or already degraded territory like mines, or no longer using mines, or harbor, ports, industrial sites. So that should be enough. But the European Union and the national government are making us to use the old territory. And we are very above the limit. We already are above the limit. So why can't they do that? So I understand you, and it's perfect. The problem is like that. So if we do not have any kind of control on where to plant the renewables, everything is going to mess. Because the only thing a region in Italy can do is just take care of its landscape. If anyone else is deciding about our landscape, it's a big problem. It's a big issue. And we have a very strong identity in Sardinia. And we really want to defend the land against the enemies coming from abroad. So that's the sensation. Sardinia has had a history of domination. Arabic people, African people, Spanish people, Italian from the Piedmont. So we still are very scared and afraid that something like that could happen again. That's the big problem. We do not want to renounce to our territory, to our autonomy, to the chance to choose where and if doing things.
Can I ask a question about Sardinian law?
Sure.
Or maybe a Hawaiian law? So I know excuse me if I missed this in your presentation, I know in the US, there are a lot of legal barriers to creating kind of microgrids and kind of really localized sharing. And so it facilitates that kind of, oh, it's got to be some massive entity coming in. Do you see the same, do you have the same kind of barriers locally there towards, there's individualized rooftop solar or wind or whatever, and putting something, but then there's also, allowing community sharing.
Yeah.
Are there barriers in there?
Kind of. I mean, you can decide to stop the major plantings, and only the major plants go under the authorization from the Sardinian. But there are 3 different steps of. The first is just free. So whoever can do whatever he wants, whenever, wherever he wants. The second goes through the local governments, like townships, which is a very, very simplified permitting procedure, and you cannot keep track of how many very small plants can establish in the same territory. Because in Sardinia, we have something about maybe, about 1,000 township. Okay, so at the border, very, very, very close, and you cannot take control, because if you are free to establish to make your plantation, the neighbor doesn't know anything about that. So at the very end, you can see a lot of turbines or a lot of solar panel, but it is already done. So it may be too late.
I'm on time for one more.
So my question, well, first of all, thank you for the presentation. My question is very elementary, like 5-year-old level question about environmental law. Very much from up in the clouds, but based on my experience, my very limited experience about information on environmental regulation and how things have progressed so far, I feel like, especially in the US, it's very, very hard, if not almost impossible now, with like the shutdowns that don't speed of the world, and for obvious other reasons, that regulation is not the most, I guess, viable option for environmental, to sustain the environment at this moment. But it seems like some incentives definitely did push towards the right direction. So an example might be the carbon credit that a lot of car manufacturers were given. Obviously, Tesla was able to make a lot of money off of those, and hopefully another type of worms, which is probably irrelevant to what we're talking about right now. But so I guess my question would be, in this stage, when the environment and environmental regulation is such a global issue, what would be a way to incentivize the actors in order to participate in pushing such agendas? Tax might be one, but it's just.
But they're kind of, I don't think you have an element. I think you have a very sophisticated understanding, but it sounds to me like you're asking a question about regulation versus economic incentives, like carbon markets and tax and cap and trade. And certainly those things are very, and I don't know if you're asking about the US, I think you're asking more generally. But obviously those mechanisms are still out there. In the US, I would say all of the major federally, the major environmental statutes were passed kind of about late 70s through the 90s, and then Congress just stopped. And that's why regulation through executive agencies has been so important. They have to work with the statutes that they have That's been shut down both by the current administration and court decisions. The states still have a lot of leeway to continue. There are existing regulations that aren't going to disappear on non-climate things. Some of them won't disappear, but the states have a cooperative role and local governments as well. And then what you're suggesting is, yeah, another way of doing this is through economic incentive, cap and trade, et cetera. Certainly think in the US, even economic incentives, because of the hostility, it's almost like a religion, I would say, in this current administration. Anything that smacks of trying to protect the environment seems to be the other team. Even that might, for the next few years, be difficult, but that's, I think, another really important mechanism generally. And I suppose folks can talk about in their respective jurisdictions. Let's see.
And maybe the biggest difference between the US and the EU is that in the EU, we are low driving. Here, it's more incentives. But I see that in January, the Trump administration released a sort of official document, a statement titled Ending the Green New Scam, January 2025. And it repealed 15 billions of incentives. So, I mean, incentives could be, but if you are repealing the incentives, incentives are not being more, cannot be longer than the solution. So it is here. I think that in the European Union we have a sort of mainstream right now that it is not sensitive to the political changing. Here it's completely different because I mean the pendulum just swung again back. So it depends. Incentives could be a strategy if you keep incentives. If you repeal incentives, no more strategy.
So, in my own opinion, when you talk about incentive versus the law, it's like the carrot and the stick approach. Which one is more effective? And within the context of economic interest on the one hand and environmental protection on the other hand, we may never come to a complete balance here. In many cases, the US, for example, economic interests may take precedence. And that is where, for me, I want the dictatorial approach of using the law to say, this is what the law is, and you're bound to follow the law. And we see the EU, as he mentioned earlier on, as being a region that is quite strict on using the law to compel actions rather than incentivizing them, using the softer approach to say, you conform to this, you want to know. You have to follow the law. And I think Africa is also another region that follows the legal approach well at the regional level to say, you just have to conform to the law, whether or not you like it. So we stick average.
I guess I'll jump in for the sake of completeness, but I don't think that you had in mind international criminal law or transitional justice when you asked about incentives. I'm pretty sure you didn't. But it humanizes the narrative on incentives from the abstraction of carbon credit in sovereign states down to individuals, military dictators accused of being complicit in crimes against the environment during, before the agreement was signed up until 2016. It offers them an opportunity to do something apart from rotting in prison, to take ownership, participate in community endeavors. Some of them have to do with the environment. So yeah, I guess it is an incentive. It's not really branded as such. And in economic terms, it's totally wrong to use the word incentives to mean this. But in the context of my presentation, and if I have to sort of complete the response, then that's, the alternative is to go through the mainstream process that the Colombian justice process also creates and go to a criminal tribunal that will award you a sentence, a conviction, and then carry that out. Would you prefer that, or by, making a full sort of reckoning of your role in the atrocities, can you kind of offset the narrative of criminality that's been written into your record for you? So yeah, I think that's kind of what I can offer. It's a pretty specious take on incentives, but that's the fun of conferences.
Okay, well, we've reached the end of the session, so we thank you all. I thank the panel.
If you went out of the courtyard and around the corner. So if you're here, obviously we'll go to you guys. But if you run off and don't know where we are, that's what we'll do. Anything else? Okay, so you want to go this?
Yeah, wonderful. Great. Couple minutes late, so we won't take much time. Part of the idea about the scholarly agenda of law and development is just how broad gauged it is. And one of the examples of being broad gauged is that I am moderating a panel about law and technology, and I know nothing about technology. So if we get right to our substance, we'll start with Professor Luciana.
All right. Aloha, everyone. Are you able to see the screen well?
Yeah.
Okay, perfect. My name is Catherine Osianen, and I'm really honored to present our paper, which I was co-authoring with my excellent colleagues, Eliana Martinez from Seton Hall University and with Benjamin Waper from MIT, that is titled Navigating the Quantum Frontier. And what I think, as you were saying, that maybe technology and especially quantum technologies, that might be on everybody's valley straight away, maybe it's first useful for me to summarize a little bit what is meant by quantum technologies. Well, what quantum technologies, what they do, they actually liberate the unusual rules of atoms and particles. So that means that you may have them existing at multiple states. You can have ones and zeros at the same time. And that is something that we call the superposition. Moreover, we can also find them being interconnected across vast distances, what we call entanglement. And these are the ones which create the new generation of devices, whether those be including, for instance, computers, sensors, communication systems, which have the capabilities far beyond of today's classical technology. But what I maybe should say in here is that when I discuss about quantum computers, they will not override the classical computer. So you will still have your laptops and your computers, but there might be certain tasks where we actually see that quantum computers, they can be better to run certain specific calculations, and that's why it brings some advantages. But as we know, quantum technologies, they are no longer scientific fiction. It's not only theoretical scientific fiction, but it's actually burgeoning the reality that promises to reshape our computation, our security, our ethics, and also our economy. But within this promise, we know there brings some rights, but there will be also some responsibilities. And what it does come, it also comes with a profound disruption. So today, what I want to do with you, I want to guide you through the emerging legal and developmental state challenges that we have to face right now. So our presentation today, it will focus on three critical pillars where the law and development intersects with quantum tech. The first one concerns the legal frameworks. So we will look here at how the intellectual property laws are currently ill-equipped for this era of quantum technologies, and why do we need to approach to innovation. Secondly, we will cover the security and ethics. And here, what we will do, we will discuss the existent threat that these pose on the encryption and also the dual-use character of these technologies. And how tools of science, how those tools can actually also become, for instance, tools of surveillance. Then we're going to go for global equity. So finally here, what we will do, we will address the risk of quantum divide. And this means the permanent gap between the quantum haves, but also the quantum haves not. And here, I will propose with my colleagues international governance solutions. So let's begin with our first major challenge. So how do we foster innovation without letting monopolies choke the industry in its cradle? So this is one of the really first major challenges as we have. And the unique characteristics, for instance, of the quantum algorithms, they are the ones which challenge our existing intellectual property rights laws and the regimes. And we can see currently that there is this kind of cold rush mentality right now in order to patent everything, whether that be from hardware to configuring the basic algorithms. So there is a rush for patenting everything that will be kept. And what we do argue in our paper is that this kind of overly strictly patenting early stage is really dangerous, because what it does is actually risk a premature consideration there, where there will be a few giant logs which will actually build the whole blocks of the industry. And this also includes and creates an innovative paradox. And what we mean by that is that in order to patent almost everything and trying to protect innovation through patents, what we actually might do, we not actually foster the innovation, but what happens is that we might actually kill the competitive dynamism in there, what is actually needed in order to support as well as advance the field of quantum technologies. So what we need in here is a legal solutions that can distinguish between the patentable hardware, the physical items that we have, those applications, and the algorithms that should remain open for scientific progress. So we have these two legal solutions that we need to be coping in here. And to solve this IP dilemma, we need to look on the economic policies. So our paper, in here we support the neo-Pardassian approach. So this is named after the Justice Louis Brandeis, and this school of thought, it kind of warns that if you have an excessive corporate concentration, what happens often is that it actually harms both the economic growth as well as democratic principles, as we know in our days. Well, and when we think about this within the quantum context, this means that we must also ensure that the benefits of this technology, they are not only captured solely by few wealthy states, usually the Western countries, or by few corporations only. So this is something that we have to pay close attention to. So what do? We emphasize here that the role of public funding. So governments, what happens is that they are currently footing the bill on the highest risks when it comes for the research. Therefore, the fruit of those research, which is really expensive, those fruit, they should also remain accessible to the greater public, the scientific community. And in here, what we want to do, we want to also at the same time ensure the diverse and competitive marketplace, rather than having a monopoly of wealthy nations or wealthy corporations who are ruling the area. It is also maybe important in this place to emphasize that public funding, it is already playing a crucial role in the quantum technology development compared to other recent innovations. Moving then to our second pillar. So this is about the profound security and the ethical implications of these technologies. So the advent of, I would say, fault-tolerant quantum computers, what happens is that it poses an existential threat to the content of digital security protocols. And this is perhaps the most urgent issue that we have to currently face. And quantum computers, well, they will eventually have the power, currently they do not, at least it's not public knowledge, that they could be able to break the encryption standards that we currently have, which virtually protect all our digital systems of today. That could be from bank transfers to, for instance, national state secrets. So all the information that we hope to be classified we have to take the measures now in case we hope those information to stay classified also within the future. Well, you might think that, oh, okay, well, quantum is far away in the future. These are the things that we don't need to be worried at this time. Well, that is a really dangerous fallacy because we are now facing the harvest now, the crop later threat. That means that adversaries, what happens, they can steal and encrypted data today, and they can simply store it until there will be enough functioning quantum computer that has the quantum power to actually unlock. So it's really imminent to act now. And what happens is that this necessitates the immediate global transition to the post-quantum cryptocurrency protocols. So instead of waiting and whether there's going to be this kind of computer, that would be a really dangerous fallacy, but rather we should act proactively. So we cannot kind of wait that when the hard drive comes in. The legal as well as the technical safeguards, those should be implemented now. And in this context, what happens is that we're not just proposing that licensing should be the way to go forward, that we should have a licensing regimes, but rather what we propose and encourage organizations to do is to handle their sensitive data proactively in a way that it would be ready when this kind of quantum computer, what is functioning enough, would be able to unlock the sensitive data that was supposed to be safeguarded for good. So beyond encryption, we also must grapple the idea of the dual-use nature of quantum tech. So quantum technologies, we can say that those inherently have the characteristics of being dual-use, meaning that civilization advancement, those can be easily repurposed, for instance, for military purposes or surveillance objectives. So recognizing that these technologies you can use for good, but you can also use those for evil. And the same quantum sensing, for instance, the same technology what allows doctor to imagine with a great precision, these can also be used, for instance, by the military in order to detect summarizes or, for instance, underground bunkers. So these are the things where you can use them for the dual purposes. And the same computing powers that, for instance, stimulate new life sensing drugs, this same power that can be also used, for instance, to break enemy communication in a warfare and a military warfare. And this, of course, creates a massive regulatory hassle, and complex, right? Because you have the dual nature of these technologies. But then the question arises, how do we regulate the technology to prevent this kind of a misuse and protect the civil liberties? Especially when it's discussing about safeguarding the surveillance without halting the scientific progress that benefits the humanity. So what we do, we argue that proactively legal consideration is needed in here within privacy networks and frameworks, and that is essential. To note, these dual use characteristics, this is not anything new. You probably recognize from the history that there is a clear parallel, for instance, with the nuclear technology, where you were able to use these technologies to progress the humankind, but at the same time, we know that they have a really significant military implications. Finally, we turn to the developmental challenge. So ensuring that this technological revolution doesn't leave the world behind. So unlike many, digital technologies of today, quantum capabilities, they depend highly on a specialized hardware, infrastructure that is a physical one. And that is something that often creates also, I would say, significant barriers to the entry. And that is something that also creates global challenges, because if you don't have that physical hardware, and if that is really difficult to build, you don't have that kind of access to a certain governance. So that also creates a lot of concerns. And in this slide, we are facing the imminent threat of the dual divide. And as you can see in here, the developmental nations and the tech giants, they are really pouring billions of dollars in R&D and monopolizing already the limited pool of people who are capable of working with these technologies. Whereas, meanwhile, when you look at the developing natures in here, they actually often lack even the physical infrastructure to having that kind of really well running and working delusion recreators, but also like lab environments, which would be helpful to have in order to want to compete. So you can already see here the quantum divide. And in case we decide to do nothing, the economic as well as the security benefits of quantum tech, they will concentrate only a few hands, whether that be the Western rich nations, few corporations, but what happens is at least we can be sure it will increasing already the global inequality. So what we have to do here, we must view the equitable access as not just something that is regarded as charity, but rather that is a requirement for a global stability. So what is the solution then? Well, what do we propose? We propose a robust international governance framework. And we success exploring, for instance, model like the United Nations of Sovereign States, what would be creating a binding international body that can actually set standards and oversee technology transfer. Practically, this means that we can bridge the hardware gap through, for instance, using a cloud. And by ensuring developing natures that they have the remote access to quantum processors hosted elsewhere, what we can do, we can actually democratize innovation without requiring every country to be building these multi-million labs and have an access to it. So ultimately, international collaboration, what it stands for, that is the only way that we can actually ensure that the quantum future is one of a shared prosperity one rather than a fragmented conflict. To conclude, in the rise of the quantum technologies, what they do, they actually really present a complex web of challenges, whether that would be from the courtroom to the battlefields. And in order to address them, that requires a proactive effort from all of us, whether that would be the legal scholars, policymakers, or scientists. And what we hope is that this presentation, that it has highlighted to you the urgent need of a robust ethical legal framework. Thank you for your time, and I'm of course available for any questions that you might have.
Professor Jones.
Thank you. So I'm a decidedly non-technological person, so it's going to contrast markedly with what you just saw, but hopefully it won't be held against me. So my name is Professor Randall K. Johnson. I'm a professor of law at the University of Missouri at Kansas City. Specialized in property law and local government law, but in a past life, I worked for the Congressional Research Service. I worked in foreign affairs, defense, and trade, worked on the World Bank project, grew up in a developing country called Chicago. So, I have a bit of experience in the developing context. So much of my theoretical and practical work, it looks at how individuals make decisions. Some of the work also extends those insights to look at how institutions in groups and institutions more broadly, what type of information they use to decide how they're going to proceed going forward. Specifically, my work usually focuses upon statistics and behavioral law and economics, which is a study of how people respond to incentives within different types of circumstances. One focus of my work has looked at the domestic US market with respect to policy ideas. Other work has looked more broadly. I have a paper that I did maybe 2 years ago with a group of scholars in India where they looked at how to deal with bankruptcy and the structure of bankruptcy options, whether it has an impact upon those that are involved in that system, creditors and debtors. And so one of the most pressing issues that I've seen in my studies of behavioral law and economics is the issue of whether and how to nudge people into making better quality decisions. So nudges is a term that was popularized by University of Chicago, then University of Chicago scholars, Richard Thaler and Cass Sunstein. And these are ways of changing how people respond merely by determining if you're going to collect and present information in specific ways. And now, unfortunately, nudges are too rarely applied to governments, although these institutions could definitely benefit from improved decision-making. So within this context, the question of whether and how to improve governmental decision-making is an issue that calls out for greater examination. So this presentation, it does some of this work by describing how one local government, the local government where I teach, Kansas City, Missouri, how it can be nudged into making better decisions with respect to legally complying with public records requests. Specifically, this presentation builds on a recent article, Why U.S. Cities Should Comply with Public Records Requests, which will be forthcoming in 2026. And both this presentation and the article that it draws upon, what it uses is the latest publicly available data to find out whether this local jurisdiction should revisit its decision to systematically withhold public information without any adequate legal justification. And this is especially important because Casey Mo's decision to violate state law is not cost justified with respect to how it interacts with others for a number of reasons. One such reason is that it provides what some would refer to as perverse incentives, incentives that encourage people to engage in activities that are not socially beneficial. Secondly, it imposes losses potentially upon the most vulnerable groups, low-income people in particular, but also people who belong to certain socially unpopular groups, such as Black Americans. And lastly, I think, and this is one of the most important things, it provides additional reasons for people to misunderstand their relationship to government. In the US legal system, the people are the owners of government, not public employees. And as a result, people should have liberal access to the basic information that tells us if government is doing what it says it's doing. So within this context, today's presentation is going to proceed in 3 parts. It begins with a brief introduction to the Missouri Sunshine Law, which is a state level version of the Freedom of Information Act. This law was passed in 1973, and what it does is it just gives people the opportunity to figure out what a local or state government is doing on a daily basis. Next, I'm going to summarize my paper and its key findings. And lastly, I'm going to explain how a reevaluation of Kansas City's policies could help this U.S. city to make more informed policy decisions. So to wit, the Missouri Sunshine Act is a state statute that guarantees access to certain unprivileged information that's generated by local governments in the normal course of their work. Examples include records, meetings, notes, emails, other types of information that let us know what state employees are up to. And it's commonly assumed that any failure to turn over public information in a timely manner will result in some type of sanctions, such as money damages, declaratory judgments, and or injunctive relief. So recent news stories, however, throw this theory into doubt. Specifically, U.S. cities such as Kansas City openly admit to withholding public information without fear of regulators imposing sanctions on it. So in other words, Kansas City and other scofflaws often don't feel the need to fully comply with the law due to a less than optimal incentive structure. So for this reason, among others, my presentation asks and answers one basic research question. What is the economic cost of Kansas City refusing to comply with state law? And in carrying out this work, I use simple arithmetic to figure out the minimum economic cost of non-compliance, and I do so for 3 basic reasons. So first, arithmetic provides an easy way to compute the minimum cost of this type of policy, and it does so by multiplying the number of violations. Kansas City is admitted to engage in this behavior 4,500 times in 2025. And if you multiply it by the minimum cost of holding them to account, which is $160 for pilot fees, that ends up being $720,000 just in 2025. And that's only the minimum cost. Second, such an approach allows for a potential determination of the distribution of such losses. Is it going to be individuals that have to file lawsuits, or also are we going to figure out whether there's going to be, let's say that differently, out of the population of people that have to sue this local government? Is it going to be more individuals or more businesses? What's the relative distribution? Should it be 50-50 or something else? But this provides certain basic information that we can easily make decisions for. And lastly, the use of this back of the envelope approach aligns with the recent push in the U.S. legal academy more broadly to generate scholarship that can be easily replicated by third-party researchers. So in sum, by using arithmetic, I'm able to find that information is collected in the normal course of business can be used to confirm or to deny the cost effectiveness of one particular policy. And it turns out that Casey Mills, Kansas City's non-compliance with the Sunshine Law also could be unjustified on other bases. within a context of economics, we could say that there's a negative return on investment to taxpayers. We could say alternately, that there's some kind of inverse cost of benefit ratio. Or thirdly, that, and this is in just basic legal terms, the failure to treat people in a relatively standard way runs afoul of the 14th Amendment, and that cannot be justified under the U.S. federal constitution, state constitutions, as well as local law. As such, today's presentation concludes that KCMO, Kansas City, should reevaluate its approach to public records requests so as to better comply with the state law and to avoid these unnecessary costs. And such a conclusion aligns with new research on economic efficiency and distributional equity, some of which I've undertaken, which supports the view that far too many governments don't live up to their promise. In what remains of my time, I want to explain a little bit about how Kansas City could move away from its current unlawful approach to public records requests to do something that's more in alignment with what the Sunshine Law requires. Kansas City could do so despite its statements against interest and, generally speaking, its aversion to doing what they're required to do, merely by focusing upon some of the things that they need to do well. Kansas City supposedly has a very good relationship with its business community, and that relationship could lead the city to adopt more cost-effective approaches and provide a better return on investment for more citizens than merely businesses. And so this raises a certain question: why does Kansas City continue to make use of a less than optimal approach? We're going to reframe this question in a basic research question. Why does Kansas City refuse to change course despite having ample evidence of its findings? The short answer is that Kansas City refuses to recognize there may be good reasons to move away from its initial position, which is a bit of a self-serving one, and toward a more informal one. And as a result, I want to leave some time to be able to open the floor to questions so that people can ask some of the ways so people could maybe think about some of the ways that such an approach could apply in other contexts, outside of the US context, potentially in developmental instances in which people are starting governments. So should I open it up, or how?
You have 6 minutes.
Awesome.
You can do whatever is, it's up
I
to
think I'm
you.
the first person to actually finish under time.
Okay. Okay.
So one thing I want to open up is this: since this is a law and development context, has anyone been involved with public records requests in their own home country or in other contexts? And what was the context in which that happened? There was 2 different hands that went up. You go first.
I was taking a break from academia. I worked for a district council for 2 years, and I was the person who managed all the official information requests. So we have a different statute for government and for local government in New Zealand. For central government, it's called the Official Information Act, but for the local ones, like I was in, we call it the Local Government Official Information and Meetings Act, the appointment. So I would receive requests, then I would find the information, redact information, withhold what people wanted to withhold, release it, and then deal with complaints to the ombudsman. So everybody has a right to complain to the Office of the Ombudsman if they don't like what they got. So I have to deal with complaints as well.
So please, sir.
No, I'm just giving you 5 minutes.
So within that context, was there any litigation that arose as a result of decisions that?
No, there was no litigation. The only form of litigation is a complaint to the Office of the Ombudsman, which really all he can do is look into it, and it takes months and months to do that. And then he can make a recommendation that the information be released. We don't really do litigation. We're not as litigious as the US.
No, but you raise an interesting point. I'm from Illinois, from Chicago, Illinois, and we take a markedly different approach. So in Missouri, where I work, there is an option to complain. You complain to the Attorney General. The Attorney General may take action on your behalf. They can reach out to local government. They can make a finding that they violated the statute. They can file a lawsuit. Illinois, we don't do that. We have a separate office within the Attorney General's office that can adjudicate disputes. And so it's kind of a midpoint. Now, the paper that I actually wrote, it actually builds quite a bit on some of the things that were made in that introductory lecture that was given by our colleague. It looks at the implications of Chevron being knocked down and the possibility of increased litigation around these types of matters. And if the increased possibility of litigation could lead to better decision-making by local governments, merely because they'll be put on notice by the fact there's a lawsuit filed and the possibility it can become more unpopular. So that seems to indicate there could be at least 3 possible options that could be adopted in developmental contexts and possibly you could do a cost benefit analysis and see which one works the best for your particular situation. You want to make a comment, sir?
Oh, you just asked about public trusts.
And did you have any, you said you had experiences with it? And what were your insights into that experience?
That it doesn't, this is here in Honolulu, State Uniform Information Practices Act. We can provide access, public doesn't have a right to access public documents.
And did the local government largely comply?
That was filed to the city and they took months to reply. They also species and lost requests and eventually they turned over to very small fraction of things that they knew they had. Even like where they had emails, they reference attachments and attachments were disclosed with an entire server drive. And, so it was basically an exercise of frustration. Hawaii does allow attorney's fees to be filed a lawsuit and do not consent. But in this case, not so. We'll get back, that's probably another way. So that's the point. So
very good. Okay. So I guess one way to bring this to a close is that one of the reasons why this might be a topic that's useful to both examine and potentially discuss is to think about other applications. Are there circumstances in which governments can be put to the test in order to determine if they're actually living up to their promise? One possibility in developing context and also in more developed context is that governments actually don't do what they're supposed to do. And one potential option for holding them better to account is to use less complex approaches, less high-tech approaches that are things as simple as figuring out whether it's cost-effective to engage in certain behavior. Make that information available to the government, and then bring it before the people to see how they respond. Thank you guys for your time.
Okay, from Kansas City to Hangzhou, we'll Ms. Hay and Professor Lowe.
Afternoon, I'm Wayne Low, and my co-author is Ishin He. We are from Bond University, Australia. We would like to first thank Professor Lee and Professor Chen and the Richardson School of Law for inviting us to present a paper at this conference. So our topic is Law and Development in Smart City, a case study of Hangzhou's regulatory model and its international impact. So in this 15 minutes, I will first provide you with a contextual background and then use it to highlight Hangzhou's experience from you, and at the end, I will draw conclusions. So as you know, sorry, some technical problem. Okay, so there's an upward trend of urbanization. So urbanization can generate both benefits and drawbacks in various domains in society. For example, transportation, housing, accommodation, education, energy consumption, and so forth. In this case, urban planning and sustained development are essential for the quality of life of residents and also for the equitable distribution of resources among generations. Okay, so in the Rio Declaration, sustainability run is not defined, but it is guiding principle. And according to Goal 11 of the Agenda for Sustainable Development, the aim is to make cities and human settlements inclusive, safe, resilient, and sustainable. So urban sustainability is defined in various ways, depending on your own perspectives. So a very brief explanation, urban sustainability is a city's ability to operate across economic, environmental, and social domains successfully at the same time. Now, with the advancement of digital and information and communication technologies, the concept of smart city has emerged as feasible strategy for urban governance. Also depend on your perspective, smart city have defined in various ways, and this is the OECD definition. Initiative or projects that effectively leverage digitization to boost citizens' well-being and deliver more efficient, sustainable, and inclusive urban services and environment as part of a collaborative multi-stakeholder process. So the basic element of smart cities consists of digitization, multi-party collaboration, enhanced citizen well-being, efficient and inclusive urban services, and sustainable development. So first, we have the question. We have the understanding is that urbanization will generate both benefits and drawbacks. And the next, smart city are feasible strategy for urban governance. And sustainable development goal 11 largely aligns with those of smart city. And the success of smart cities can foster urban sustainable development. So our research question is, what role does law play in facilitating the construction of a smart city and the resolution of issues arising from the operation of a smart city? So I'm going to turn the time to Yuseng to highlight some experience of Hangzhou.
So thank you, Mai, and let us turn to Hangzhou Smart City Initiative. It's also called the City Brand Project. So in this research, we chose Hangzhou as the case study because Hangzhou is the capital of Zhejiang province in China. So it has the population of over 12 million. So a lot of common issues we can observe in an overcrowded city, we can observe here. Another reason why we chose Hangzhou is because this city brand project received international recognition for its leading position in the smart governance. So in this timeline, we summarize the development of Hangzhou City Brand Project. Actually, in 2012, Hangzhou was selected as the national pilot city for smart governance. But the whole story about the smart city thing didn't really happen until 2016. So in this year, in order to deal with the severe traffic congestion situation, the Hangzhou government started collaboration with the Alibaba, which is a local giant tech in China. And they jointly launched the so-called version 1 of the City Brand Project. So throughout this project, the traffic time was successfully reduced by 15.3%, which provides strong empirical justification for the further scaling up of the smart governance in the city. So from this point onward, the smart governance in Hangzhou experienced two major phases. In the next two slides, I'm going to show you some of the technological highlights that defines the two phases. So here in 2019, the city launched the version 2 of the city brand, featuring the introduction of the city brand digital cockpit, which is actually a central dashboard that brings together data from multiple departments. And later in that year, in December, the unified data management platform was also introduced to coordinate operation across different services, which actually combines 11 essential infrastructure services in the city. And early this year, in 2015, Hangzhou announced actually the version 3 of the city brand. And in this stage, they focus on wide use of virtual agents, such as Ibar, as I indicated here, where you can actually ask the virtual agent as to what you should do and how you should approach different apartments to deal with your administrative matters. And also, the increased use of drones is another major changes in this space. So in the video I'm going to show you here, it's a good example of demonstrating how the drones are used in Hangzhou as a way to deal with the traffic accidents with substantially less amount of time. So here is a brief transcript of what has been said in this video. So it is not that complete, but it does provide a general understanding here. Yeah, amazing, isn't it? So in addition to the technology advancement, the City Brand project is also governed by two major regulations. So the first one is called the Smart Economy Regulation. The actual name is too long for me to pronounce it. So in this regulation, it puts smart economy as the central concept underneath the smart development in the city. And the second regulation is called the Urban Governance Regulations, which actually provides further details on how the City Brand project should be developed in the city. So jointly, those two regulations has guided the construction of the city brand in Hangzhou in four aspects. So the first, they emphasize on the allocation of responsibility by upholding the principle of who provides the data should be responsible for the data provided. And secondly, they enhance the data transparency by encouraging open access data and the data protection rules. And third, they attempt to create economic values during the construction of the city brand by encouraging contract signing and providing enough dispute resolution channels. And finally, also the most importantly, they're trying to enhance the governance efficiency by encouraging the concept of the one-stop rules, which means all the public sector services that need to be done by the citizens shall and must be completed in one place only. So, of course, the whole story about the smart city is not entirely celebratory. In this slide, we have summarized 5 major legal challenges that are currently faced by city brand in Hangzhou. So apart from cybersecurity, which is the only issue that is mainly left for the techniques to deal with that. So the risk for the accountability, public distrust, privacy issues, and inequality is regulated by regulations and other policy moves. So in order to deal with privacy protections, the urban governance regulations requires that the discretionary data practice have to be legally binding. But in addition to this, the Hangzhou government introduced 2 major implementation opinions. One to demand a unified security standard to promote the consistency in enforcement, and another one is to encourage the development of a data element market. And apart from that, the notice issued early this year sets quantifiable infrastructure goals to make sure that the smart governance is technologically capable. And in order to promote algorithm transparency, the urban governance regulations introduce this called scenario access, evaluation, and exit mechanisms to ensure every smart applications will be assessed before their deployment. And here, in the 14th five-year development, they standardize the algorithm used in urban management to expose and trying to set up the certainty in the algorithm used in the smart governance. And in 2024, we have 2 independent organizations being established to expose the algorithm process to external stakeholder scrutiny. And in order to promote inter-department coordination, the urban governance regulations encourage pre-agreed contract to ask the parties involved to share the responsibility and the interest. And also, there are 3 notices being issued by the Hangzhou government. By providing political endorsements, they do encourage any organizations, government departments, corporations to share data with others. And in order to increase citizen participation, Hangzhou's approach is a little bit different. So on one hand, they disclose their legislative development to the public for comments. And on the other hand, they also take this a little bit like bottom-up approach by allowing citizens to actively engage with the smart governance. So this 24-hour AI grid assistant is one example in point I'm going to share with you. So this is the interface you're going to see here. So on the left-hand side, those are the problems you can normally see in the street when you encounter and something you want the government to address, but they haven't done so. So whenever you walk on the street, you want to report it, you can click on the report now, and all those information will be immediately transmitted to the government. And on the left-hand side, here you can see someone is trying to ask the AI agencies where I have this water leakage issue, what should I do and who should I speak to? And you can see the AI agents basically provide them an immediate and step-by-step guidance saying how this issue should be addressed and who to speak to and what this person needs to do. More importantly, this residents can actually do have this feel of engagement in the smart governance. And also the guide itself serves as a very important indication as to who will be responsible for the issue alert. So likewise, in order to deal with digital exclusiveness, the Hangzhou's approach, instead of slowing down the innovation, it actually encourages further innovation and increase the subsidies to make sure that innovation will be beneficial to the local citizens. So we can see the development of Hangzhou's smart city program is kind of like heavily relied on the significant roles played by the law and the technology. So what does that mean for other jurisdictions? And I'll leave it to my colleague Vi to continue this topic.
That will be quick. Okay. So smart city initiatives can be top down or bottom up, but the main component is citizens engagement. And in Hangzhou, the basic principle is having people as the basis and people's livelihood as the priority. This is the guiding principle. And in the case of Hangzhou, it is a top-down approach, but centered on the well-being of its residents. So based on the Hangzhou model, you can see four major components for its success. First, there is a balance between innovation and regulation by establishing a predictable legal framework. Second, people-oriented policies. Third, there is mature electrical infrastructure. And fourth is public and private collaboration. So these are the four major components of its success. So this model is replicable. It is not just because something unique in the Hangzhou situation, but the four major components, I think, can be transferable. Legal framework, balancing innovation and regulation, people-oriented policies, investment in technological infrastructure, and public-private partnership. I can skip that. Okay. There'll be one more.
You're okay. You got another minute.
Oh, really?
You got
Okay.
another minute.
So that should be one more slide. That's it. Okay. So in conclusion, we think there's a logical connection between urbanization, sustainable development, and law. Now, if sustainable development is the ends, smart city is the means. And if smart city is the end, then Lord, a established people framework is the means to achieve in its order development. Urbanization and smart city both can be double-edged swords. That means you have both benefits and also drawbacks. So our conclusion is that law can play a crucial role in facilitating the construction of smart city by creating beneficial impact and by eliminating adverse impacts. Thank you.
Hey, David.
I'm David Lee from Kent University in the Union, New Jersey.
I'm an assistant professor of business law, so I teach in business law. So today I'm going to discuss my recent research, which is about how to make digital trade, digital market, digital trade sustainable. So this is the research I developed as an extension of my former research in antitrust, which was for digital sustainability. That paper is currently being under review. In that paper, I proposed two functions which are dynamic efficiency function and dynamic and sustainable dynamic efficiency functions, which do complement the long-term consumer welfare standard being still traditional in this era. So today I'm going to discuss how to map this antitrust insight onto trade law, so we can think about how to innovate the new version of the trade law. Again, the fundamental question I posed in this paper is how should law govern the codes being widely used to the govern and activate the trade law and digital market, so cross-border digital trade stay open, contestable, and sustainable. So in this paper, I argue for co-regulatory interface between trade law and antitrust law. So rather than having each of this field in silos, but having these two intersecting together to establish more broad an overarching framework. Throughout this paper, again, my core idea is establish a certain rules, certain tool, which is compliance by design tools that makes openness verifiable rather than aspirational. Again, I argue competition is not merely about the price; it's about how we can offer equity for the public and even those market participants, so they can think about how to provide and interact with incentives to innovate. So this is my underlying notion, but there's a paradox, which is platform power growth over time, but that represents still the largest concentration of infrastructural control since industrial era, and particularly in this age. So we need to think about now how to incentivize innovation and what are impeding those incentives to innovate. So that way that we can think about a new way of dealing with trade law. The one conceptual the ground for this work is digital sustainability. I do coin this term from a little bit newer perspective. We know the sustainability, which is not a relatively new term, but digital sustainability, I believe it becomes a new term and new standard these days. So how we can deal with the trade law and digital market from digital sustainability perspective. And then 200 years ago, there was well-known German philosopher who was an author in Schopenhauer. He wrote on the masterpiece, which is entitled "The World as Will and Representation." So I borrow his metaphors to build analogy to support my idea. The code as will, and the Lord as representation. So I believe the code will be serving as a pivoting role to activate digital platform and digital market. And then behind the curtain, there's the law, which is again a combination of trade law and antitrust law, which are governing those dynamics. So in my work, I propose trade law should provide the baselines, while the competition law and the antitrust law provide a complement. So the trade law will be again the lightweight approach that we should take first, because the sovereign state will do again the govern dynamics between the sovereign states in dealing with again specific market participants, and then the for specific fine tuning and microscopic massaging of those anti-competitive business activities being seen in digital market. We need to think about competition law to complement. So the law of digital gatekeeping. So yeah, platforms act as sovereigns, access, identity, discoverability, monetization, so all set contractual via application platform interfaces and the ranking systems and neutral seeming architecture platform can entrench incumbent or raise rivals cost. So these the champion the reason why we do again carry give more weight on the role of antitrust in complementation to the how trade work. So blockchain. So again, when I argue the co-regulatory framework, which embeds both antitrust law and trade law, I see the code as will be again empowered by the blockchain. Of course, we do have an algorithmic database or algorithmic discrimination, but again, long story short, the blockchain will be serving as a regulatory platform. So the compliance by design will be the golden ledge term, because the market participant will do will be self incentivized to comply with those code, those the will again which will drive this from the platform. Of course there are certainly expectations of roles of regulators and those member countries broad perspective, but their roles are not again fine tuning those systematic management. They are again overseeing and managing the system and market. So again, market participant, particularly the platforms which EU's Digital Market Act the frame as the gatekeepers, and they will do receive this incentives to comply with it. So that is the golden ledge. And the three primitives are decisive. Again, this is the based on my former discussion. So the modularities. There certainly be the core basic rules and the standards we cannot really tamper with. And also there are some types of rules we can do add or modify depending on the situation in the market, the sectors. So we need to think about how to again balance and separate these two different types of layers. And then interoperability, which is the hot issue currently. Interoperability and data and portability that will be the next one, and auditable and openness. Again, how to maintain the valid the auditing system. It depends on again how regulators will do again govern the system. So these are the three primitives that are decisive in regulating digital market and digital trade. So rule complementarity. So I see the future of dealing with two types of the digital market in the next years coming quite positively, which means they can do the complement rather than we see any rule primacy between trade law versus antitrust law. So both law can do complement in a positive way to, again, establish an overarching framework. But again, these are not based on, the digital sustainability, because again, currently we don't have, we don't necessarily expect, price. Now, everyone just use Instagram and Facebook, but you don't necessarily pay for that. You pay, in forms of your personal information and how many times you view in a certain content. Okay, so but that are still, as some scholars argue, quantifiable, but I don't think there are not. I don't think that are completely quantifiable. So we need to think about, how to again, deal with this new form of competition, non-price competition, for example. Non-price competition does come with, again, the need of, again, bringing this new framework. So interface norm for rule complementarity. In this part, I propose three things. The sequencing rules. Again, the trailer comes first, and anchor trailer does complement as a backup, and then a burden shifting presumption. Because the platform controls the bottleneck interface. Sometimes they restrict the consumers from doing kind of multi-homing. So they require again the market participant, particularly consumers, to rely on their own interface API. So that means we need to think about how to balance this the burden of proof. So my idea is we give kind of basic burden of proof, basic burden onto the platforms, and then we give them a chance to revote. So that's my idea. And then safe harbor for an honorable openness, because equity and openness are increasingly again defining the fields in the states. So we need to think about how to make that auditable, verifiable. So platforms can do benefit from these three norms. So my last introduction is who does what. So again, we think about three different types of the market participant in a broad sense. The market, again, the member, the sovereign state, and then the market participant, and particularly the platforms, the operating that of the platforms, and then independent, third-party regulators. So they have their own roles. I envision in this paper. So the platform operators, of course, do very specific job to again manage their platforms a special way. So they can do they keep audit ready logs and uptime and latency and the ranking input and classes, all these kind of the tools and the systems they use verifiable and manageable. And then member state again the govern at the highest level. So they make sure this platform operators, the gatekeepers do do their job well, and that independent regulator, particularly the competition authority, to the step in to enroll when they see any exclusive or exclusionary or anti-competitive activities. So these are everything I have today. I'm really open to any question or comment. Thank you very much.
I hope you guys don't get confused about this previous paper and the next paper, because the previous paper was called Sustainable Digital Trade. And this one is called Sustainable Development Digital Trade Agreements in the Digital Economy. But they're two different papers with two different people. So here's
So good afternoon, everybody. I hope we're not too tired and not too jet lagged. So I will try, not to be too boring. But as was rightly noted, the presentation before mine kind of sounds like, but I confess, I didn't read your paper, and I didn't steal any ideas off of him. They sound very, very similar, but I'll talk about it. Yeah. But they're very two different papers. So my name is Kende Olaoye, and I traveled from Qatar. So it took me quite some time. So please pardon me because I should be fast asleep, but I will try. So my presentation will focus on sustainability and digital trade agreements. And the work that I do, or the discussion that I'm having in the next few minutes, sort of relates to a trend which I observed in the context of research that I'm part of in Qatar. And as many of us in the room know, digital trade agreements has sort of become a new thing. Every few months there's a new digital trade agreement, and the question I was asking myself is, okay, so how does this relate to old ideas of development, protecting the environment, and other issues? So in my presentation today, I'll focus on some of the linkages between the digital economy and the sustainability. And the background for this is sort of the shift away from national development plans to digital economic plans. And then, of course, the new trilateral trade agreements and how this relates to the new international economic order that we find ourselves in. So as I already mentioned, we've had a rise in digital trade agreements. I don't have the numbers. Some of us in the room may have the numbers, but I don't. But these are a few recent examples. So we have the Digital Trade Protocol of African Continental Trade Area 2021 and its protocols, which came into force in 2025. And then more recently, we have the European Free Trade Association States and Singapore Digital Economy Agreement. And then more recently, also more recently, we have the ASEAN Digital Economy Framework Agreement. So how does this relate to things that are happening? So if you had some patience to read the paper that I have submitted, sort of try to establish the fact that we've had sort of this resistance from host communities. And there's a lot of news about data centers, protests, and the energy consumption by data centers. And these are some images which sort of capture some of the developments that are taking place. I find it interesting that these cases exist. But of course, these cases sort of exist in a very, very different context. But there's signs that there's trouble brewing. And of course, international law is always the last place where you can think of having any form of justice. So if you read the paper, you will see many examples. So very, very traditionally, when we think of the digital economy, this is sort of a very good framework for looking at the legal issues. So we have the market access component, and then we have the regulatory component, which is more related to some of the environmental and sustainability issues. So issues related to data protection, spam control, data localization, which is a big topic, protection of legitimate public policy interests, and of course, cybersecurity. Of course, there are more other issues, but these are some of the issues that we think of. So like I said earlier on, we've sort of seen that there's an input or a rise in strategies. Of course, these are soft strategies. And I sort of feel we're in, it's a new period in history where we're moving away from development plans, economic development plans that were first developed in the 1960s and the 1950s. So for example, we have the digital economy of Sri Lanka, and of course, this is also leading to new changes. So we have new departments, ministers for digital economy, and it's going on at the domestic level. So the question that I then ask myself is, how do we all tie all of this together? We have several layers of government. So at the domestic level, we have these soft policies and strategies. At the international level, we have regional trade agreements. How do we reconcile these two overlapping and sometimes not overlapping forms of governance? So the main argument I make is very, very simplistic, is that securitization of trade law and economic security and geoeconomics is sort of hindering the inclusion of sustainability provisions in digital trade agreements. And I have some preliminary support for this. So in the next few minutes, I'll just highlight a few provisions from some recent agreements. So this is the EU-Korea Digital Trade Agreement 2025. So as we see, this is the preamble. There's express reference to sustainable development, green and digital transformation. And of course, we see, the fact that it's important to ensure that the relationship is in accordance with the objectives of sustainable development, economic, social, and environmental dimensions. So very, very specific, very laudable. But as we all know, this is very, very aspirational and has very, very limited effects in practice. We also have the African Continental Free Trade Area Digital Protocol, which is considered one of the most green-friendly digital trade agreements. So this is from Article 2, and there's of course express reference here to sustainable and inclusive social economic development. Article 4 recognizes the right to regulate. And then the more recent digital protocol, which is, an annex to the digital protocol. So Article 22 refers to data for development, which is sort of a new development, which is laudable, but of course a regional agreement, so it has limited, but it's a key. But then it says taking into account the importance of data development, the parties shall facilitate innovative ways to promote public interest by sharing or using data. And then let me take you to support data capabilities to take advantage of data-related technologies, promote research, development, and innovation. So extremely laudable, of course, but very, very little reference to protection of the environment. And then these are the other annexes. And then this is from the Agreement on Climate Change, Trade, and Sustainability. So here, this is another recent agreement, but it recognizes in the protocol the possibility of some exceptions. So at this stage, it's very, very pretty obvious. But we have new types of agreements. So I'm going to highlight two new types of agreements. The first agreement is framework agreements that are signed between China and selected African countries. So here, for example, we have a framework agreement on economic partnership for shared development between the government of China and the government of the Republic of Liberia, which was signed in September 2024. And under this agreement, which is not a real agreement, it's a soft, very, very, aspirational. But what China does basically is that it has what is called the model for more modernized sectors of development. And basically, the parties can facilitate digital trade in the fields of e-commerce so as to assist Liberia to narrow the digital gap and improve the level of digital development. So that's China. On the other hand, we can then contrast with the US. So we have the agreement signed between Cambodia and the US in October 2025, which has paragraphs on digital trade. But specifically, Article 3, sub 3 says Cambodia shall consult with the US before entering into new trade agreements with another country that jeopardizes the essential US interests. So, basically preventing Cambodia from signing any agreements, new trade agreements that are contrary to the interests of the US. So I've tried to be really, really brief. I hope you have some time to read the paper. Of course, work has also been done by scholars in the room, on this topic. So, not entirely new. I'm also standing on the shoulders of other scholars. But the thing is, how do states deal with these issues? The world has changed. Things are extremely different. Negotiation is different. So maybe we should be looking at other things or looking at other forms of lawmaking, domestic law, contracts, outside international law. But at the same time, there's still space, of course, for drafting new agreements which take into consideration protection of the environment and ensuring that development is a priority. Digital development is a priority, but also ensuring that the environment is protected and that the sustainability of states is, protected under international law. So it's still work in progress, but I look forward to discussing with anybody about these topics. Thank you.
Okay, so we have about 20 minutes, at least on the schedule that I've got now for Q&A. So
40 minutes.
What?
40.
Oh, yeah, but he was not clear in the it was not clear in the description. One of them said that the coffee break is at 3:30, then said this was supposed to end at 3:10, which meant that we should spend 20 minutes in a state of suspended animation. So we can try that, but that does give us a chance to do some good Q&A on this. So before, I've got lots of things, but I want to know who the questions that we have here for people on the panel. Oh, sure, go ahead.
Hello, everyone. Thank you for an amazing presentation. I actually have like 3 different questions for you, 3 different presenters, but I'll do one now, and then if we have more time.
Okay, yeah, do one now, and we'll circle back. It's not such a huge audience that we can't be a little bit more informal. So, go ahead.
So first, I wanted to ask about the climate. Just had a question about presentation. I thought it was really
Me? Oh, okay.
Yes.
Hi.
I have something for you too. So it was really interesting how you talked about the innovative paradox, and then how early patenting can be dangerous because it can kind of deter innovation in a way. And I think I read something very similar about like pharmaceuticals as well, like early patenting pharmaceuticals is kind of like a double-edged sword for both pharmaceutical companies, but also the medical field, because they don't want to plant the flag too early. But at the same time, they don't want to, like the society doesn't want them to plant it too early either, because that might stop everyone else from developing. But if they don't do it too early, then they're going to keep it secret, which will all the, like, it's not something down that line. But so I just wanted to say, like, so who actually takes the lead on developing these things? And that kind of made me think about the internet. And I was born into the world of internet, so I don't know how life was.
What was the world like back in the dark times?
It's surprising. Like, I ask my dad that all the time. Like, how to be mom. So, like, I think the internet, based on what I learned or read, it was kind of a governmental project, because it was such a huge project to scale, but also it was so uncharted and unpredictable of how it will actually pan out. And it was actually a good thing that the governments did, because they were able to set the right infrastructures, and also that kind of led to like broadband that we right now and everything. So would it be like, in your opinion, would it be a good idea for governments to maybe take the lead on these developments? I mean, obviously there's the market factor, with government stepping into these kind of infrastructures, they do have a lot of backlash, but at least to ensure that it goes down the right path. Because if we imagine like the internet, if that was held by a few companies, then our lives would be very different. And maybe I'd have to suffer some of the things that my dad did when he was my age. To know how you thought.
Well, you have many excellent questions in there. Well, maybe I could comment first about internet. So in the beginning, nobody was expecting it to be a success. It was supposed to be like a tiny little circle bubble who was about to enjoy the fruits of it, right? But what it turned out to be something enormous, right? As we know. What I would maybe draw your attention here to is that the approach to quantum technologies is quite different, for instance, already when we are comparing the transatlantic scopes. Let's say that, especially in Europe, many of the quantum innovations, they have taken place at the university labs. So that is the place where all the magic and secrets happen. And if they're successful, you might have these spin-offs that take place and they become commercial players. So when we have these innovations taking place in Europe, it's mostly often funded by public money.
So then you also have a different incentives of how you will use the fruits of those innovations. So that means often that you have a different moral standing in there because you have been using the taxpayers' money. So the intention there is that you hope that these innovations would be beneficial for the society at large. So that I put it really black and white. So of course, just to make my point. Whereas when we think about how these been funded, for instance, within US, we see the big commercial players who put a lot of money in, and those are companies. And when we think about companies, they usually have quite different incentives than governments, at least often they do. And they probably don't have the same, may I say, ethical boundaries that hopefully governments do have. So sometimes you can actually sell your products for somebody who just pays the most. Whereas a government, you have to take different actors into account as well. So answering your questions, whether governments should be taking the lead, I think probably not. It's actually us within the universities who are working with the taxpayers' money, hopefully make the best out of it. Governments, I'm not always sure who is the government. That would be probably my next follow-up question for you. Who is government? But if I go back for the philosophy of law and thinking that we make the nation as it stands. We in the universities innovate. So I think that would probably be my kind of like a concluding note to say that we are actually the ones who are responsible. And hopefully we can be the ones who, whether it would be the legal scholars, scientists, to make sure that we're going to go on the right path. But just being said, the approach is really different in the both sides of the Atlantic. And incentives, for instance, who is the leading country? I've always been asked, like, who leads this quantum race? At the best, we can only guess. And why is that? Is that because there are no right incentives to reveal what is your current state of development. Because let's say that if you have a fully functioning quantum computer, that would be the kind of the same thing that if you could read somebody's minds, would you tell them? Probably not. You would have fun just by knowing that you have that capability, right? So it's the same kind of way it goes with the quantum technologies. If you would have enough functioning quantum computer, there is no sense to relieve that, right? Because we know that there is so many information that might be really crucial, whether that would be the state secrets, information that you want to stay classified, military things, you name it. And if you would actually suddenly have access to all that, would you tell it? No. So at the best, we can only guess. But that's why it's even more crucially important that people in academia would hopefully collaborate more, being able to understand that we have the shared responsibility to make sure that we don't encounter the same issues that we encounter with some of the previous technologies. Did I answer any of your questions?
Wait, I want to push on this a little bit, which is doesn't that suggest though that there has to be a role for the government, even if the government, I mean, you can't get away from it. Either the government's going to set up incentives or it's going to not do anything, in which case incentives go completely on the private market. So it's really a question of I mean, the government's going to decide one way or another.
It's usually within the universities, like,
Right.
because if you think about, that's why I would try to give a division between US and Europe. Like in Europe, many of the money comes from the taxpayers' money.
Right.
And taxpayers' money are the money of the government, right? So when government actually funds these university labs, these spin-offs, it is actually taking the action already by providing that taxpayers' money to hope that that will generate something good. In US, we can see that the White House, yes, they are definitely thinking that quantum is one of the number one priorities in US. So they are putting more money on that. However, in US, it is still the private market that actually plays the game. Let me compare it to China. China is one of the biggest money putters when it comes from the public. So in China, we can see that the central government plays a crucial role deciding how the money is being used. And they definitely have their gentle nudge on a certain direction, which is, of course, unknown to me. But that's kind of see, like the funding is actually the way how the government can pave the way where they want them to go. Would that make sense?
It does, although the government could always, it could, but just, I don't want to belabor the point. The government could always say if there's a private investment in something like that, there are certain kinds of disclosure or sharing requirements. It could always write the law.
That's why they do export restrictions. And that is one of the reasons why in our paper, we're also proposing that we should have more of hopefully like super nationwide organization, something similar to United Nations, but hopefully not as toothless as we have seen, but rather something that we could work it out together. Because what we saw during the COVID, what happened was that there was only few countries who were capable of surviving alone, right? And when we think about the quantum technologies, there's only few countries. I'm fully biased. I'm originally from Finland, but there's only few countries who are capable actually building these machines themselves. So even for that sake, we actually need that intergovernmental collaboration in order to create playground rules in the international area, especially for the ethical reasons that there would be no state left behind. As we have luckily worked it out with internet, we have internet, I would say, probably everywhere more or less in the world, at least in a form or another.
You just want to, go ahead, David, go.
So, well, I mean, overall, you know, I second both of you, but I have a little different thought, because you said you took in a pharmaceutical, you know, example. For pharmaceutical innovation, you know, like 25 years ago, there was a Hatch-Waxman Act. That act, kind of established a huge incentives for even generic drug manufacturers to, you know, challenge, you know, first, you know, new drug manufacturer, so they can do, you know, challenge the market, you know, where the new drugs are, you know, placed on the marketplace, so they can do, you know, they are, you know, more incentivized to, go in that process. So that, you know, those first filer, you know, those first challenger, you know, first generic manufacturer who files that, to challenge that, you know, new drug, manufacturers will be receiving, you know, market exclusivity for a certain amount of time. So during the time, you know, that, you know, new drug manufacturer, who is, you know, named, the brand name manufacturer, then the first filing, you know, generic drug manufacturer, you know, can do instead of kind of duopoly in the market. They can do, you know, sell, you know, both drugs without any competition. So in that way, you know, Hatch-Waxman Act provided that incentives for, in a general perspective, you know, how to incentivize, you know, innovation. I see, you know, of course, we need to think about, of course, you know, who will take the lead, you know, to this, kind of initiate this process. But again, you know, for sure that we have, you know, pretty obvious, the question is how to incentivize those innovation. I think that those innovation incentives must be kind of spread out among those, you know, market participants, not just, like a huge, giant, tech companies like Google or Amazon or Microsoft, but also like a small and medium business enterprises who are trying to kind of poke, in the market with their own product. So they need to be incentivized to challenge those market which is already in the marketplace. And then maybe, you know, consumers can do also, benefit from this, you know, incentivizing system, because they can do, again, receive, low price and like quality or a better quality product. So I think the question is how to, incentivize innovation, but not really, who will take the lead to, this incentivize, this incentive, generating process.
I have to say, I fully disagree. Can I counter argument on that? For the pharmaceutical field, because I think that is not exactly how the market might not start. Because that's why we have two incentive schemes. We have a totally different patent law in US and the other side of the Atlantic. And no wonder why we have so many big pharmaceutical companies in Germany, in Switzerland, in the European zone, is that it provides the better incentives because we have to think that you actually have to be the innovator of that in order to get a protection. But because of the European Union, and as we have seen probably in the case of a Microsoft, European Union wants to support small and medium-sized companies and make sure that you have a free market entry, or at least there is not any great obstacles. In the US, we could say the winner takes it all. But when it comes for the pharmaceutical companies, and especially with quantum technologies, which are capable at the best, accelerate this process of innovation, is that there is definitely the question of ethics. So we are not capable of putting all the money on the pharmaceutical companies and creating the monetary incentives because there's exactly that pop of money. So in case you're able to innovate and a succeeding truck, like how was it with the COVID? What happened was that many of these trucks were actually released from the patent protection to make it better for the society at large, to save those human lives. And that is kind of where I would say really different from the general patent protection as we know nowadays. So
Okay.
there is no same protection anymore coming from patents, but rather the governments paying back for the companies to provide the incentives.
Well, it's easier in the United States now because we don't even believe in pharmaceuticals. So it takes a little bit serious out there. Other questions on this one? Professor Trissolini, you were there?
Questions on smart cities, so I can read if there are more on this topic.
Go ahead. We'll more the merrier. We'll come back around.
I had questions. I really interested everyone. Really interesting talks. To all of you, I question more things I want to hear about all of them. But on the smart cities, I was trying to think about what does it mean. Like if I'm a resident of one of these cities, how does this change my experience? So a few things you said. So the traffic is going to get a little better as the city is smarter. If I call for services or assistance, maybe that's a little faster, although it's AI, so I don't talk to a person, but it's a little faster. And if I have an accident, a drone may come and provide some faster help. Those are the things that. So I'm wondering, are there other things from the citizen's perspective that this does? That was one piece of it. And the other piece of it is, so I was trying to imagine like where is this information being gathered from that goes into this brain? So the traffic, I can imagine traffic lights, traffic cameras. But I saw something in there about facial, you know, you said there's privacy issues, facial recognition. Oh, what's that about? And you know, and I know you had a lot to cover, but it kind of was in there. And then there was also something about sharing some of the information with markets. So I'm like, what was that? So two questions. What does it look like for the citizen? What are the other, like, how would this change your experience of the city? Are there other ways that I'm missing? And in terms of the inputs into the system or kind of what it's in or what the brain is interacting with, what are the other things it's interacting with? Is it facial recognition of people walking down the street, if they're getting on their phone to ask a question? Is it what they're walking by this store right now? I don't know what are the inputs?
I mean, let me answer in general, and then she can use some example from Hangzhou. For example, we know that the world is aging.
Do you guys have some mic down there?
Okay. In terms of citizens' benefit, we know the world is aging, so the elderly population is growing bigger in every part of the world. But in Hangzhou's experience, they really help the elderly people. And in terms of how you get input, it's two-way communication. They use like social media and so forth. So it's a two-way. It's not just one way. So, for example, I put a question when I'm waiting at bus stop when the bus is coming. So it's one way through maybe social media or whatever, and then the government collects the information. They can give me the real time the other way. So maybe use a concrete example from Hangzhou.
Yeah, I'm going to address the thing you mentioned about the privacy protection, as we just mentioned. So actually, it really comes to how the city wanted to define privacy protection. The fact is that nowadays, especially for the younger generations in China, they don't really consider providing information as an essential concern for protecting their privacy. Instead, it's kind of like for the younger generation, it's kind of essential, as you just mentioned, is to provide information about our face, about our fingerprint, to access to some services. That's one thing we should keep in mind. And another thing about how does the whole system interact with the information. For example, we mentioned about the facial recognition. It is particularly used in the aging houses where, for example, when there's a group of elder people living in this aging department, so their face will be automatically logged into the system. So if they didn't show on a daily basis, there could be recorded as some inconstant or some abnormalities in this person's movement, which may indicate a potential risk about this person may fall down or has experienced some severe health conditions. So it is kind of like, do you want to trade for the face recognition things for the safety protection for yourself? It is not compulsory, but it is kind of like you can opt in or opt out, but it basically enhances your experience by providing this information.
You can opt out.
Yeah, we can opt out.
And so there are specific services, like you're elderly, you want us to watch for your face.
Yes.
To see that you're moving about.
Yeah.
You can do, so there's specific services related to the recognition. That's interesting.
Yeah, and similarly, like in some aging homes, you can see monitoring devices being stored in your own department. It doesn't record anything. It's just a lot of sensor being stored in your room. So if they detect any fall down or unprecedented move before, that will be a warning to the central services, and the relevant services will be called upon and they will come to your place to examine, to check on your are you okay kind of things. But yes, but it depends on your personal choice.
Wait. Hold on a second. At what point or another is this really a personal choice, right? Because you can say, well, you don't have to give over any of this particularly sensitive information, but you won't be able to access the services if you don't. I mean, if I were in a cynical, cranky frame of mind, as I often am, really? I mean, is your view that people in a smart city just simply aren't concerned about that? Is that something we should be concerned that they're not concerned about it?
I think the point is, how do I put it? It's like it is the matter of how do you want to educate people to participate in this scheme.
I apologize, but not going. Is this in relation to? Yeah, I'm sorry. I'm gonna go out of the queue because I just wanted to see what's going on with this.
So I wasn't gonna ask this question, but now I have to. In your presentation, you mentioned that the public had an opportunity to provide a comment in the regulatory stage. Did you go in and assess whether comments were made and what the quality of those comments were? I mean, were they saying things like, we want to be able to access the service without you taking our personal info? Was that fair?
Yeah, it's basically disclosed their legislative process. So basically they list out, this is the law we wanted to enact, we want to introduce, and how do you want us to recommend on it, or how do you want us to revise on it? And based on the reports, we can actually access online. Of course, we cannot access the entire document, but basically were like comments like, maybe the citizens may want this aspect to be improved and that aspect can be improved. And then you can see a lot of comments from the government saying, this is what we do in order to address your concern. That's how they responded.
And was that specific concern about privacy in there?
No, I don't think they'll much about that.
I want to go. Professor Coyne has been waiting very patiently, and I know we have a question over there too. So I just want to.
Thank you. I do have a question for Professor Johnson.
Please, sir.
Thank you. I was wondering if under the Sanction Act you mentioned, is there a chance of taking direct action before a judge rather than going through the Attorney General? Because it's funny, I mean, in Italy, where the Freedom of Information Act entered into force in 2005, and it was said that it had been copied from the Anglo-Saxon countries. And in Italy, it is possible to go directly to the administrative court, which decides very, very quickly. and normally within 15 days, and can order the administration to release the document. So I'm discovering now that for once in Italy, we have done something that works better than abstract.
So, first of all, excellent question. I do think my presentation doesn't accurately represent the full range of options that exist, in part because the question is, how deep do you want to go? So as a general matter, I'm an empiricist, I count things. So I look at things like tax liens, the distribution of tax liens, the relationship between different factors, et cetera. I was actually forced into doing both this paper as well as a new paper I'm going to put a plug in for called Poison's Evidence, which has come out in Maryland Law Review. And both of these papers arose out of the fact that I had to sue this local government, in part because they destroyed evidence that I submitted to them about wrongdoing, in part because they went to my job and tried to get me fired. They didn't realize I'm a full tenure professor and a named professor. Like, come on, right? But in light of that, it definitely provided new and different insights into ways that one can undertake research in ways that are practical and are helpful to the general public. And one of the things that came out of that, I want to talk a little bit about the Sunshine Act itself. So under the Sunshine Act, this is a direct quote, a lawsuit to enforce the Sunshine Act may be brought by any citizen, county prosecutor, or the attorney general in the circuit court of the county where the public governmental body has its principal place of business. So it is available, lawsuits by the person who is injured, by nominal parties, etc. One of the reasons why I'm much more focused upon making use of the attorney general approach and in general administrative complaints is because that information allows for the possibility that other similarly situated people can gain access to the information about what happened to you. And as part of a larger project, my work largely is interested in how people make decisions and the type, quality, and quantity of information that people use in reaching an informed approach. That doesn't mean we start out as an informed person. I can say with respect to this paper, it's gone through various iterations. And one of the reasons why is I lack the requisite knowledge about how this particular source of law works. But as I grew in my knowledge, experience, and training, I was able to think about it in more complex ways. One such example is to say, look, I could just go to court, but then they're going to say, oh, you're just angry. Or, oh, this is just one-off. I had to go about it more strategically. And my goal was, in light of the change in, I mentioned slightly a little bit about Chevron, the different standards that apply in terms of deference to administrative agency pronouncements. In a world without Chevron, we're actually in a better position to hold administrative agencies that act in excess of the authority they're given by, one, bringing lawsuits. But I think part of it is also setting up the lawsuit, generating information to have success. So that's just a long way of saying, yes, the US sometimes gets things right. But I think one of the reasons why it's so important to explore every avenue is to think about the different functions that different sources of law perform and help our students, which is at the core of what we do in legal education, to understand how to be better citizens.
Thank you. I should know your name, but I don't, so I will simply say, you there, have a question.
Turner Jensen, got a question for Professor Johnson. I was just curious about if you were able to account for how this kind of willful and kind of frivolous and casual breaking of the law results in an increase in the amount of litigation happening. Obviously, in our country, we have a problem with courts being overburdened, so I wasn't sure if that was something you looked into. And then kind of building off of that question also, judges tend to get pretty ticked off when they think you're wasting the court's time. I wasn't sure if that was something that you observed with their reaction to litigation regarding these types of issues.
So can you say that first part again? Because I had something in mind, but I'm increasingly getting old, so it's hard to could you say that first part again?
Yes. I was just curious if you were able to account for the costs for the courts in terms of the added litigation that comes either from the Attorney General side or from individual litigants in all of these, like in terms of how overburdened the courts are, just how this casual and willful law breaking by a city like this can contribute to that overburden.
So the short answer is there's not a lot of litigation around this. My point in raising the possibility that there might be economic costs that arise from this type of systematic violation of the law is to identify the potential costs that arise. There's other related costs. But I will tell you within the context of the lawsuits that I've seen, one of the real challenges that people face is from gaining access to the information about wrongdoing. So my other paper, Choices Evidence, the one that I mentioned, it really focuses on circumstances in which relevant probative information is not available. Maybe it was destroyed by the wrongdoer. Maybe it's being withheld by government itself by making an argument, the government's making an argument that this information is privileged for some reason under something like the Sunshine Act. A third option is that it's hard to find out how government and third parties interact with other folks. So to make the argument that there's an equal protection violation that requires having information about who else has been subject to this type of treatment. So one of the reasons why I think these two papers operate in some ways in tandem is that they underscore a basic truism with respect to certain types of litigation, specifically civil rights litigation. Civil rights litigation, as a general matter, has a requirement, a condition precedent to filing a lawsuit as a general matter that you go complain to the government. But the government itself may not take your allegation seriously. So one of the ways that we can get around this is to identify new, more innovative ways of helping other people who have also been subjected to that treatment come to the government attention. One way to do so is to write an article. Another way is to file a lawsuit. Third option, which I also explored, I wrote everybody I know in the entire world and I told them about this, right? Everybody. And I worked in a lot of governmental jobs. So Democrats and Republicans know I'm not lying about this, right? And that's not available to everyone. But I would really encourage students in particular to think about new and different ways that we can bring these types of problems to the attention of the general.
This is maybe the first time that I've ever heard somebody saying, I wrote a law review article and it came to the public's attention. Professor Coleman has been very patient on all of this stuff.
Excellent discussion. So many fascinating parts to this panel. I want to ask quick questions, one about the quantum paper and the other about the paper at the end on digital trade and sustainability, which is that I put this on as well. And so on the quantum paper, thank you so much. I have to say, my oldest daughter wants to study quantum physics. She's a senior in high school. She's going to think I'm so cool because I was at a conference where there was something about quantum. So I can't wait to tell her about it. But before I became a full-time academic, I was a trade negotiator. And I wonder, with like the increasing complexity of the technology, what are those who are negotiating these agreements going to do with all of that? And how do we put forward any solutions that, you know, whether it's in the African Continental Free Trade Area agreement or, you know, these new and emerging digital agreements that are coming out, what would the solutions look like? I think of, you know, I think a multilateral agreement right now, we have had a hard time even getting multilateral agreement on factors of digital trade that are much less complex than quantum. So I'm curious about that. And on the last paper, and thank you, I look forward to reading it in more detail. I'm glad to see you're working with George, whom I know very well. And thank you for the reference, by the way, to I have a paper that just came out on this topic, but where I looked more at digital inclusion. And also some of the sustainability. We have the same issue that the sustainability references are quite broad and vague. I found one thing that kind of got at it a little bit more. But I was very interested in your kind of overall takeaway, which is that security interests are going to override everything else, which I think is true across the board, whether it's in digital or other things. And I'm just wondering, you know, did you think about sort of the inclusion part of it, extensively, which is okay if you didn't, but I think like how we define development, I think is one question that I have. And the second one is, do we think that those provisions, I mean, it's going to be interesting to see how those provisions in these new agreements are going to even be interpreted and enforced. The Cambodia agreement, and I have been kind of tracking what the United States is doing, which is all over the place. So how do you think that's going to play out in reality? Anyway, thank you all. This was a great session.
Thank you. Well, first of all, please send your daughter on our way. We're always looking for new talent. Seemingly, I need to start writing better papers with my collaborators because we're getting so many questions. And you didn't want to do anything with tech, right? That's why you chose chairing this panel.
But no, I was chosen to chair the panel, but I'm very glad I was, because it means that I'm having to pay attention to these things.
Well, I think first of all, it's complex, but that is something that we know for granted. But But as I was mentioning in our presentation, one of the practicalities that can be helpful is that many of the things we can have on cloud. So what it means is that when we think about the hardware, that is the thing that is really difficult to build, that is really expensive, and it needs a certain kind of an environment to hold that. So first of all, you have to have a really, really freezing temperatures in order to have those computers functioning, and it costs a lot of money. But one of the practicalities could be there that if you're able to access remotely, so using cloud services, you would be able to remotely access these devices. Like for instance, I know that in Finland that is already currently taking place. They have functioning quantum computers in the south, in the north, and they are communicating together, and that is already helpful to transfer information. But what would be the incentives for the more wealthier countries then to support the least favored ones? One of the aspects, as we know, the World Bank, they have already having their supporting programs where you will be getting some of the benefits when you're helping developing countries to have their better standing with the technological matters. That is already something that is happening. Other things in there, of course, we can have bilateral agreements. We have several of those already in place. Those might be really helpful. I think there is no one simple solution, but so that we can at least make sure that those fruits will not be only hanging for the rich Western, I think the cloud services could be one of the tools to make it more possible for people having access from all over. And what I mean by access is not only the government, as we'll be discussing today, but rather that we actually increase the knowledge, the awareness, and the access for all lay people as well, us, normal humans, right? Not only the governmental officials are making important decisions how to use those technologies, but so that those actually will be available for many. And I think the cloud services could be one practical tool to make that hopefully more feasible for different continents. But I would think that probably the World Bank, like incentive programs that we have in place, WTO has their own as well, as we know. There are different ways to do that. Sure.
It ties into sustainability.
Yes.
Too.
And then of course we have United Nations. We know that we have the sustainability principles in there, and you have certain incentives that have been laid out by the United Nations as well. So those could maybe playing out as nice incentives to make sure that nobody is left behind. But I also think that there's a really strong incentives for the Western countries to make sure that that is not the case, because otherwise, if we will have a great disparity between the access to these technologies, what does it create? Problems, a lot of problems.
Professor Ole, I just want to make sure
Yes.
she gets a chance.
Did I answer your question?
Yes, thank you.
Okay.
Thank you for the excellent question. Very difficult to answer in practice, of course, but I think it's part of the shift away from anything that's hard law towards softer norms. So we can't really think of these agreements, this newer form of agreements, as trade agreements, traditional trade agreements. But at the same time, a lot of it, of course, is going to be tied to conditions for investment, in specific technological sectors and certain things through non-traditional means. So, for example, investment agreements, aid, so US aid, we have the AGOA, for example, with
Expired.
exactly, which has expired. But then, I think, to wrap it all up, it's because, we're also dealing with digital empires, as has been coined by Anne Bradford. So the choice is more for developing countries. And yet again, we face this, recurring problem that we've had for decades. What is development, And, are we really trying to bridge the digital divide, or is this really about big players? And, this is why we're now down this path of, economic disparity and, bullying as well. So you can talk about it later.
Yes,
Thank you.
Well, with that, speaking of segues, because we do have, it is nearly 3:30, and I think probably better to continue the conversations in a more informal environment. And we're the ones standing between you and coffee, so I'm going to stop. But thank you all for a really wonderful panel. This is terrific, and we can continue.
Yes.
Oh, are we missing someone?
Yeah, that was on.
Okay.
He was here a second ago.
Yeah, he was here.
Oh.
Probably.
So.
Yeah. Oh, there you are. Just get it, guys. This one's really, it got folks, yeah.
Yes.
Okay, so we have a full house. Thank you. Alright. So we have 15 minutes, which is good for time, so I'm sure we. Alright, welcome back. So this is the third panel of the day on international trade and development. As you know, a lot of things are happening on trade fronts. In Washington, we have unprecedented tariff going to the rest of the world, which literally shook every trading nation. So it's a very concerning time and also exciting in terms of academics. There's a lot going on here, not to talk about. So we'll do that. So with the interest of time, I don't have a lot of time introducing these great speakers we have. But like I said, you do have online material. You just go on the line, we'll find all the speakers and papers. So I'll leave it to you to get to know the speakers. So without further ado, let me introduce Professor Coleman, Georgetown. It's your floor.
How do I advance the slide? Oh, there's a clicker there. Okay.
Everybody has a 15 minutes. Okay.
Okay, great to see you all. I'm looking forward to this. I will try to make this entertaining since it is the afternoon. But I'm going to talk about trade and development and a typology that I've been working on through various projects that I think we need to kind of order where we are right now in trade and development and think about what's working and what's not. So yeah, we're at a turning point, I think you could say. I feel like all of the years that we've been talking about the importance of trade and development, it's probably more crucial now than ever before, but it's sort of is in danger of falling off of the agenda. I think we just heard this in the last panel. National security, the tariffs, a movement away from multilateral trade rules. So what happens to trade and development in the context of all of that? So I think as we kind of see the shift more towards zero-sum trade, I guess if we could call it that, and away from some of the development aspects, I think we need to double down and make sure that we're really studying and reinforcing what exists. And so part of this project is to look at what is out there. What have we already created? What does international law look like related to trade and development? Why do we need it? And how could we maybe better assess it? And so I'm going to talk about this in the context mainly of regional trade agreements. I'll talk a little bit about multilateral trade rules. But some of this is kind of looking at the shift away from some of these traditional models like special and differential treatment, which I'll touch on. For those of you who've studied trade and development, of course, this is kind of the traditional way we've looked at it, but it's got its limitations for certain. And I think right now, too, with all of these different narratives that are happening around trade and development, we've also, I think, accepted the view that the old way of thinking that trade can just lift all boats is probably not going to work. And so what takes its place? We see populist narratives in the United States, for example, that other countries are taking something away. We see narratives in other parts of the world that the system has been built in a way that doesn't reflect the interests of countries. I think that's very true. I think the US narrative probably could benefit from some of the things that I'm going to talk about today. And some of you know some of my previous work where I focus on what I call micro international law. So looking at a much more granular, bottom-up, decentralized version of how law is being made at the more local level. Many of you have touched on this concept, and I really think this is what we need to be doing right now. So I'm going to also look at that, this kind of micro level, and I think that gets us much more into the distributive effects of trade. And where are, how do we deal with those? How do we deal with job losses and wage stagnation and security threats and the effect on marginalized communities? Because I think all of this has to be part of development. And of course, sustainability itself. So I will take us through some of these things. And I think if we look at the very high level, sort of multilateral WTO trade rules,
there is a broad commitment maybe to sustainable development. It's embedded in the preamble to the WTO, for example, a reference to sustainable development, but it is not broadly reflected in the rules. So even though, however, there is much more conversation taking place right now in Geneva within different, committees and the public forum that takes place every September, talking about development, it's more of a kind of cooperative effort, or maybe more focused on transparency, which I think both of those are really important, but those two things alone are not going to move the needle. The rules themselves are not really changing very fast at the multilateral level, even though we do have a recent agreement on fisheries subsidies, which we could count, I think, is a big win on sustainable development and a few other things. I think the other thing that excites me in particular is that we see so much innovation happening through regional trade agreements. Some call this fragmentation and something we need to be worried about. I think this is where the innovation is happening because we're having trouble globally coming together around common rules. And what I think is also very interesting about this is that initially on some of the sustainable development pieces, they were being pushed maybe by the United States, some trade agreements like the US-Mexico-Canada agreement, which is now under review and upended by some of the things that are happening in the United States. And Europe, of course, too. But I think now actually we see much more innovation coming from different parts of the world. Africa, Asia, Latin America, New Zealand, so many other places are pushing innovation in the trade space, which I think is really promising for the future of trade and development. But I think we need some kind of an organized way to study some of these things that are happening because we have so many agreements now. The WTO tracks that well over 350 trade agreements, many, many more I think actually exist. And we need to really understand what's in all of these agreements. So this typology that I'm going to talk about does that. It also integrates this micro dimension, which I've written about previously, studying these smaller scale domestic level interventions and also how stakeholders are engaged in the process of the rulemaking in trade. And it's got some empirical and comparative components, which I'll briefly touch on at the end. So one thing, and sorry that we have this thing here at the top, but so substantively, often the way that we organize our thinking around what's in trade agreements based on the substance. What kinds of provisions do we have and how binding and precise are they? So in the development space, I would say these are some of the main ones. We have a lot of provisions that are focused on cooperation and transparency. And I mentioned already that that's kind of the prevailing focus at the multilateral level. This could be cooperation on climate change, very important, again, but not substantively changing the rules. We see a lot of reaffirmations of existing commitments. So other treaties, multilateral investment agreements, human rights treaties are often integrated into trade agreements in a way that kind of reinforces these other commitments, which is also really powerful, but is not changing the rules in a new and substantive way. We have a lot of reservations and exceptions. So we have general exceptions that reference sustainable development in multilateral trade rules and also in many trade agreements. We have security exceptions as well. And then sometimes, but this is much less often the case, we actually have trade agreements advancing new minimum legal standards. They could be anything ranging from the protection of women's rights to labor standards to environmental standards. So trade agreements sometimes kind of push the envelope on new areas of law or requiring countries to have commitments, to change domestic law in certain ways. But again, that's kind of less often the case when it comes to what I call sustainable development, which is, basically everything covered by the Sustainable Development Goals. But I'll break that down a little bit more because I think even though the Sustainable Development Goals are such a great tool, sometimes I think things can kind of get lumped together if we don't qualitatively think about how they're done. We're increasingly also seeing tailored provisions in areas like renewable energy and energy transition, business and human rights, digital inclusion. So this is also kind of a new trend that these new sustainable food systems, these are starting to appear in some agreements, as well as a few other things. So let me talk also though about why I think that's not enough. I think it's not enough just to look at the substantive provisions. I think we also have to think about qualitatively from a socio-legal perspective, what are these provisions meant to do? Are they meant to increase sustainability? Yes, right? We all agree that's important. But again, I think if we kind of put everything under that umbrella, we wind up losing some detail that we need. So I had previously kind of tried to break this down into other things that I think we're trying to do with some of this law. Equity and inclusion. How do we actually use trade rules to increase equity? And it's not going to happen just by putting the word equity into a trade provision. We have to actually think about how those provisions are going to be applied in practice. Differentiation, which is kind of our traditional way, we still need to keep that, but we've seen that that's not enough. Flexibility. This is something that came up a lot during the pandemic. Countries need to have some ability to deal with changing circumstances. Certainly is something that's very important in the context of climate change. Something I call regulatory gateways, and I was excited to reference Steve's micro trade work in my paper too, because I think we also have to look at what businesses are experiencing. What happens when they try to get something to happen in the market? Is it too complicated to make anything work? Often it is, and I'll show you at the very end this way of mapping law that I have proposed in the micro international law paper that I think applies to many different areas. Engagement and transparency, I think this has to go again beyond things that are just kind of on surface level requiring that to something where you really have active engagement of stakeholders in the process and some way of ensuring that their input makes it into the agreement itself and is followed through on as these agreements are implemented, because it's not even just getting the right agreement on paper. It's having something that's going to work over many years in practice. And then how do we really assess impact? So I will talk a little bit if I have time about impact assessments, but I think those also sometimes fall short of it because they're often done ex post. They don't necessarily include a broad range of stakeholders. So this is multidimensional, again, like looking at the substantive aspect, looking at this qualitative and socio-legal dimension, and then looking at domestic law, because I think domestic law really does shape a lot of what is going into trade agreements, but it's really traditionally been the domestic law of a few kind of powerful economies. So I think part of this is trying to think about how can we cast a broader net. And again, right now, with trade and development being in this really precarious position and things being somewhat stuck on the global trade rules, I think this is how we can try to preserve some elements of the system, but improve upon them. So some colleagues have also worked on things they call flanking measures, like looking at CBAM, for example, the carbon border adjustment measure that Europe has. I think those are interesting, but I'm not sure that they always get at some of the qualitative aspects like equity. Yes, I'm keeping my eye on time too. So I think I've mentioned some of this already. I won't go into it in detail, but the paper looks at where some of these things are happening at the multilateral level. And then really goes into trade agreements. And again, here we have so many trade agreements. The UN estimates that 2/3 of all agreements signed since 2005 have some aspect of sustainable development. It could be just a broad reference in the preamble, or it could be a labor chapter or an environmental chapter or a gender chapter or something on small businesses or something on indigenous rights. There are many different ways. And as I mentioned earlier, I really think it's exciting to see innovation coming from new places. So one of the things I've worked on a lot is gender and looking at gender provisions in trade agreements. I think sometimes there's this assumption on gender that, okay, this is coming from, Europe or Canada, not that that's not a great thing. But I mean, if you look at actually these provisions, you see countries like Chile that are really taking an innovative role in this. I think that's particularly exciting. There's a new gender protocol on gender and youth, which is one of the few things that actually references youth, under the African Continental Free Trade Area Agreement. And some of the African agreements actually, which predate many of these other agreements, have binding minimum legal standards. Are they always enforced fully? That's another question. You probably know the answer, the way that I'm asking it. But the fact that these provisions are in there, I think, is a really big deal. And so the paper kind of breaks down then, really focusing a lot on equity, which I think is one of the missing dimensions. How do you address these systemic disparities, fair distribution of benefits, distributive justice? I think trade law is trying to do that maybe in some places, but it doesn't do it particularly well. Engagement and transparency, I think, is working a little bit better. There's a really great example actually from New Zealand, where there is a really detailed process to include the input of the Maori community in trade agreements. Now, if you read some of the analysis of it, there's still some criticism, right? It doesn't do everything. It hasn't always been fully reflected, but across the board on a range of issues, from digital trade to investment to non-tariff measures, that is being done. And I think that's a model that deserves greater study. So since I'm almost out of time, I'm not going to talk about impact assessments, but I want to talk a little bit about this micro piece. So again, this is from a previous paper that came out earlier this year. And I'm really advocating that we look at the granularity, that we look for the domestic examples that are shaping the way that these rules are being made going forward. And I think that if we can do that better on trade in some of these areas that relate to equity and some of these other factors, I think we will see models that could be scaled and replicated and expanded through trade agreements, and hopefully not taken apart. And so I'm going to leave you with this. Please do not read all of the fine print here, but I just wanted to show you what I mean by mapping law. So this is actually some work that I've been doing over the last 15 years in Africa on mapping agricultural regulation, which is very, very technical and very, very detailed and relates to science and relates to environmental sustainability. And what I've found with breaking the law down into these small pieces like this is that you can find these granular good practices that are embedded in so many different countries' systems. And I have seen firsthand by doing this with agricultural regulation, which is a big deal, by the way, in trade that we don't talk about enough, and a very big deal on the African continent, that some of these examples actually have risen from the domestic level up to the regional level, and then are being discussed in a way to try to expand some of that internationally. So I think it kind of goes to this theme that we were talking about earlier in the day of how do you link these pieces. I probably didn't do all of this such justice in the short amount of time, but hopefully that gives you a sense of what's in the paper, and I look forward to the discussion. Thanks.
So much. Tamara? Sure.
I'll move.
Walk around back.
Thank you. I just want to start out by thanking Professor Lee for keeping this going for as many years as he has, and also to Professor Chen and his colleagues for their help in putting this together. It's a lot of work for the other conference. So my topic is, well, entitled Tariffs, Trade, and Sustainable Development in an Uncertain World. Just an overview of the talk. First, I'm going to talk about the current situation. I'm sure you've heard some of it, the US tariffs, trade issues, legal disputes. I'll give a little bit of history about the convergence of trade law and also the way trade law developed sort of since the 1980s. Very broad overview, mainly useful to those of you who grew up, who don't know a world without the internet. And then a brief proposal, which is sort of market-based, to try to make markets for essentially derivatives to handle tariff fluctuation impacting the commodity-dependent LDCs, and with some questions to think about there. So this is probably going to look somewhat familiar. This is actually just a snapshot of the New York Times' tariff tracker. You can click on various countries and see the tariff rates. They launched it in July. They update it every few weeks. This one, I guess this is from the last update, which was just before, November 19th. At any rate, some things to note about the tariffs, right? For those of you who are like thinking about tariffs or the past, unlike say the 1990s or the 1980s, these tariffs are mostly country specific instead of being industry or good or product specific, as they used to be. That's how most tariffs were in the past. The latter type, when you actually target a particular product, like cars or steel or something like that, tends to be driven by a desire to protect a domestic industry. These seem to be driven by a desire to protect maybe everything, and also to negotiate ad hoc country by country. Just an example of two rates, right? You can kind of, maybe you can see it, maybe you can't. Two that might be somewhat relevant, but they also explain two different things, right? Some of these were imposed unilaterally by the US, like the one in Canada of 35%. And, you know, that's just, they're working on a deal, but there's no deal. Many countries have struck a deal on these sort of one-off, negotiating head-to-head with the administration. Philippines, you might noted America's a former colony. Current rate is 19%. That's because they struck a deal, right? Now, like I said, unlike the past, these are tariffs that are targeted by countries for the most part, not commodities or goods. But there's a couple of things to note. In addition to being harder to think of as just protecting a particular industry. So, for example, if you think about the 1980s, the US saw a big flood of imported cars, this is long before the internet, from Japan. And there was a deal, right? There was essentially a deal between the Reagan administration and Japanese government and automakers, right? Voluntary export restraints. You can kind of finagle something if you know the political calculus of the industry. This is a little more, it's a nice word to say, chaotic, symbolic. The other thing to notice that these are sort of very, like I said, they're handling them on an ad hoc basis, country by country. They're fluctuating a lot, like they can fluctuate day or week to week. Additionally, they seem to be very political, maybe security oriented. A term has come up, for example, secondary tariffs. This didn't exist in the past. It seems to be based on an idea of secondary sanctions. Secondary sanctions, maybe you're at war with a country or something, and somebody else does business with them, another country, so you put sanctions on that third country. This is a tariff in the same way, and we didn't used to have this, but now we have a new vocabulary word. Now, one thing to think too about that tariff tracker, because I gave you those two examples, right? America's big northern neighbor, America's former colony, right? The Philippines and Canada. They're actually, I'm sure they have their complaints, but Canada is a high income country with a diversified economy, according to the UN HDP. The Philippines is a middle income country, according to the UN HDP, with a diversified economy. But some other countries are much more exposed to US tariff fluctuations. I'll try to show you on the next page. So here we have a list of some of the poorest countries that are also highly dependent on a particular commodity, right? I think Madagascar's probably gotten the most attention in the media about this, but they're actually only 5% of their GDP is from vanilla. But as you might guess, once you're talking about 5 or 10 or 12 or 15%, and you're at a very low income, the potential loss of that, significant, not the majority of your country's income, but significant, is pretty bad, right? And you can see there's these tariff rates. If you're like, I want to see the sources, you can go to the paper and but the other thing to realize is these tariffs rates have been fluctuating depending on, well, I don't know what they depend on. But depending on perhaps the calculations of someone in the White House or in somewhere in the administration or how the negotiations are going with these particular countries. So one thing to think about, first of all, is so why can the US do this? And I apologize, I'm going to bring up some domestic law in a case, which I think we don't usually do, it seems like this conference, but not anything negative about that. But just last month, there was the oral argument in 2 consolidated cases before the Supreme Court, Learning Resources versus Trump and Trump versus the OS. And both of these cases essentially deal with a 1977 codification, an act called the International Emergency Economic Powers Act, which itself, goes back, it's really the descendant or revision of a statute that came up during World War I. But essentially what this does is it creates authority for the president to regulate interstate commerce after declaring a national emergency in response to an unusual and extraordinary threat to the United States that stems at least in part from a foreign source, right? And so the question is, is this sort of kind of upending of expectations in world trade through these fluctuating and ad hoc negotiated or head-to-head negotiated tariffs? Is this something actually authorized under the act? And there was a lot of attention paid to this oral argument. I think the commentators generally agree that the Supreme Court is unlikely to invalidate the entire act, this authority. Rather, the focus is on the use of this statute as applied by the Trump administration, right? So that raises a second question. If we think this is really a question about application, the next question is, well, is the way this statute is being used, Trump administration's use of the statute, is it actually appropriate? And so this raises the question, particularly for those of you who maybe are not following this very closely or not Americans. Trump basically has set out 2 executive orders subject or from this act, right, coming from this act. The first one quote, regulates imports with a reciprocal tariff to rectify trade practices that are aimed at the U.S. goods trade deficit. This is probably the primary one. There's a second one that has amendments to duties addressing the synthetic opioid supply chain in the PRC. That one is also part of this, but the first one's sort of more at the heart of this problem. And so the question is whether or not you can actually, under that statute, right, the national emergency, extraordinary threat to the U.S. from foreign source, whether you can actually, rectify all trade practices because of the U.S. good trade deficit, right? The focus of the oral argument before the Supreme Court, which it seemed to be, and you can never fully predict from an oral argument, I think, but it seemed to be whether or not the tariffs are actually regulating. Are they doing regulation like the statute talks about, or are they taxes? If they're taxes, there seems to be the view that they require congressional action. I don't know that this is as important as people sometimes think, because I think if the Trump administration were to lose this, they could still resort to regulation that looks less like taxes, right? And I've kind of mentioned one of them, sort of the voluntary export restraint idea, but also things instead of tariffs like various non-tariff barriers, quotas, bans, God knows what else. And so, the thing is, just for those of you who, again, are from the only from the internet era, here are just 2 charts. The one on the left, I hope you can see this, at least I hope you can see the trend, shows the effective tariff rates of the U.S. since the Great Depression of the 1930s, basically. And you can see, the 19.8% of the Smoot-Hawley tariff, and then gradually you see, I think it's kind of inarguable, they're going down. For those of you who might wonder, right, we used to take courses in the 1990s on international trade law. I'm sure they still exist, but they probably seem less important. They seemed less important until about a year ago, because of the sense that look at what's happening here in the tariff rates. And then if you look at this is from the Federal Reserve Bank of St. Louis. This just shows the graph on the right shows during the same period what's happening to U.S. exports and imports as a percentage of GDP. Right, the blue is the exports, the tan is the imports, and what you can see is that trade as a percentage of U.S. GDP is rising, and it is true. Give some credit to the factual situation. We do import more than we export, right? But notice this sort of history. It was intentional, right? Post World War II, the GATT created a kind of one-way ratchet downward on tariff rates among its signatories, and then the World Trade Organization in effective 1995 created a kind of more structured system with an actual kind of dispute settlement body and a critical mass of countries. It was hard to escape this, right? If you wanted to have an economy as well. The late Professor John Jackson, who was a key architect of the WTO, and particularly called it a world trading system, emphasized security and predictability, and that for things to be secure, you really have to have some presidential effect. So notice this emphasis on predictability, security, certainty. And that's kind of what gets undercut when you have many fluctuating tariffs, right? Because people who are investing or intermediaries buying and selling or investing in those trade flows, they suddenly are not sure what their return was going to be. There's always some uncertainty in this world, but now they're less sure because of the tariff problem, the fluctuating tariff problem. So, what I have is a proposal, and this is partly a thought experiment, partly, hoping someone would actually do something like this. Development organizations, the World Bank, the IMF should work together with market makers. By market makers, if you're not familiar with the term, it's basically like a subset of investment banks to create derivative markets around the U.S. tariff rates that are imposed on the poorest LDCs, right? Least developed countries. And the idea here is that the market makers could create markets. They already do this. They create markets around any risk so long as there's sufficient volume. This wouldn't make the tariffs costless. It would simply allow for greater predictability in investment by allowing people to hedge, and maybe not your smallest players, but people who are in this business, intermediaries, people investing in, whether it's vanilla production or something like that, to give them more predictability with respect to the tariff fluctuations. Now, it's not a perfect solution. It requires certain safeguards. You'd worry a lot about exploitative actions, particularly kind of insider trading. For those of you who've heard of things like the taco trade or concerns about Trump insiders are benefiting from that. For those of you who don't know, Chaco stands for Trump always chickens out, meaning that he'll often announce something incredibly draconian and then pull back on it. And if you know that if you have advanced knowledge that that's going to happen, boy, can you make a lot of money. So this kind of proposal requires certainly some safeguards. But it was just a way, for me, it was a way to think about what the sort of the architects of the world trading system wanted to do, who really gets hurt by what the US tariffs are doing, and if there's any way to kind of, not so much a cure, maybe a Band-Aid, but sometimes a Band-Aid helps. And with that, I look forward to your questions.
Mr. Gibson, of the state University.
Correct. Yeah. Oh, wow. I've listened to you twice. They had two AIs. That's fun.
All right, good afternoon.
Good afternoon.
You still awake? There you are. Great. So my name is Ronnie Gibson, and I'm going to talk to you about my article entitled Opportunity Loss. And I'm so glad that I followed Professor Mayer. Yeah, I want to make sure I pronounce your last name right. Because I'm going to basically take you up one level. And in my paper, we looked at trade from a macro perspective. Okay, and so here's what I do. In this article, I start off by talking about the positions of the different types of economies that you can have. And this is based on Adam Smith's work, The Wealth of Nations, mercantilism versus free trade. And as far as I'm concerned, these two approaches sit at opposite ends of the spectrum. Okay, for mercantilism, let's run through a few fundamental concepts so we're all on the same page, and then the rest of the paper will make sense. For mercantilism, a state that uses mercantilism as part of their trade to construct their trade policy, the import of goods is bad. Why is the import of goods bad? Because those imported goods compete against domestically made goods, and they serve to lower the price for domestic manufacturers. So under mercantilism, they don't want that. What they do want is they want the import of raw materials and resources. Okay, so that's one of the fundamentals of mercantilism. Imported goods bad, but we will import your resources. The goal under a mercantilist system is to always have a trade surplus. So if I, as an independent state, am trading with 3, 5, 7, 10 different other states, with each one of them, I want to have a trade surplus. Now let's take a step back. 196 independent states on the planet. It is impossible for every state to have a trade surplus. That is the first part of the paper. Okay, it is impossible to get there. One of the reasons it's impossible to get there is because domestic concerns, domestic political concerns, come into the decision making about what type of system you're actually going to have. So I go away from talking about mercantilism versus free trade. Well, what's free trade? Free trade sits at the other end of the spectrum. So free trade is, we're not looking for a trade surplus. We are looking to remove the barriers. So I, as a country, have resources. For example, I'm a tropical climate and I grow pineapples, oranges, things like that. Well, that's what I'm going to export. Okay. Well, if I'm exporting those types of goods, what I don't have is I don't have natural resources, for example, to manufacture electronics, right? Because my topography, the topography of my land is geared toward fruits and vegetables. But I need that other stuff. Okay, so as I export fruits and vegetables, I import those other things in, and we work with those other foreign states to lower barriers. And they can be tariffs, they can be non-tariff barriers, like I keep thinking, and I never say it right, PSP, phytosanitary.
SPS.
Yeah, oh, it's SPS. See, I do it wrong every time. SPS, sanitary and phytosanitary. There we go. Other non-tariff barriers like health concerns or health regulations, those get put up as ways to sort of slow down trade between nations, especially when they're reaching for a more mercantilist approach. Now, with the understanding that mercantilism and free trade sit at opposite ends of the spectrum, most states, you will see them pursue something that is a hybrid. It's some form of a hybrid. The United States has been pursuing since 1947 a form of a hybrid free trade mercantilist system. You look at it and you will see indicia of mercantilism. You will see a lot of free trade, especially with the multilateral and bilateral agreements that we signed. Okay. So after that, after talking about mercantilism and free trade, one of the things that I do is I insert Reagan's speech, President Ronald Reagan's speech, that I think was played at a baseball game in Canada that upset the current administration. So sad, too bad. But President Reagan understood that tariffs were a short-term measure. President Reagan gave a radio address, and this is what was actually quoted and cited, because the United States had a dispute with Japan over semiconductors. Japan wasn't living up to the terms it agreed to in this trade deal. So Japan was violating Pact Sunt Servanda, which is a doctrine, an understood doctrine in international law that countries have an obligation to adhere to their treaty obligations in good faith. Right. So Reagan imposed the tariffs, but only for a short term. And it's in this radio address, it's really fascinating, that he talks about, and he basically lays out the whole lesson. This is why you don't want to use tariffs as a long-term measure for controlling your trade policy. Why? Because if you do that, what happens? You're going to end up in a trade war. You end up in a trade war, your trading partners, especially if you're, and I'm going to use the language, piss them off, are no longer going to be. If you piss off your trading partners, they're no longer going to be your trading partners. Right? That wasn't rocket science. Okay, it wasn't. Okay. The next part of the paper, I then walk through the historical impact, and I talk about the conditions that led to the Smoot-Hawley Tariff Act, and how that actually contributed to the United States entering into the Great Depression and prolonging it until FDR came along and worked with Congress to remove those restrictions. So that after World War II, we had this understanding, we don't really want to have a society that's built around these tariffs. So let's move more towards free trade. Well, now we get to Trump. Last time I checked, President Trump was a Republican. It seems to me that if you are a Republican and the father of all Republican presidents is telling you that tariffs are bad, you might want to listen to him. That's not the case. As noted economist Douglas Irwin, who's a professor at Dartmouth, he was interviewed, and in this interview, he talks about the different things that actually need to happen that the Trump administration needs to do. And the reporter asked him, it's like, well, why don't you just sit down with him and his administration and tell him what needs to be done? And he responded, he said, they won't listen. They won't listen because they don't care about the consequences. And that's the part that is very troubling. So with that understanding, I basically say, well, let's identify, right, how we fix this after the Trump administration comes to an end. Okay. Throughout the paper, I highlight different points in different parts of the economy where the United States has basically been presented with different opportunities to solidify the relationship with our trading partners and improve it. And one of the parts in the article that I talk about is the Trans-Pacific Partnership. And the Trans-Pacific Partnership was envisioned to be our gateway, the gateway for the United States into Asia, opening up markets that the United States had not necessarily done a lot of business with. Now, one of the things that you don't probably know about me is that I'm actually an aviation lawyer. That's how I got started writing in aviation. It was in international law, it was all about aviation, which naturally took me in the direction of international trade. So one of the big players in the aviation industry here in the United States is Boeing. Okay, and everyone at some point or another has probably flown on a Boeing airplane. Well, Boeing, its main competitor is Airbus. So if you go throughout Asia, countries there, their national airlines will either be flying a Boeing aircraft or an Airbus aircraft. However, that duopoly is coming to an end. And it's coming to an end because China is coming on strong with its COMAC-made aircraft. They've got it's called the C919. And the C919 has not yet been certified by either EASA or the FAA. And those are the two main regulatory bodies that need to give it certification before the COMAC, the maker of the aircraft, can really establish a strong foothold to sell its planes. Boeing knows this, Boeing feared this, and Boeing was a big proponent of the TPP. So when the TPP got pulled out from under it, Boeing started to scramble. And I'll talk about that as I get through this. There's been, as I walk through the article, I look at different segments of the economy. And I talked to you about aviation. Well, the value of the United States economy is about $27.5 trillion. Aviation contributes 5% to the national GDP. And we already talked about how, a 5% impact one way or the other, that's significant. We're talking about 140 million jobs, okay? Agriculture. The article also looks at the agricultural industry in the United States, and I take a particularly in-depth look at soybeans. Now, I don't know if you've been paying attention in the United States over the past 12 months, but once the Trump administration came on and took office, they announced this policy where they were essentially going after China as a country because of this belief that they wanted to have a trade surplus with China. Like, well, okay. It's really hard to sort of wrap your head around that because China is the number one purchaser of American-grown soybeans. That's our number one client. So let me ask you this. This is something that I did not know, so I'll ask you. How much do you think a commercial farmer in the United States makes per year? What do you think? US dollars. Give me a number. Give me a number. What? Who said that? What'd you say? She says 200,000. Anyone for lower?
60 grand.
60 grand. What were you gonna say?
That's the lowest.
Oh, okay. Anyone else? So I did a survey. I actually had my research assistants do a survey, let's be honest. But we surveyed all the law students that we could find and asked them this question. And the average belief about commercial farmers in the United States is that they make about $60,000 to $70,000. Well, statistics from the federal government show that commercial farmers in the United States, $250,000 a year. Okay, hold on, let that number sink in and start thinking about partner draws at law firms at the end of the year. Right? I'm giving you apples to apples. Okay. Now go back and take a look at the Trump electoral map. All the states right in the middle of the country, the plain states that grow soybeans, voted for Trump because they believed that his policies would help them. And they did not have a true understanding of free trade, mercantilism, and the impact of using tariffs to try to control that industry. The economy is this, I see it as this machine from the Wizard of Oz. You pull one lever and you hope that something happens. Yeah, that may happen, but if you don't do it in a thoughtful manner, 7 other things are going to happen that are going to be bad. So you really have to stop and think through all of the different changes that you want to make when you are trying to adjust the economy. So soybeans. So I talked about aviation, tourism. Sorry, how much time do I have left?
You got actually 2 minutes.
Oh, good, okay. Tourism. So I also looked at the tourism industry. And the first thing that stood out for me is how angry Canada is. Now, the question for you. Number 1 source of tourists in the United States. Guess where they come from? Canada. Canada. So sure, let's just say we want to annex that country and make them the 51st state. That's certain to go over well, right? That's going to increase our numbers. No, it actually didn't. But tourism is very closely related to aviation, and those numbers have fallen, and they are not actually predicted to come back up to the levels prior to Trump once he leaves office. So we've got a lot of diplomacy and relation building to get into to get those back. So I told you, aviation, take a look at this. This is the Boeing 787, and different parts of this aircraft the parts themselves come from foreign countries. Sweden, Japan, Italy, more Japan, Australia, Korea, Japan, the UK. So when the administration just announces these blanket tariffs on countries without a true understanding of what those tariffs are going to do, the companies end up suffering. Because I don't know if you've noticed, a lot of American companies have taken the position that we're not going to pass on those tariffs to the consumers. We're going to eat that cost for as long as we can. That's not a recipe for continued success, because the consequence has been that they've had to cut costs in other areas, meaning they've had to cut labor. Okay. So how do we fix it? Well, last thing, it was he was the director of trade in Japan under Prime Minister, I think, Toshiba, who talked about, well, we negotiated a deal with the Trump administration, but we don't want it in writing. We are reaching for what we call now strategic ambiguity in trade deals. We don't want it written down, because that way it gives us the domestic room, the political room to maneuver. It's like, man, I think that's very dangerous. It's like, how do we really know what the agreement is? But that seems to be the position that some of our trading partners are taking. So my solution, Congress must reclaim its constitutional authority under Article 1 of the US Constitution. The United States Congress is charged with developing trade law policy, and it's their job to exercise it. So they need to reclaim it. If that means they need to pass a statute that basically vitiates all former transfers of power under different acts, then so be it. Because I think that is the way that it will give the Supreme Court no room to misinterpret Congress's power and Congress's intent. And I'm relying on a case called Youngstown Sheet and Metal Tube Company, where the court said that when the president acts consistent with something that Congress has passed, he is at the zenith of his power in the issuing executive order. When the president acts in an area where Congress has not spoken, he is actually at his weakest point. Okay. Focus on the removal of non-tariff barriers and work on rebuilding our partnerships. We want our trading partners back. Okay, so let them exist in this era of strategic ambiguity for the next 3 years, but afterwards step in and send our diplomats from the US State Department around the world to do the healing. Thank you.
Is it close to
Ano kakao, kua hui maine e mi ana ki te mana whenua o tene oe. This respectful sentence is what I always tell my students or any conference where I speak at in New Zealand. And it is a form of acknowledgement and respect for the people of the land. And I want to acknowledge the native Kanaka Maori, the native Hawaiian people as the original stewards of this land. And I also want to thank very much the organizers of this conference to being able to bring us together to discuss these very important issues. Mahalo nui loa for welcoming us here. The ideas I will present today reflect my own understanding, own reading of how trade law can evolve to support climate resilience in the Pacific. So this is a bit of a break in the action because you have three experts on trade law and you have a fourth expert at the end, but in between it's me. I'm not an expert at all on trade law, but I'm working much more on sustainability issues and on climate change, even though my main area is international humanitarian law. But what I really want to do is to look at how and proposal can about making trade more resilient for Pacific Islands. What I really wanted in that paper, short paper I've written for this conference, is really to look at the potential of climate compatible trade as a way, as a catalyst for sustainable economic development in Pacific small island developing states. And the core question, what I really want to talk about today, is how can we redesign or refresh at least traditional or trade rules so that it can strengthen rather than undermine climate resilience and development in the Pacific region. Now, I usually don't speak with notes, but I have a very bad reputation at conferences of going above time, and I don't want the professor to come and take the microphone away from me. So you'll excuse that, which make it not as natural as usual. But Pacific small islands states really sit at the crossroad of extreme climate vulnerability and structural economic dependence. Most rely heavily on imports. They face high transport costs and have narrow productive bases. And they are now confronted by the climate shocks that really are threatening not only livelihoods, but the very viability of their territories. At the same time, global trade flows account for roughly a third of CO2 emissions. And what we need to understand is that trade rules shape development trajectories for good or ill. And if trade and climate law continue to evolve in isolation, Pacific small island states will remain trapped down between rising climate costs and rigid economic structure. I'm not going to go into much detail. I think that this chart talks for itself. There's been really an acceleration in global warming. This is affected. It's always been global warming, but this is at a pace human organized in a way that really threatens evolution in a normal way. So this is really quite clear. 2024 at a temperature of one additional 1.29 degrees Celsius, and that is really, you can see really the tendency. Also, obviously, in terms of surface air temperature, we can see that really it is warming up, and this affects very much Pacific Island states. It affects the crops that can be cultivated. Also, it does affect even the fish species and the capacity for people to go and fish for their livelihood. And so really these are grave problems that are really there. So traditionally, we know that law and development thinking equated liberalization with growth. Trade rules were assumed to be neutral. Technical instruments were capable of delivering development if states align their domestic policies correctly. But I think that it's clear that Pacific experience forces us to see that there is a contradiction in this assumption. And neutrality in practice reinforces existing asymmetries between large and small economies, between industrialized exporters and fragile importing states. And this reality forces us to rethink development. What we need is a model of trade governance that is context sensitive, climate informed, and one which is capable of supporting adaptation and resilience. And this is really the normative foundation, in my view, of climate-compatible trade law. What is climate-compatible trade law? Well, by climate-compatible trade law, I mean the integration of climate objectives
into the design and interpretation of trade rules themselves. And this goes way beyond relying simply on exceptions like Article 20 of the GATT agreement. Instead, what I'm envisioning here are trade rules that actively support Paris Agreement objectives. For example, tariff schedules can prioritize climate-enabling goods. Licensing systems can be designed to reward low-carbon technologies, and subsidy disciplines can be differentiated so that developing economies retain the policy space for just transition. And really the goal is really for trade to become a driver of resilience and adaptation, not a source of rigidity. And I think to some extent what I'm saying here is quite safe, as I'm really presenting here more of a vision than what is actually law. And what I'm trying to provide is an idea of some kind of model that will align with the WTO law as we have it. And it's not walking away from it. I'm quite clear that I want to really to understand this alignment is feasible, provided that measures remain non-arbitrary and proportionate, and that they are consistent with WTO law. In terms of normative foundations, the model already stands on normative pillars. First, sustainable development, which is rooted in what I say, the Rio instruments. You find it in the Rio Declaration in 1992, and it's been found in many treaties on environmental protection. The 2030 SDG agenda is another one. They really embed the idea that economic governance must account for environmental and social needs. Secondly, it's the Paris Agreement. The Paris Agreement affirms principles of capacity building, climate finance, and adaptation that give small island states a legitimate basis for differentiated treatment. And thirdly, scholars have underscored the need for law to evolve alongside development realities, rather than imposing one-size-fits-all prescriptions. And finally, I would say that recent WTO scholarship emphasizes this interpretive flexibility within WTO law that permits, in my view, climate-aligned policymaking when measures are well-designed and evidence-based. And this fits, in my view, with the jurisprudence of the WTO appellate bodies' approach to evolutionary interpretation. And they can be accommodated, in my view, under Article 20 of the GATT agreement, Article 2.2 of the TBT agreement, when measures are not arbitrary. If I look at some comparative examples, I look here at the carbon border adjustment mechanism and the agreement or attempt to have an agreement on climate change, trade and sustainability. These are two models, external models that I think can be quite constructive for the Pacific. The first one really links trade measures to carbon intensity, and it shows how environmental integrity can serve as a basis for non-discrimination. While the scale of the CBAM is not directly applicable to small island states, I think it's the logic that aligns trade with climate objectives, which is relevant. The ACCTS initiative that has been led by New Zealand and a few other states goes further as it promotes tariff-free trade in environmental goods and disciplines harmful fossil fuel subsidies. And together, these examples, in my view, illustrate that climate-compatible trade law is not theoretical. Now, let's turn specifically to the Pacific. And in the longer paper I'm going to prepare, I really want to focus a bit more on the experience of Pacific Islands. And I'm taking here two kind of extreme examples, Kiribati, first of all, and Samoa. Kiribati really represents one end of the spectrum. It has a highly concentrated economy, limited productive capacity, and extreme dependence on imported goods for food, energy, and basic infrastructure. Climate change compounds these structural constraints: sea level rise, saline intrusion, damage to transport infrastructures. They all increase the cost of trade and reduce policy space. And because of these vulnerabilities, small changes in global trade rules, for example, tariff escalation, certification burdens, have outsized effects. And Kiribati really shows us that without some kind of flexibility, climate critical imports will remain expensive, unpredictable for such a small economy. At the other end of the spectrum, we've got Samoa. We've got Samoa, and Samoa has stronger institutions and a more proactive engagement. But it has a more diversified economic base and comparatively stronger institutions, which have enabled the government to, in the past, to make some strategic, they're really making some strategic use of trade facilitation measures and streamlining custom processes, for instance. And Samoa has been able to engage more actively in regional and international initiatives, including discussions under the PACER Plus agreement. It has drawn on international technical assistance to strengthen regulatory capacity. And this demonstrates that when institutional conditions allow it, Pacific states may leverage trade policy to support climate priorities rather than be constrained by it. And these constructing experiences, in my view, highlight a simple but critical point, that trade rules on their own will not produce resilience. Resilience will depend on the interplay of domestic capacity, access to climate finance, adaptation to relevant technology, and regional cooperation mechanisms that reduce duplication and share expertise. And this is precisely why climate-compatible trade law matters. It does provide a framework that recognizes structural differences within the region, gives states the policy space they need to address climate impacts, and it embeds cooperation into the trade regime rather than treating it as an optional add-on. How to make these reforms in that region? First, I think it's conditioning liberalization of climate-enabling goods to the lowering of elimination of tariffs on renewable energy technologies, adaptation tools, resilient infrastructure, inputs that can materially lower costs in small island states. In my view, preferential liberalization is WTO consistent if extended MFN style or justified under the enabling clause. Second, just transition subsidy reform. And this means shifting from form-based to purpose-based subsidy rules that allow government to support green transition without reaching WTO commitments. And these subsidy proposals are prospective reforms. Current law does not yet recognize just transition subsidies, but the expired SCM Article 8 is a precedent that shows how the system can evolve. And thirdly, maybe it's the setting up a loss and damage trade facility that would link trade facilitation measures to predictable climate finance. For example, faster clearance, reduced inspection burdens, and concessional logistics arrangements following extreme events. The climate risk fee would likely proceed under GATT Article 8, fees and formalities, and could rely on Article 20 for environmental justification if necessary, provided it is non-arbitrary and proportionate. And I think these are some kind of reforms that can create a coherent model of climate-compatible trade governance. And in the Pacific, how could we achieve that with existing instruments? Would be maybe to have a Pacific climate trade protocol that could be potentially nested into the PACER Plus agreement that aligns concession standards and regulatory cooperations with climate objectives. It could draw on the governance structure developed under the Pacific Resilience Facility Treaty that enables collective benchmarking, climate finance, mobilization, and capacity building. The objective is really to shift the narrative from Pacific vulnerability to Pacific normative leadership. And that is important. Capacity building. It is really a key phrase for the Pacific, and that's where the help and assistance is needed. And in the end, really, in closing this very short presentation, I really want to say that trade law is, when we see the Blue Pacific, trade law must evolve alongside the climate crisis. Neutrality is no longer credible. Pacific Island states need trade systems that protect their economies, strengthen resilience, unlock long-term development pathways. And climate-compatible trade law offers one way of reimagining both trade and development, not as separate spheres, but as mutually reinforcing components of climate justice. And if we take climate impacts seriously, in my view, then integrating climate considerations into trade law is not optional. It is a prerequisite for a fair and sustainable trading system in the Anthropocene. So in concluding, I hope that this conversation we begin today with this conference help us imagine trade rules that genuinely support resilience, sustainable development, in the Pacific. Mahalo to the organizers and mahalo to all of you for your attention and thoughtful engagements. The life of the land is perpetuated in righteousness. Thank you very much.
Lastly, Professor Svedlutsky. Thank you very much. So I initially wanted to have a PPT, but then I changed my mind. So you just, if you're tired looking at me, you can just look at this beautiful logo, University of Hawaii Law School. And I'm grateful to organizers that we actually happen to have the conference here. The presentation that I'm going to talk about is called the export controls of the dual-use items, balancing between security and sustainable development. First, let's discuss a little bit about the dual-use items. And one of the previous speakers talking about the quantum computing, which I already mentioned this term. I'm just wanted to make it a bit broader definition, right? So when we say dual-use items, already from the word, from the term, we assume that there is some kind of more than one function, more than one functionality of a particular product or technology. Now, normally, dual-use items that we use in relation to the economic law, trade law, is based on this dichotomy that the same product or the same technology can be used for two purposes, namely civilian and military. And a lot of regulations, national ones and also non-proliferation frameworks, is based on this dichotomy. So military and the civilian. However, if we look at some other regulatory instrument, we'll see that this is not specifically so. This is not just between the military and the civilian applications. For example, if we would look at the key non-proliferation treaties, like a treaty for non-proliferation of nuclear weapons, chemical weapons, or biological weapons, they do not use this dichotomy of between civilian and military application. They say peaceful and non-peaceful uses. And why is it so? This is because one of the concerns is that these dangerous materials, these elements, might end up not just with state actors who actually have a military to use it in a combat, in an armed conflict, but also can end up with non-state actors, for example, terrorist groups and other organizations who could put it not to the military use, but to some kind of unwanted use. And so therefore, we have to have some controls over these dual-use items. However, this dichotomy is even further blurred when we are looking at different regulatory frameworks at different countries, and I will give some examples in my presentation, where the dual use becomes something between benevolent and malevolent use, if we can say. Something that we believe, according to our value system, our ethics and so on, that is a proper use, benevolent use of a product, and something that is a ill-intended malevolent use. So, for example, different jurisdictions have export control on the technologies or materials that can be used, for example, as a surveillance tools in order to commit human rights abuses, violations of humanitarian law, tools that can be used in terrorist or criminal activities, or even some technologies that can be used, for example, for spreading mass spreading of propaganda messages, right? Now, if we draw this dichotomy so far as identify benevolent and malevolent uses, you can imagine that the family of the dual-use items is quite large, quite big, depending on our understanding of what dual-use is. But even if we do not play with the rules, if we do not play with the legal definitions, the family of the dual-use items is growing nonetheless because of several objective circumstances. One of these circumstances
is that the modern warfare becomes increasingly technological. So if we would look, for example, take a look at the Russia-Ukraine war, Russia-Ukraine conflict. Probably this is a single instance where we see an old style of war and a new style of war in the same conflict. Because you can see very much how different is this conflict from its beginning stages, where we see these traditional armed vehicles, massive troops movements and so on, to what we see now, where there is no more armed vehicles, no massive troop movements. It's all about missiles, drone attacks, and targeted, based on surveillance, targeted hits. So we also noticed that in this conflict, a lot of these technologies that are being employed for the military use were essentially applied in a civilian sector. Like, for example, all technologies related to cameras, drones, and surveillance. Second is that many nations are applying so-called civil-military synergy policies. We can see this in the countries ranging from China to the European Union, where there is an industrial policy in order to stimulate the flow of technology or inventions from the military sector for commercial applications, from the commercial applications to the military sector. Just an example from the European Union, who is trying to do now this Rearm Europe strategy. European Union, for example, would like to engage as many companies, especially small and medium-sized enterprises, in producing products that are going to be used for the defense. So we can see from these policies that the circle of the actors involved in the dual-use manufacturing is increasing, because more and more companies involved in commercial manufacturing are now producing for the defense industry, and those that are being government contractors in the defense industry, commercializing their technologies in the civilian sector. We also see that there is a privatization of the military supply. The governments realize that in order to save costs, it's much easier to announce a public tender and to buy from the private sector, because it will be much cheaper than having a state-owned enterprise or state-owned research and development and production. So again, the number of the companies who potentially involved in dual-use manufacturing and production is increasing. And finally, because now, as we can see from the previous presentations, the geopolitical tensions are very much expressed now in who has an edge technologically, who has an edge in manufacturing. More and more securitization is applied to the production of certain materials, right? So we see increasingly that the countries regard domestic production of certain materials as being crucial for their national security, for their defense. Can we say that more and more goods, therefore, fall into this category of the dual-use items, if they are so important for the defense, if they're so important for national security? Now, when we are talking about what exactly are dual-use items, is because depending on what they are, we are applying special regulations to them. And the focus of my presentation is export controls. So dual-use items, this is something that we would like to, first of all, to have in our jurisdiction. And secondly, we would not like other jurisdictions to get. So we impose export checks and export controls on such dual-use items. Now, if we look at the WTO rules, and several previous speakers focus on the WTO law frameworks, the quantitative restrictions on the exports generally is prohibited, the same as the import restrictions are prohibited. So you have to have a specific justification in order to deny the export of certain product from your country to other WTO member states. Now, of course, if we're talking about dual-use goods, we say that we prevent the export based on the security considerations. So it's about security, it's a dual use, so it's a security issue. Now, for the security issue, again, as mentioned by the previous speaker, we have a broadly worded security exceptions in the WTO treaties, which says that certain things you can deviate from the WTO norms, from the WTO regulations. So security exceptions basically contains three items there, under which you can do this exception. First item is related to the fissionable materials. So this is just applied only to the nuclear products. So this is very narrowly narrowly phrased. We cannot apply it to all the dual use items, only to those related to the nuclear technologies. Number two, measures which are taken in the time of war or other emergency in international affairs. So this is basically some kind of an emergency stop break, which we can invoke when we impose these export restrictions. So war or emergency. And finally, number three, these are the exceptions related to the trade of arms or other products that are going to the military establishment. Now, where do we fit our export restrictions on the dual use items under these three categories under the security exceptions? So fissionable materials, nuclear? No, because it's very product specific. War or emergency in international relations? Well, there are very few active wars as we have now. The geopolitical tensions that we have now, they are not really wars. There could be some kind of a trade wars, but this is not a real war that is envisaged by this provision. There have been several disputes in the WTO where the WTO panels have a very high bar to what do they consider as an emergency in international relations. For example, the US tariffs that the US has imposed on the foreign steel and aluminum products, which it has motivated that it is necessary to protect national security because these are very strategic material. All of these tariffs have failed under the WTO as there was no proof that it is an emergency in international relations. So there is a very high bar of what emergency is supposed to be. And obviously some kind of a trade tensions and these kind of mercantilist strategies do not amount to the emergency that justify these restrictions. So that's why in the paper we argue that the next battlefront for the security exceptions, especially in relation to these export controls, is going to be this third element, the products that are either can be used as weapons or they are going to a military establishment. Currently, there is one case pending in the WTO, and that is a dispute lodged by China against the US for the export restrictions on the export of high-powered advanced semiconductors. In its position, the US alleges that these materials, these products can be used for the military build-up, for the military upgrade. China claims that this is a widely used civilian product used for commercial applications, and therefore those export controls are not justified. This dispute is currently pending, and we believe that the result of this dispute, if it will be resolved by a panel ruling, will be very important, because here the panel will probably have to draw the line of what exactly standard we use to prove that some products which are in themselves not arms or not weapons, are nevertheless going to the military establishment. Here, for example, we'll have at least two challenges. For instance, is it sufficient to know that the same product can be potentially used by the military? Well, this is a very low bar, because military is using a lot of different technologies and is just for that kind of technical criteria will include it under the export restriction, that will be really low bar. However, we can ask the next question: does the country has to justify that they have a knowledge that some particular product is going to a military establishment and therefore they're putting restrictions on it? Now, the problem with this kind of evidence would be that under the WTO rules, the member states are not expected to disclose information which is relevant to their security. So there is some confidentiality related of what we actually know where it's going, and therefore we cannot be, required to disclose this information. Now, this puts the panel in a very difficult situation, because how the country then will make its case, how it will prove that it has such knowledge that something is being supplied for the military. All these questions are very important, and we'll see how the WTO panels are going to resolve it. But as you know, regardless of the outcome, because of the current dysfunctional nature of the WTO, with the second level, the appellate body is not functioning, and we cannot really expect that these findings will be conclusive and the countries will really comply with it, because WTO does not really function as it's supposed to be with the appellate body crisis. Now, if we turn to the international law, and I know I have only 2 or 3 minutes left, so I'll try to be brief. We have a very general disagreement. For example, if we look at the debates on these export controls in the United Nations. Now, a large group of developing countries essentially claims that these export restrictions and export controls are nothing else but some kind of a measure of economic coercion affected by the developed nations who control those goods and technologies. So there are a series of the United Nations General Assembly resolutions which claim that these export control measures in the form of economic coercion have to be sort of suspended, and the UN members should refrain from it because it prevents the technological development of these developing countries. Recently, for several years already, China has been successful in sponsoring a United Nations General Assembly resolution saying that some countries are abusing non-proliferation controls and thus also affecting the economic development of other members, and they again calling for a different mechanism to be administered, how the export controls should function. So obviously, we do not have agreements at the multilateral level because of the crisis in WTO and because of these disagreements at the United Nations Forum. So what are we left with is several plurilateral initiatives where some countries try to cooperate with each other on the export controls of the dual-use items. Once again, I will just summarize 3 issues or 3 problems with these export control corporations. First, many of these frameworks are country-specific. In other words, several allied countries come together in order to impose export control restrictions against a third particular country. For example, the best example is current sanctions against Russia. Obviously, this kind of framework is not feasible for universal adoption because it's not going to last forever. And second, because not all the countries agree with such targeting of a specific country by export controls. Second, there are purpose-based export controls. There are several initiatives, for example, led by the United States, where the purpose is, for example, to protect human rights, to protect citizens from the government surveillance and other purposes. And so they advocate cooperation and export control for these purposes. There again, there is a similar problem. Not all the nations share these values or these purposes on which these initiatives are based. And therefore, only certain allied countries, which like, for example, to benefit from the technologies coming from US or other members, join these initiatives. Again, it's not really for a wider adoption. Number 3, again, something maybe more possible for a more universal acceptance is the item-focused export controls. So if it would be possible to identify certain items, certain products or technologies that are viewed by sort of majority of the countries as presenting certain kind of threats, then it would be more realistic to expect for a more kind of a universal acceptance and cooperation on those things. We can see this from the example of the non-proliferation treaties or the Wassenaar Agreement, when many countries join to cooperate in the control of arms and certain dual-use goods. So, since my time is up, just to conclude, so we have a multilateral level, which is clearly not functioning because of the issues related to the WTO and disagreements in the UN. We have plurilateral cooperation, which again, basically is just a coalition of the willing with some problems for a wider expansion. And finally, we have a continuous proliferation of export control measures unilaterally by the individual countries. And many of these export controls are even applied extraterritorially, which really enlarges their scope. So for example, United States and recently China, they apply export controls not only to the products that are being actually exported from that jurisdiction, they even maintain certain degree of control with this product after it already left the national territory and being continuously resolved and moved. So that is the situation what we have, and sorry if I exceed my time. Thank you.
Thank you. Right, given the dramatic development in trade, this has been very helpful and exciting for excellent presentation. So we have about 35 minutes discussion, so we'll do Q&A, okay? So, all right, so we'll start with the audience and introduce yourself a little bit if you could, and let us know from whom you expect answers. Go ahead.
Hey everyone, it's Laura Bernadette, originally Spanish, but hailing from Cayman Islands today. From small island to small island, I'd like to ask, being in a small island as well, I'd like to ask a question to Alberto, if I may. So you've talked us through about measures that other states in conjunction with the Pacific Islands can do. But I wonder, to what extent the Pacific Islands themselves are committed to environmental principles. So I'm thinking about a couple of experiences in the Caribbean. For instance, the Cayman Islands charges duty on everything. That's how they make their revenue. Literally everything, except for electrically powered vehicles. Bahamas has prohibited completely the use of single-use plastics, and even if you get as much as a spoon into the country, they fine as much as they can out of you. So all of these measures show some, albeit limited, but some commitment to environmental principles, even though they do have a cost. But in the Caribbean, saving the distances, some of those countries can actually afford them. They should even do more. So I wonder what the situation is like in the Pacific Islands. First of all, can they afford to be environmentally responsible? And second, if so, how do they do it?
It's an excellent question. I think that, first of all, from a point of view of speaking through one voice or together, it is correct that, as I was trying to make the point with Kiribati and Samoa, we have very different economies. And I mean, I gave a very positive view about Samoa, but even another country like Fiji, despite being more advanced economies, they do suffer for any vulnerability that is cyclones. And so it is problematic to speak through one voice. They work together quite well through the Pacific Islands Forum, through the PACER agreement, and that has had positive impact. The problem is really that they have very different economic needs. And I think that maybe to first give a wider perspective is that in the Pacific, the biggest issue is one of capacity. And in the Pacific, for Pacific Islands, it is very difficult to, what is sometimes perceived as not being willing to take measures is more because of the limited capacity they have. And one question we asked often, and even I remember the Pacific Islands Forum officials coming once to Wellington and talking that sometimes the issues of great relevance to Pacific are what they call the fish and rice issues. They have difficulties with the basics. There are often sometimes a handful of legal advisors. And so that brings a limitation of what they can do as a group within each state and also as a group. So I think that the challenges are the same, but what is difficult, I think, is really the question how to approach some of these problems. And also in the more recent times, I think the geopolitics has reached the region, and there are some differences in approach. If you take Kiribati, who now recognizes Beijing as China, as it used to recognize Taiwan. You have obviously Solomon Islands, but Papua New Guinea with different challenges. So I think that in the little that I know about the Caribbean examples, I think some of the economies are a bit more advanced. I would say much more advanced, and I think there might be a more of a capacity to handle some of these challenges. But for the Pacific, I think that what I would like to maybe show when I increase the size of the paper for the conference is that we start from the need to work together, rowing. We always talk about the waka, the canoe, all rowing in the same direction. And that's not very easy because it's really divided still into three regions, with the Northern Pacific being very much having to cope with, for lack of a better term, with the United States and their there. And then you have the Polynesia, which really deals a lot with Australia and New Zealand. Then you've got Papua New Guinea, Solomon Islands, who have a variety of other issues. So for me, the kind of there is an element of unity, but in approaching these issues in the economic sense, there are disparities. So you have only six, if I'm not mistaken, six members of WTO from the region, and even within the PACER agreement, I think Fiji is not a party to the PACER Plus PACER agreement, if I'm not mistaken. And so that leaves really difference. And I was reading some reports. I mean, the WTO has done reports in the past. There have been other reports. I met at the Asian Development Bank. The problem is really the small territories, small populations, huge problems, and an incapacity to bring together sometimes some of the answers that are needed. But at the same time, I would say that there are efforts. The word resilience is now, everybody talks about resilience. And that is really important. That's why we need to play with existing, play not the right word, with trade rules to try and see how we can help these countries to improve their economic position. I'm not sure that's really your question, but it is really a question of capacity and resilience.
Any other presenter would like to answer?
Can I make a quick comment? I think I loved your presentation, by the way. It's incredibly interesting to take a case study. That's kind of part of my, what I'm advocating in this kind of bottom-up approach, because I think that gives us the ability to really look for answers. I think one of the challenges that I see with the WTO rules, though, is that they do have some limitations. So Article 20, the general exceptions, have been used successfully 3 times because countries can never meet the requirements in the chapeau that, where you have to show that it's not used in a way that's arbitrary or restrictive of trade. I'm paraphrasing, but I think that, in the times that it has been successful, the country has had to revise the measure. So I worry a little bit about that element. And I worry also a little bit about CBAM, for example, where it is something that is very clearly in this space of regulating climate, but it is not being done in a way that reflects differentiation. No special and differential treatment, no common but differentiated responsibilities and respective capabilities. Everybody has to comply with it. And it's going to, I think, put this huge defensive burden on countries. So you talked about subsidies. I think WTO subsidies rules don't allow for some of the things that we need to see in the climate space. So I'm just wondering a little bit, I think we do need to work within the framework, but could we push the limits on the framework a little bit? And I think that's probably part of the reason that I think the trade agreements, and you talked about PACER Plus, I think that has so much potential because you can do a little bit more than you can under WTO rules, which I have utmost respect for, but I think they have, we have run into some challenges in that context. So I just wonder what you think about that. And thank you for the
Yeah, sure. About subsidy, I think you're totally right. And I think what I'm thinking, and you're more an expert, I would like to have your view on this, is to maybe revive in some sort was Article 8 of the SCM agreement, which obviously there is a reason why it expired. Yeah. And I think it was not only developed states, it was also developing states that were responsible in part. I understand this. I'm just trying to also, and what I'm trying to see is, well, it might have sounded slightly revolutionary, but I try to keep it as close as possible to what we have. I think you're totally right. If we provide examples that are really out of the ordinary, there won't be any buy-in. And I think for me, in terms of Article 20, I think that for me, maybe what I would like to work on is to develop this idea that the article, instead of being exceptions to Article 20, would be a bit more maybe look at how this climate objective can be much more upstream in the design or interpretation of the rules themselves. But I do completely agree with you that we have to be careful because we have to work within the system, which is far from being perfect, but still has been working some time.
Yeah, I definitely think we should not dismantle it, but I think there might be some creative things that we could think about.
All right, I like it. Okay. Any other questions? Please.
Yeah, so thank you very much. Really interesting presentation. I guess my question is directed to forgetting your names here, Professor Bull.
Yes.
And Professor Costi, but fair enough, if anybody else wants to answer. So, you talked, Professor Costi, you talked about climate change kind of measures in trade agreements, and we talked about gender kind of issues in trade agreements. So my question, I just have to tell you a little bit about where I've come from. So I'm Canadian, and we recently elected a prime minister who believed in climate change issues before he became prime minister. And now, because of the terror problem that we're facing from his country, we are now in a situation where he's basically torn up basically any climate change issues. And so I guess my question is that I of course agree with what you said and think that we should include all of these things, but what do we do in a situation where we're now in a situation where trade has become very, very problematic? We want to ensure that trade is being facilitated and not economically burdened by doing things like putting in climate change measures or gender measures.
Do you want me to go first, or do you want to go first? I think that's a great question, and honestly, it's part of what I've been struggling with as I've been thinking about all of this. So this work that I presented is also part of a project I've been doing with the United Nations since 2020 of cataloging trade agreements and looking at different provisions of trade agreements and trying to think about what could be useful on climate change, on gender, on small businesses, on labor, and I was struck by the amount of variation that I think we don't talk about very often, and also struck by the fact that most of these trade agreements actually do kind of are based on the foundation of WTO law, but then kind of push the boundaries a little bit like we were just talking about. But I am very worried, and I really appreciated the tariff presentations. I've also been following the whole tariff debate and teaching it in my class and went to the Supreme Court hearing. I just am worried though that that's like now taking all of the energy out of trade, everything we could be talking about on trade and development, and putting it in this completely defensive, as I called it, zero-sum context. So that's why I worked on this paper, because I knew we probably were going to talk about tariffs a lot. But I feel like there is a lot of law. No, we should be, we have to be. This is what's happening. But I also feel like there is a body of international law that has been built up through these 378 regional trade agreements that is going to be difficult to undo, even though I think your point is then, and I guess this is my fear, maybe I shouldn't articulate it because then I'm worried it's like, you know, the movies where if you say it, like it happens, but my fear is that these US, whatever these things are, I don't think they're trade agreements. I don't even know that they're like real. They're like, you know, write it on the napkin and, you know, shake on it kind of agreements, but they have like certainly some enforcement, I guess, desires behind them. I just worry that that is going to be used in a way to kind of get countries to undo some of this. And I guess part of the reason that I said I'm also interested in looking at what a lot of other countries are doing is that I think undoing this in every single country in the world, every single trade agreement is probably beyond the capacity of, you know, so there are things hopefully that I hope create like a little bit of a safety net on this. I mean, I think it would be a real shame if Canada moved away from, as I said before, Canada's been a leader on many of these things. You know, it'd be a shame if we take these provisions out of the USMCA when it's going through the review. I think we just don't know what's going to happen, but I felt like in a conference like this, where we all care about development, I wanted at least to talk about kind of what that safety net maybe looks like and how we could try to study it in more detail so that we don't lose some of it. And that's at least my hope. But I mean, if the United States can dismantle the entire international trading, you know, system of global rules, both multilaterally and at regional trade agreements, we're in trouble. Yeah. And I hope somebody will stand up and do something about it, because it's going to be a huge disaster if we let that happen. So I just really hope that with all of these side deals, that all of this doesn't get undone. I don't know, did I answer your question well enough? Or, you know, there's a lot there though that maybe could be held on to, that's at a level of granularity that maybe, you know, and again, you can't dismantle every country's domestic law either. And a lot of this has been reflected now in domestic law. So my hope is again that creates a little bit of a structure that doesn't disintegrate, and we can continue to innovate around it in places where we need to, and we'll maybe see more innovation coming from smaller economies, so I don't know whether I answered it well enough, but, and I'm worried.
Just briefly, first of all, as a fellow Canadian, I must have been quite proud of seeing how Canada has stood up to the administrations of the United States so far. I will only say that I look at it, I'm not at all an expert in this area, and I look at it as an area, any area of international. We have periods of time where things go very well, international develop a lot. Sometimes we slow down. I think that for me, and you were referring to the chapter on Maori rights in the EU New Zealand agreement. I think it's positive.
Yeah.
It is the capacity of this regime, despite the fact that it comes under a heavy criticism, and not all of it unfounded, but that there is this dynamics, this dynamic force that can allow, within obviously still the principle of the WTO, to have agreements that are much more suited to. And I think that we need to be careful how to stretch it, but I think that even chapters on gender and other, I think are quite important. It shows a system which can go with the times. I think that's something that we need to keep in mind. And I would like to think that even when there are negative times, that's a prelude.
Can I interject and add something?
Please, yes. I ask you.
That'd be great. Oh, do you want to take it off or just, I can just pass it down?
Yeah, you pick it up.
No, we can just go.
There we go.
That's true.
So, oh, is it off?
It does come out.
There we go. Okay.
I'm.
There we go. Okay.
Sorry, I
So,
haven't used it.
in response to your question, I don't see that Canada's response through its prime minister is an abandonment of those values. I think it's a reaction to the situation that he's been placed in, and the need to actually protect Canadian industries. So I don't believe that it's gone forever. I think you're going to see some normalization after Canada engages and finds new trading partners to sort of supplement or to replace what it's lost. There's an excellent speech by the president of Finland. His name is Alexander Stubbs. That's right, Alexander Stubbs. And he made a speech in the United Nations like the day after Donald Trump smelled up the place. And the speech is on multipolarity, but it's a fantastic speech because it talks about, well, this is the situation that the United States, it's a situation of chaos that it has now thrust the entire world in by attempting to withdraw from multilateral agreements, tear up bilateral agreements. And so we are moving into this phase of what he calls multipolarity. And he talks about how moving into this realm of multipolarity, we can actually take advantage of it and use it and not dismantle the system. So I would urge everyone to go find that speech and read it. I may actually go back and put it in my article.
Yeah.
So, oh, and strategic ambiguity. Don't forget that. Oh, okay.
That's insightful. Thank you. Any other questions? Yes, please.
So, my name's Gad. I'm from this law school. I'm a 1L. But I have a question directed at Professor Gibson, but I'd love to hear from the rest of the panel too. So you were talking about rebuilding relations with other countries in a post-Trump era, but I feel like there might be a particular area where it might be difficult to do so, and that's with the restrictions, like such as with chip manufacturing. I watch the news pretty frequently, and I know I've seen lately that China is developing really heavily into their own chip manufacturing based on the current restrictions that it kind of put in place along with the tariffs as well. So I'm just wondering if it's even worthwhile to go about rebuilding those type of relationships with other countries, because it's also happening with other ones as well. Or if it's better to focus on industries where the US might have a stronger hold, in a way. I don't know. I would love to hear your opinion.
Here it is.
It's still on.
Oh, it is still. Okay, there we go. I'm very hesitant to agree with that position. I think in the long term, when I think about trade, I don't think about the next 2 years or 3 years. I'm thinking about how do we engage in trade and build a solid foundation for the next 25, 50, 75, 100 years? And I don't think it's in our interest to let the interactions between the Trump administration and our other trading partners color how we engage and trade with them going forward. It is, I think there's a lot of diplomacy and rebuilding of relationships that actually must be done, because again, we go back to the fundamentals between mercantilism and free trade. No state has all of the resources that it needs. No state does. And so at a certain point, we need to reach out to other states, right, and engage in trade to get the goods and services that we need. And if we don't have a good relationship, we're not going to get them. Okay. And so, great. Does that mean every American now starts to suffer from scurvy? Right. And right. That's a bad example. It's an extreme example, but it's illustrative of the point. So, and I welcome thoughts on that. Oh, okay.
All right, thank you.
Right here in the middle.
Yes, please.
Thank you, everybody. I would like to thank you again for this session, insightful presentation. I am very happy to hear your different presentation, because it confirmed me, as I said to my student during last semester, during spring, Morocco, because I think that there is some very interesting remarks through the presentation. The first one is the rise of unilateral measures within international trade. I think that we can observe two things: the contamination effects between maybe trade field and investment field, because we know that within investment we have a specific mechanism as a investment screening mechanism, but now we have also a trade investment mechanism in accordance with the practice of Trump administration. But also this practice exists, for example, in the European Union. This year, I think in February 2025, as you know well, Morocco and the European Union have an FTA, free trade agreement, and European Union practice also sweeping tariffs, the same as a retaliatory measure, but for me it's not retaliatory measure, it's a counter measures, different. It's like sanction, economic sanctions. Because when I followed the presentation of my colleague, Gibson, I saw in the card that there is no sweeping tariffs concerning Russia, and the Trump administration justified this position because economic sanctions equal sweeping tariffs. You know that we are in the countermeasures approach, not in retaliatory, because there is no DSB, no appellate body, etc. Then concerning the case between Morocco and the European Union sweep the tariff just against specific field, aluminium, and we focus on Chinese campaign and in car industry, and the reason was just to discourage the same company to invest again in Morocco and to build another factory. And European Union reached success because the company left Portugal to escape to the sweeping time. Then I think there is a systemic risk across this approach of this practice of international trade law now, because we have been assisting to the rise of unilateral measures and to the lack of the multilateralism system.
Okay, good. So I got time for one more question. You had a question? Go ahead.
Yeah, I'm reminded of the romance of the three kingdoms. The empire, long divided, must unite. Long divided, must divide. And it seems like that's what the World Trade and World Trade in general is going through right now. I'm thinking specifically of Indonesia's raw nickel export ban. In order to create, like, basically just said, we're not doing this, we're gonna create our own industry. And it's been remarkably successful. At least in my opinion, I'm sure people here know far more about it than me. I'm wondering when should the day come in the post-Trump world when we come to decide on a new trade framework agreement, is it gonna look anything like it used to look?
First, why don't you go, and I'll go last.
I think you can hear me without the microphone, but I think one of the problems we see, right, is that whether we're talking about the dual use technologies or we're talking about the sanctions with Russia or is that or whether it's a fever dream of the Trump administration or it's reality, that security concerns have really ramped up, and there's a lot of, and they can be used strategically to favor an industry, or they could be legitimate concerns. And I think it's not an accident that the 1990s saw the development of the WTO. That was a sense of the wall had fallen, and there was transition all over the place to a Atlantic consensus society in the world, or at least thought it was that way. I think, yeah, if we continue to have this kind of, world of conflict, East Asia, Oceania, and Eurasia, or whatever, we're going to have a different system.
I'll jump in maybe, because that's the perfect final question, by the way. Not an easy question to answer, kind of a lot there. But it's difficult. I taught a class this semester on international economic law and institutions, going back to, the Bretton Woods institutions, which was also supposed to create an international trade institution, and then led to the General Agreement on Tariffs and Trade, and then eventually the WTO. And the system has been evolving over many years, right? But I think so many of the kind of reasons that everybody entered into these agreements to begin with now are getting tested and challenged and frayed. And, I think national security, and I really appreciated the presentation, by the way, on export controls. I think that's like an incredibly important area. I think, a colleague mentioned earlier that national security is overtaking everything. I definitely think that's something we need to figure out. How can you do things in the name of national security? The United States, by the way, has said that national security exception is completely self-judging. So even if they get a panel report saying you are not acting within the confines of this national security exception, they're like, self-judging, sorry, bye. And so I think somehow, but what is favored nation treatment anymore? What is non-discrimination anymore? I mean, the way that the United States right now is approaching international trade law, those of us who believe in the rules, I think we're trying very hard to say, we still have a system of global rules, but the United States, what we're doing is outside of the rules entirely. So I do think we need to somehow figure out if, when we regroup, what is this next phase? Is it something where there is a different kind of flexibility for countries, but where there are still some, international parameters around it? Do we do more, which I think is probably likely at the plurilateral or sectoral level? I mean, I think you mentioned, there's a lot of critical minerals where countries are, African countries too are saying, we are not going to export any of this. We want to produce it here. We want to add the value here. We don't want to send it all somewhere else for the value to be added. So I just think there's so many things happening that maybe push us back towards that kind of coalition of the willing plurilateral level, which honestly, the global trading system evolved through that kind of system before the WTO. So maybe we go back to that and try to rethink kind of, fundamental principles. But I think it'd be very difficult to kind of go back to the way it was after all of this. I mean, it seems almost impossible but so I think you're absolutely right. And I think security is going to be kind of one of the big things. But hopefully we can rebuild. And I think that's why it's important for all of us to be thinking about these things. What can we hold on to? What can we salvage? Are there pieces of a system that we can still, use and to make work? Do they completely disintegrate? I don't think so. I'm an optimist, but I think it's really difficult right now. So I don't know, that's not a note on which to add. Maybe somebody wants to be more optimistic.
I would add into that I agree with what both my colleagues have said. I would say history matters. Okay. The lessons that history has given us, especially in the area of international trade, Bretton Woods didn't happen overnight. People risked their lives to get out of those Axis countries to go and attend the Bretton Woods conference. And let's keep going. GATT superseded, right, by the WTO, is really folded into it. Again, it didn't happen overnight. There was a progression here. I think that the era that we're in right now is doing nothing more than testing the system and saying, when you come out on the other side, it's going to look different, but the system is going to be intact. And not fully 100% intact. I mean, right. I agree with you. I'm an optimist as well. And I think I have to be, otherwise I would cry.
You too. That's part of this.
So it's a great presentation, great discussion. For long development, I was a trade lawyer. I worked at the WTO and worked with, not against, USTR, representing foreign governments. So it's like coming back home. I just want to make one comment. I'll have to do the closing. Same guy. Look, I mean, I went to undergraduate like late 1980s and 88. There's a really nice thing that came out called a Macintosh, right? And that computer, you don't have to program everything to do anything. There's a mouse. And that thing was priced over $2,000. Back then, you can buy a car with it.
Yeah.
All right. It's only rich kids were able to buy it. Well, that's 80s, right? Now, anybody can buy it. Guess what? Trade made it happen. Because computers were produced places where there was a fraction of the cost. Everybody was able to get a computer. That's what trade does. That's what trade and development is about. And thanks to that, countries like China, hundreds of millions of people got out of poverty. Isn't that a good thing? Everybody in America can use a computer. Lots of people in developing countries like China got out of poverty. South Korea, Japan, right? So now what's happening? Prices have gone up here. I mean, the tariff was sweeping statement. We all heard that. Some, folks in the States saying, look, we can do things, right? Prices have gone up. And I live in Atlanta, Georgia. Atlanta is a big city, but it's a 1 hour away from it. A lot of people depend on a place like Dollar Shop. Now they're gone. One by one, they're gone because they cannot afford to sell anything for $1 anymore. Guess why? Washington, period. Poor people got hit, right? Rich people, they don't go to dollar shops, so they're probably fine. $3,000 more for the car. I'm an academic salary, so it's a problem for me. But for those who are making decisions in DC, so something to think about, right? Trade and development. So everybody's great contribution. I can only build them. So thank you again, and thank you. Because I'm making closing, I have to. Some fun, isn't it? We're hearing from the same guy twice. So look, I mean, it's a great conference, right? 3 panels talked about something very important. Environmental protection, we got to sharply divide 2 sides in this country. One, Washington says it doesn't exist. And on the other, a lot of people think that the environmental problem could bring an end to our civilization. So, how more drastic can be. And we have things. So we talked about it. And then technology, like quantum physics, quantums. When the world became digital, like 20 years ago, you can sign electronically, and you can email, you can grade. I mean, it took us a few years. I'm slow in technology. That's where I am. Now they're talking quantum physics, and quantum computers. Gosh, I mean, it's one thing to teach trade and law development. It's quite another to catch up. So the second panel really tells us a lot about that. Even I could understand some. So thank you so much. Trade, I feel, again, we're at the juncture. Now, Kathleen and others talked about the world is changing, but beware. I went to one of the largest trade conferences called SEAL, Society of International Economic Law Conference, and they're talking that, look, US is an important country, right? Largest economy. The way it's going, it could be WTO +1. And the +1 could become less and less and less relevant. And the biggest fear of Washington, decisions are made by somebody else. The US does not control them. Well, because we have disfranchised, exclude ourselves from the world. So it's going to be a problem, isn't it, for this country and the West? So we'll see what happens. Thank you so much for presentations and discussions.